I'm like so stressed out.
I'm sure you're nervous.
But I was like, I can, I still don't need a treatment. It's like, I come here, like, I can get this here. So I do it. And then she, so she missed. Well, no, she had a revisions this morning. She was so aggressive. She missed our turn.
All right, system is up. Just better than yesterday. Good morning again, everyone. We will turn to the Malcolm Wiley bond hearing as soon as we get a prosecutor for that. So I'm going to start with the trial calendar. The trial, for whatever case is going forward, will start Monday morning. So today is a chance for things to work out if they're still work outable, and if they're not, then we'll figure out which cases remain. And I will get an email out to the lawyers today, letting you know the order in which I'll be calling the cases out. But if there are multiple cases, there'll be a few cases that need to be here on Monday morning, and we'll roll with whichever one we're going to roll with. But I'll give you guidance that I plan on calling case X before case Y before case Z. Position 1 has already resolved. Position 2 is Mr. Compton. Ms. Wood, you and Mr. Abate and I discussed that. You're going to try one more time to chat with him?
I want to give it one more shot, Judge.
All right, good luck. Is Mr. Compton up?
Yes, he's up.
Okay. Does he seem like he's in a positive frame of mind? Okay. There we go. Position 3 is Dontavius Wright. I don't know if Mr. Johnson is on the call or in person.
When I spoke with Mr. Johnson yesterday, he said that he was under the impression that he was excused because his client was supposed to be having the evaluation today. So
Oh, it's today. Okay.
I don't expect Mr. Johnson to be here, but I think he
No, in fact, you're right. He asked to be present to get that rolling.
Yes.
Update for you then, and I'll pass it on to him. I spoke with the other doctor, and she said if I get an order to her, getting the jail records is easy. She doesn't have hard copies of anything. She looks at stuff through portals. But an order from me, she would download the jail stuff. She said the Grady and something called Care Everywhere. She said, I can't download that. I can look at it, but I'm not able to download it, which then made me wonder why this doctor wouldn't have similar access as a medical professional if given an order. But I didn't learn this till late yesterday. So I may have to work through Mr. Johnson with Dr. Owens, I think is his name, to say I don't know if the access that Dr. Y has is unique because she is Emory Grady, or if Dr. Owens, who is a medical professional, could get the same kind of online access with an order.
He and I, that's actually what we were talking about yesterday. I think we were kind of inclined to believe that the nurse is probably how his doctor got it.
The special access because she's Emory Grady.
Yes, that was our thought. I don't know if he then was gonna go ahead and go through the process of actually getting the records.
Okay.
I don't know.
No,
I'll follow up with him.
Yeah.
When I was out here, and then I guess we'll go from there.
Okay. I just don't see how unless Dr. Owens sees Mr. Wright and says like, come on, Dr. Y was correct. If he is going to take at all a stance of, I need more info, then he needs to get this other info and nothing can happen on Monday.
That is my understanding, that he wants to get the other information even after the evaluation before he's willing to do.
Opine. Okay, all right, then you can stand down on that one. If Mr. Wright is here, his lawyer, he's here? Huh, I wonder how he's gonna.
Well, that's what I heard, that's why I was confused.
Yeah. He's okay. All right. Well,
I do also believe I saw Mr. Peoples pop in a.
Yeah, he's right.
I did too.
Yes.
Okay, great. All right, we'll press on. Fagan resolved. We didn't produce Palmer and Owens because of lawyer conflicts. We can't reach that case. Mr. Pendleton is online. Is
Yes,
Mr.
Judge.
Hey, how are you?
I'm good.
Judge,
Hold on one second. Yes, on the monitor.
yeah, it's me. I'm sorry.
Hey,
Since I have Amari Williams who
Right.
should be in the courtroom, but I didn't want to hold him there.
no,
If
he
he's
should
physically
go.
present,
He is.
yes.
He's here. He can leave. And we need to get this specially set, so it fits with, everyone's schedule.
Correct. I just didn't want him to be caught there, and I knew you were about to go through the rest of the calendar.
Okay. Nope. Mr. Williams, you're good to go. So Aaron Michael Pendleton, Mr. Pendleton is on the screen and Mr. Cook is right here.
People standing in for Ms. Williams today. Good morning.
Hey.
I've been talking to Ms. Williams since she's quasi back from her leave.
Mhm.
And I think Mr. Peoples and I need to talk. And I think in chamber, could we have a bench conference?
At the end of the calendar.
Fine,
Okay. So Mr. Pendleton will just hold on.
that'd be fine.
Okay.
And I do have, if we don't resolve it today, I have called in on older cases in Fayette and in DeKalb Monday morning on felony trial cases. I didn't realize this was on for Monday, so I haven't found a conflict for Monday here, but I found it in other places, so I can get that filed in here as well.
Please do.
Court is aware, so my apologies. I didn't understand it was on for Monday, so.
Okay. It is. So if you'd get us that and we can talk after the calendar.
Thank you, Judge.
Sure. Kayla Brown entered a plea yesterday, which gets us to a Darren Jones, who was here a whole lot yesterday. Is Mr. Wooten, he's online. Hey, Mr. Wooten.
Hey, Judge, good morning. Just a quick update on that. Miss Mormon and I have been talking about Mr. Jones. She just sent me some exculpatory or potentially exculpatory information last night. I would like to run through that with the victims if I can. As the court knows, there's quite a few victims, so that's going to take me a couple of days. I know Miss Mormon has the conflict with the federal court trial as well, so I'm not sure if it makes the most sense to maybe just push the next trial calendar, but sort of what the court believes is best.
Okay. Let me hold on that and let's pivot to Ms. Jones. And her lawyer, Mr. Campbell, is on, but I'll start with you, Mr. Wooten. What's happening with Ms. Jones?
So I have not received any potentially exculpatory evidence as it relates to Ms. Jones. And so I think Mr. Campbell and I just need to continue discussions on that. I'm not sure what her inclination is as far as a potential plea or not.
So, trial's Monday. You want some time to see if Mr. Jones's case is working out. Would you want to sort that out before we would go forward with Ms. Jones's case because you'd want to try them together? Or can we put down Ms. Jones's case as one that could go out on Monday?
I'd prefer to keep them together just because there are so many witnesses in the case.
Okay. What's a reasonable deadline to give you and Ms. Mormon to work through? I guess she's done what she was going to do. You need some time to work with the victims. What's a reasonable deadline for that?
I would say no more than 2 weeks.
Okay.
Probably less, probably 10 days.
All right. Ms. Mormon, your federal trial, how long is that expected to last?
2 weeks, Your Honor.
2 weeks. And what district is it in?
District, Florida, Tampa Division.
Tough place to be for 2 weeks.
Yes, it is.
And do you actually have a client in there, or you've got someone who's a witness, or what's your role?
No, Your Honor, I have a client.
Okay. All right. Well, while you're doing that, Mr. Wooten will be assessing the evidence you provided and talking with the victims, and I guess we'll reconvene after that to see where we are. All right. Then Ms. Mormon, you, and if I got a lot of people online, if your client's on, you guys are free to go. Mr. Campbell, why don't you give me your thoughts about where we are with Ms. Jones?
Good morning, Judge.
Morning.
Yes, Judge, I definitely would like to have some more conversations with Mr. Wooten. And I think it makes sense to keep her case with Mr. Jones.
Okay. Then we'll do that. You stay in touch with Mr. Wooten and we'll take everyone's pulse sort of 2 weeks out.
Thank you, Judge.
All right, you're good to go.
Thank you, Judge.
Carter Jackson. Hey, Mr. Griggs.
That he is present. Judge, I do understand your ruling on my request for continuance. I will renew that request. Just as early as this morning, Mr. Jackson was presenting in a way that made it very difficult for his family to actually get him to court. His brother had to help him. So we do have an appointment with the facility at Grady. It's not till July. But we would simply ask, if possible, to have another evaluation, because I have found it very difficult to communicate with Mr. Jackson. And I was very concerned this morning about the text I got from his mother, and then the conversation that I had with him this morning. I don't think he fully appreciates what's happening. So for those reasons, Judge, I'd ask for a renewed continuance. I did get a chance to talk to Mr. Body. I do have an offer, but I don't think I can communicate it effectively to just its current state. Further, I got notice from Judge Lanier down in Calhoun yesterday that I am called in Monday morning at 9 a.m. on an older case. Granted, it's a case that was in bench warrant, but I think that my client is now in custody. It's an 18R006 case, State of Georgia versus Fannie Barber, which is set to go out in Calhoun County in front of Judge Lanier Monday morning at 9.
Okay, and that's a felony case?
Yes, Judge.
Okay, all right. Mr. Jackson, how you doing today?
I'm not bad.
You're not bad? Okay. Did you have breakfast this morning? Did you want to have breakfast this morning? You didn't what?
I didn't desire breakfast.
You didn't desire breakfast. Okay. Did you have breakfast yesterday? Okay. When did you last have something to eat?
I had something yesterday, but it was like earlier in the evening, later in the evening.
Okay. What'd you have?
I think I had pancakes and pancakes with bacon, so I had a slice of that.
Did you make it or someone in your household did?
Then my brother and my sister-in-law made it.
Okay. Were they good? Excellent. When's the last time you had a conversation? I don't want you to tell me what you talked about, but when's the last time you had a conversation with Mr. Griggs?
I believe it was about a month and a half ago. I think it was discussing the particulars of my appointments at a neurologist. I first to get appointments with a neurologist to try and ascertain what's going on with like me neurologically speaking.
Mm-hmm.
As far as like treatment plan and what's that, I'm just trying to kind of follow up with the appointments that I had and see results from that.
Sure. So what kind of appointments do you have now?
I have a neurology appointment, things coming on the 28th of July, like my lawyer said.
Yep.
Other than that, I'm supposed to have I just had a physical yesterday, and that checked out, blood pulse and all that.
Good report from the doctor.
I am.
All right. Are you working these days or what do you do to fill your time?
Usually I just sit home contemplating.
What do you contemplate?
Just the nature of like basic medicine.
Okay. Do you remember what you're charged with in this case?
I believe it was a particular homicide.
Okay.
Of major.
All right. Well, Mr. Jackson, I appreciate you sharing those things with me. I'm going to talk more with your lawyer and the prosecutor and we'll make a plan. Okay. Thanks.
Thank you, Your Honor.
You bet. Willie Moses. Ms. Nelson, have we heard from Mr. King?
Good morning, Your Honor. Can you
Oh,
hear
he's
me?
on the Zoom. Hey, Mr. King.
How are you today?
I'm well. What are we doing with Mr. Moses today?
Your Honor, I'm hoping to, this is going to be a resolution. I'm asking the court to continue this one time, um, because I haven't really had a chance to speak to him since we got an offer. I know the discovery was served at some point before I got, before the case got moved here, but I just got discovery last week, and I want to be able to go over with him, and then also go over the offer with him. So I was just asking for a one-time continuance, if alternatively, maybe later in the week, maybe like a Thursday or Friday next week, if the court is in, I can come in and potentially try to present a resolution to the court.
I didn't realize we were interrupting a leave that you were on, so I'm sorry. I appreciate you hopping on the Zoom, Mr. King.
So that's my fault because I for some reason I dropped the ball and didn't file it in your case. So it's really my fault, but I'm obviously happy to be on.
When are you back in action?
I'll be back in I fly back in on Wednesday.
Of next week?
Yes, sir.
Okay, well, that would be one reason why we couldn't try this. I'm not inclined to roll it to another calendar, in part because we had to produce Mr. Moses from the state system. He's here now. I don't want him bouncing back and forth a lot. Just looking at what the allegations are. So I do want to give you a chance to digest discovery. My guess is it's not particularly voluminous.
It's not
and so
voluminous.
maybe once you're back and have a chance to interact with Mr. Moses, we shouldn't keep him here until the next trial calendar. He'd have to go back to GDC, and those cycles are complicated for the inmates and they're expensive. So I think what I may do is take you up on your offer of being available towards the end of next week to see if we can sort this out.
Yes, sir. So I'll be in touch with Ms. Nelson because I'm available for the court Thursday or Friday. So I'll go see him at the jail, but hopefully we can present something to the court Thursday or Friday.
Okay. Well, enjoy the rest of your break, and we'll look to hear from you end of week.
Thank you so much, Your Honor.
All right. Bye-bye. Oh, Mr. King, Mr. Mr. Moses is here. Do you want us to bring him out so he can hear what the plan is, or would you prefer to you're going to connect with him when you can?
I'll just connect him when I come back.
Okay. All right. Thank you.
All right. Thank you, Judge.
Teresa Smart. Ms. Smart is here. And there's her lawyer.
Yeah, we just give a moment to pre-trial. I think it's gonna be a few today.
Okay, great. We'll try to knock that out. Now, I have Ms. Williams's name down. So is Mr. Peoples handling it?
Yes.
Okay, great. So you will, at the appropriate time, speak with Ms. Sherry Lassiter.
I will do.
Great. Then we have Christian Falconer and Kayla Newborn. Mr. Falconer is here with Mr. Blevins. And there's Ms. Newborn.
Good morning, Your Honor. Retired for Minute Newborn.
Hey.
Hey, how are you?
All right. What's your announcement?
So my announcement is I was briefly retained to the case. I think she retained on Friday. I wanted to try to try with the state to see if we can resolve today. If not, I may need a continuance because it is a lot of discovery.
Okay. Can you give me your last name again?
Yes, Rekayah, R-E-K-I-Y-A-H, Baker.
Baker.
B-A-E-R.
So you've replaced Ms. Golding.
Yes.
You're not colleagues. This is a completely separate.
I have my own law firm. We filed a substitutional counsel, I believe on Monday.
On Monday. Gosh, that's late in the game. Okay.
We spoke about it previously. I think she reached out to me about 5 months ago, but she did decide to go with Attorney Golding. And then I think once he got close to trial.
She pivoted.
Yeah.
Okay. Well, welcome to the case. There is a lot of discovery. Why don't you speak with Ms. Smith after we get through the calendar, maybe when we're doing this bond hearing we're going to do in just a minute. Mr. Blevins, I know you filed a motion in limine. I've got that. We'll work through it whenever this does go to trial. You are also new to the case.
Yes,
and had very graciously said, I will try to plow through discovery. Tell me where you are now.
Judge, I've been through all the discovery. There are some missing pieces. I've reached out to Ms. Smith. We've talked about it. She's, it's not that she hasn't given it to me, she's going to get it as well. There's an FBI agent that was listed on the witness list. I can imagine what he's gonna have to say about pinging and things of that nature with cell phones, but I don't have any data or anything to have to review or get an expert review. So I would ask for continuous judge. I don't know if I'm ready, if that's what's gonna be inevitable. That's
Okay.
the deal with.
When I was asking Ms. Smith about which cases she is more ready on or less ready, she identified this one as one where if it is a trial, it will be a whole bunch of witnesses because there were a number of agencies involved. Is that I know you've had more time with discovery than Ms. Baker, so I'm gonna ask your initial sense that Ms. Smith was saying is, two defendants, and even though this is one robbery, there are these tentacles that go elsewhere. I think that shows up with your motion in limine. And so Ms. Smith was forecasting that it wouldn't be a 2 or 3 day trial if it went to trial.
No, her witness was about 30 plus witnesses on it.
Yeah.
Some would be expert witnesses. I think there's a Homeland Security person and FBI agent I mentioned earlier. So it's going to be at least 2 weeks.
Okay.
No more than 2 weeks.
Right. Right. It sounds like it would spill over a week. Okay. Then let's do this. Ms. Baker, please do talk with Ms. Smith.
Yes, I received the link from previous attorney discovery, so we're in the process of downloading.
Great.
It is a lot, so we're downloading now and I'll review it.
Okay. But talk with Ms. Smith before you go. I don't see this being the one that goes out on Monday. But if it is, it'll be in the email. If it's not, then I'm granting sort of an informal continuance request from Ms. Smith, a more formal oral one from you, Mr. Blevins, and then a plea of mercy from Ms. Baker saying, just got on this case. You can sort of see where those things stack up.
And Judge, I also filed a motion to suppress as well. The search of my client's vehicle was filed.
When did you file that?
Same day I filed the motion.
Okay. I haven't seen that one, but we'd need to work through that.
Yes, and Jackson didn't. So
Okay.
3 things.
Got it.
But
All right.
That be handled pretty quick.
Right. No, and that may be, depending on what we're doing next week, it may be, let's knock out the motion to suppress in the Jackson Deno. But we'll see. Okay. Mr. Falconer and Ms. Newborn, you remain on bond. Make sure you continue to comply with conditions of your bond. And your lawyers will be in touch with you. So Ms. Baker, if you want Ms. Newborn to stick around while you talk with Ms. Smith, you manage that. All right. Yes, sir. Lorna Heath was resolved. Reginald Arnold was resolved. Trinice Lawton.
Judge, she just sent me an email. She's running late, so she's
Okay.
en route. This will be a plea. I just need to check. We were trying to get a clean accusation going. I don't think it's ready yet.
That's correct, but it was dropped off this morning by Eddie Williams, who was waiting on a new acquisition.
So you all have agreed to a different charge or set of charges, and we ultimately need the 26 SC number.
That's correct.
We forecast getting it today.
That is my anticipation.
Okay, we'll sit tight. We don't have Ms. Lawton anyway, so.
And at some point during the break, if it's not here, I'll run to the clerk's office.
Okay, great. Scott Schoenherr.
No, that's my case. A couple things going on here. First, I'm also on leave of absence. I was originally on leave of absence for the first final plea date. So my client actually has not had a final plea date.
Well, maybe that's what today is.
Maybe,
Okay.
I spoke with the state yesterday, and I spoke with the state a couple times. We produced fairly voluminous discovery, and I think they got it all yesterday. We talked about, I hate to say this, but concepts of a plea offer. And I think it would involve a reduction in the charges, but we're not quite there yet. I don't know if they've gotten through the entirety of the discovery yet. I do know they reached out to one of my witnesses who I believe witnessed the event. I don't know if she's available next week. I was trying to have her serve a subpoena today, but I don't think she's available because I think she's actually on leave. She's a full county employee. I am called into trial in 2 different counties next week, first in CAD and second in Net. So I would be asking to be moved to the next final plea date because I do believe we're close to a resolution. As speaking with my client, I think we're closer rather than further away in terms of resolving the case rather than trial, but certainly the next trial calendar will find the case resolved one way or the other.
When you say you just delivered a bunch of discovery to Ms. Smith, what kinds of things did you provide?
So we provided a link in February of quite a bit of discovery that my client had collected from various angles of the alleged incident scene, pictures of, so this is involving a neighbor and the child, right? The allegation is that my client brandished a firearm when the neighbor's dog came and attacked him at the client's neighbor's child. A lot of pictures, a lot of video evidence of the various aspects, some statements, some accounts of various other neighbors, an affidavit of a neighbor that was not interviewed by the police that I believe witnessed the event that we had filed originally. We provided that. I provided contact information to the state yesterday. The ADA agent indicated that she reached out. I don't know if she actually made contact with her or not, but that's my indication that she may not be available to testify. So
It's the neighbor who did the affidavit, who's the Fulton County employee?
yes.
Okay. All right. Ms. Smith, what's the state's readiness to go forward?
Yes, Judge, I do think that this would resolve via plea. However, the discovery that I received in February is the same one I got from yesterday, but I think the link expired back in February. I got a chance to get through most of that, and then by the time it expired, I didn't get to see the rest of it. I reached out to the neighbor that's in the affidavit, so I had a chance to speak with her. But as far as going forward, I think that this could resolve via plea and not trial, but we don't see anything hindering us from going forward at this moment.
What do you need, if anything, to get to the place where you think it's resolvable by way of a plea? Or you're there and it would be Mr. Schoenherr who would need to get to where you are?
I've communicated a plea in this case, an offer, I'm sorry.
Yeah.
And just waiting to hear back from the defense to see how we're going to resolve it. It's going to be a negotiated or non-negotiated plea in this case.
Hold on. Did the offer reflect what you learned from the neighbor? Or was the offer before the neighbor conversation?
So originally there was an offer that was higher than what the current offer is.
Mhm.
After I spoke with the neighbor, the offer did reduce to a misdemeanor in this case.
Okay, so you factored in what you believe the neighbor's gonna say,
That's correct.
and that's resulted in the most recent offer?
Yes, Judge.
Okay, my request, you said you're on leave today?
Yes.
You don't look like you're on leave.
Well, Your Honor, anytime I come to Fulton County, I want to file my case.
Okay, did you not file the leave or did?
Leave of absence should have been filed in this case because I represent Mr. Henry.
Okay, I'm not doubting it's not in there, but you should invoke it so you don't have to come down here. But you're here. I would ask that you and Ms. Smith do a little more talking now because you're all together. Because it sounds like Ms. Smith has, as she often does, quickly digests what she's given and has processed it and said, hey, okay, based on that, here's a different offer. And she didn't give me the specifics, but she gave me enough to say, this sure does sound resolvable.
There's one final thing that I'm looking into. I haven't done an issue. It involves my client's clinical license and any plea that would in fact that I've reached out to counsel on various issues for that licensing issue. Haven't gotten an answer to that. So
what does Mr. Schoenherr do?
He has a clinical psychologist. He's a licensed clinical psychologist. And
Okay.
any plea would have impacts on his ability to retain that license. In terms of the plea, obviously before we had a reduction, you're in a position of trying to case because that was an impact. But with the reduced offer, kind of changes the minimum, but I still need to make sure he's making an educated decision. So that also kind of throws some wrinkles into it. And probably would have had a little bit of this if we would have had a final plea before. It's just my leave background.
Right. No, that's no one's fault. Again, why don't the three of you talk? And Dr. Schoenherr ought to know what phone number to call to get some information about what's the impact of a misdemeanor on my license. So maybe we could do some of that research. I'm reluctant to let people go until we've talked a little bit more, and then we'll figure out. So why don't you all talk more, do a little research, and then we can figure out when people come back to see if is this a plea or not. Okay, thanks. Mr. Walker pled. Ms. Clark we dealt with. Ms. McGee Russell. Ms. Rios. Okay. When did you last chat with her?
It was last week.
Okay. All right. Makiba Clark. Hello, Mr. Hirsch.
Good morning, Judge. Dr. Clark is here. In that matter, Your Honor, I'd ask you to put it on the next trial calendar.
It's a theme today. We got to try something next week.
And I think you should. I just don't think it should be this case.
Great.
I can't tell you that it's going to resolve short of trial, but I have to follow up. Basically, I got internal video from our office. I turned it over to the state. I miscalculated time, unlike when I get their videos where I can watch most of it or get the gist of the rev transcripts. Before I turn over my videos, I have to watch, I feel like, every single minute. So I did turn it over. Based on the videos, I've asked the state to obtain the complaining witnesses' medical records. They said they've done so last week, but don't have them yet. In addition, they've updated their list of witnesses. There was one police officer on the list of witnesses. Now there's the victim, the witness who I knew would be there, but there's 15 altogether now. There are a variety of other reasons, but if that's enough, I'd ask you to put it on at the end of June. I don't think this request is a post.
I don't know that it's enough. Ms. Smith, my sense was this was a case that you thought was going to be a trial, but I didn't recall you saying this would be one where you wouldn't be ready on Monday.
Correct, Judge. We got some discovery from defense counsel in this case about those videos inside of the business. We've had a chance to review it. It doesn't change the offer in this case. I do know that the defense wanted a copy of the medical records. In this case,
Her meaning the alleged victim. Okay.
the defendant in this
Who is a patient of Dr. Clark?
well, her dog was.
Oh, right. I'm remembering this now. Okay.
So, in this case, the defendant is charged with ag assault and not ag battery, which ag battery usually, then we would definitely need the medical records. In this case, we have not obtained them, but we do not think not having the medical records would hinder us from going to trial. I don't have an objection to him asking for a continuance, but I don't think that the discovery that was served would change the state's offer in this case.
Got it. Okay. But as I understand it, the discovery that was served was internal video. So video within the veterinary practice.
That's correct.
And then a missing piece is medical records that Mr. Hirsch has asked you to try to get from the victim, not the pet, but the human.
Correct.
From Grady, yeah.
Okay. Okay.
My other concern, if I had a concern in this case, would be some of the videos that skip minutes and portions of the recordings. So I would just ask for the entire video without it skipping. However, from what I've seen, it doesn't change anything, but.
Got it.
That's all I have.
Okay. I will take this under advisement.
All right, well, can I give you the rest then?
Sure.
All right, thank you. Ms. Smith is correct. It's ag assault, not ag battery. However, in the state's discovery, she has all these injuries on her head. After reviewing the internal video, they're inconsistent, totally inconsistent with the alleged act, and there's actually a video of the act. So although they don't need it to prove it, she has shown the police this and told the police it was caused by my client. So they have exculpatory, I believe exculpatory evidence. They're best suited to get it. I can obviously do a motion as well.
You're talking about the medical records?
Yes.
Okay.
In addition to that, I filed just on Tuesday a motion to produce evidence. They have given me, I don't know, 15 or so videos. And upon initial review, I watched them and I was interested in what they showed. But in further reviewing them, only about 5% have any audio at all. So
these are body cams, or what videos are you?
Body cam.
Okay, so it's 15, there were 15 different officers in the mix?
I don't know. I don't know. I don't think on the list of witnesses, they have 13 officers, but I don't think this is simply 13 different viewpoints of the same thing. I think this is probably a handful of officers, and they have video of what happened after the incident. They have video of my client at the jail. They have video of the complaining witness 11 days later when she comes to the police department and gives a statement. There's no audio though. And they have dash cam video of them informally interviewing some of the staff, to which there's no audio. That may be the answer. Oh, I have a VLC player. No, well, some of the video has some audio. Anyway, the video may not have audio, but I've also had cases, usually DUI cases, where I get sent a video and it does have audio, but the copy I have doesn't have audio.
Okay.
I can certainly try it on a different player, but I have some video that starts off with the audio, doesn't finish with it.
Dr. Clark, you don't have to stay standing.
So that isn't another reason, that, you know, these are witness, among other things, it's witness statements.
Ms. Smith, have you recently had a chance to review the body cam segments that you obtained in this case, that you received in this case? And if so, was there audio or not audio?
Yes, Judge, I was able to hear the videos. I wasn't aware that defense could not, but this happened in another case for some reason I can hear everything, the defense can't. So if I can put that on a hard drive or anything, I can get that over to him, but I can hear the.
Okay, so we know the answer, which is there is audio. And then either Mr. Hirsch in pressing the right buttons, not faulting him, but it's the wrong codec or who knows what, or for whatever reason, the way in which the things were duplicated, although if it's an evidence.com link, I don't think it's even duplication. It's literally the same info. The audio isn't playing for him. Okay, got it. That seems fixable. Anything else on your list of woes?
I would call it my list of completeness and fairness.
Okay.
No, but I will tell you that should be expedited because when I gave them my videos, I put it on an external hard drive, so they have an external hard drive that presumably they can return.
Send back. Yeah.
That's my woes, Judge.
Okay, got it. I'll take that under advisement. Thank you.
So we will hear from you prior to Monday, or should we be here Monday?
Oh, you'll hear from me today.
Great, thank you.
You'll hear from me today. You and Ms. Smith don't need to talk more today. You seemed like you were heading for the exit.
We've talked a little bit now. No, I don't think so. We've talked it through. And,
Okay, you know where she is. She knows where you are.
very responsive. We just have different opinions of
Okay,
what's gonna happen in trial. I suppose.
that's why we have trials.
Exactly.
All right, you and Dr. Clark are good to go. Thank you.
Thanks.
Francisco Garcia. Good morning, sir.
Good morning, Your Honor. Joanna Bamelos from Mr. King's office.
How are you?
I'm doing well, Your Honor. How are you?
I'm okay.
Good. I believe the same announcement as a prior calendar call. We're still awaiting psychological or psychiatric reports, which we were waiting from state to provide us, from the prosecution to provide us details if family had authorized. And just to refresh, Your Honor, the outcry was done during, I believe, a session, a counseling session, and that's the importance of trying to obtain these psychological reports for our discovery review.
All right, let me check the docket because, oops. Anyone from the state here for this case? And Ms. Nix is out.
Correct. Sarah Patel is standing in for Ms. Nix, but
Okay.
I will reach out her now.
Thanks.
We reached out, I believe my colleague, Mr. Eli Bennett reached out to, prosecution counsel and as to the status of the reports, and we have not heard back.
All right. So I'm not sure what you are referring to. There was a request to obtain defects records.
Oh, my apologies, no, these were regarding, counseling reports, I believe,
Now, I heard what you said, and I'm not seeing, so this was just basically a private conversation between counsel and counsel? Because there wasn't, usually there is a motion filed. It's a Bobo motion if it's for anything related to mental health. And then for DFACS, it's a different motion. And we've worked through the DFACS and I entered an order saying, I looked at the DFACS records and there's nothing there. So I'm gonna see if there is a motion, because if there's not,
As I understand it, it's not motion, it's, just discovery documents.
Okay.
That we're still missing, and we, from my understanding, it was, the initial reports that provided, well, the, details of the outcry and how that happened and when, all that was involved in that. And, the prosecution needed to get authorization from family to make sure that that we could get a copy of those. And that was the last I had.
okay. You're gonna have to sit tight and we'll wait for a prosecutor to get here.
Of course.
Does Mr. Garcia require the services of an interpreter?
No, we're good.
Great, all right. And finally, on this calendar, Ms. Didier.
That's my case.
It is, and there she is.
I have a case specially set before Judge Glanville. It's older than your case, and it's, definitely gonna go out next week. The following week.
So we don't have a following week, but
Okay.
I'm not so sure about Judge Glanville trying something next week. I'm gonna have to check with him. I'm not doubting you if that's what you've been told.
Who is listed as the one that's gonna do it, so I don't know if he's assigning it to somebody at the last minute.
Tell me, maybe he's bringing in a senior judge.
DeShazier, Diamond DeShazier.
Do you have the case number?
I can do it.
If you could look that up. Ms. Didier, you can take a seat. I don't mean to make you stand through this. Ms. Smith, you're ready to go on. Mr. Hirsch is apparently going to represent the state in that case.
I would love to.
Yeah, I could see where that case would go. Ms. Smith, you're ready to go on Didier if we get there?
Yes, Judge.
Okay, case number?
25 SC 006354.
Because I've been hearing about, Juju. Yeah, so this is a Judge Williams case. And is it just your client? Is Mr. Hoover available? He's never available.
As far as I know, they got it marked especially said, everything that I've gotten at Landville.
Yeah, okay. He is kind of chaperoning the Williams docket right now until a new judge is in place. So what you're saying fits, other than there's a trial next week.
If there's not, it'll be news to a lot of people.
Yep, well, we'll want to fix it.
Myself included.
Well, I know you were asking for the Jones case. Is that what this is, the Jones case?
Mine is on, the consolidated.
Yeah, and it's not on the short list for next week.
But I am special set in the 8th in front of Judge Glanville.
Okay, got it. I'm gonna need to learn more about who's gonna be playing the role of Judge Glanville. Okay.
So you all aren't dismissing this one? This is literally my client pumping gas late at night and armed robbers come up to her.
Okay, now isn't the time to pre-try the case. All right, it's odd, all the special setting notices say April 7th, and you missed it. So assume for a moment that Diamond DeShazier is not going out on Monday.
I would have to totally rework.
Then you're here.
I would have to totally rework because everything is looking like it's going out. So, I have, for that reason, I haven't been working on getting this one up to speed. Because it looks like it's 100%.
Okay.
Actually, it's not a hard case to try.
Well, you were about to sell me on it.
I could probably try it tomorrow, but.
Well, okay, then I'm giving you all the way till Monday. I will check with the powers that be about a trial next week in 8F. Get back. Also, I'll note that's set for June 2nd, and I'd need you on June 1st. So
But they put special set, I don't know how that works.
we'll have to work through that. Stay close to your email.
Okay.
All right.
Okay. So what should we do now? Are we excused for today?
I mean, if you're working the case out today, you should stick around. If you're not working the case out, then be checking your email. All right, Ms. Wood, Ms. Wood's not in here right now. Ms. Rios, any update on your client, Ms. McGee Russell?
I text her about it.
Okay. Ms. Wood, your client was it Ms. Lawton?
She's here.
She's here.
Yes.
There she is. Excellent. Okay. I have a couple other calendars. We'll get through those. I wanted to call the trial calendar so we knew sort of who's ready and the long list of people who aren't. Do some pre-trying. Ms. Smith will be available to pre-try. The bond hearing that I need to do now for Mr. Wiley involves Mr. Peoples. Okay?
Judge McBurney, may I make an additional announcement on number 26, Dr. Farner?
You may.
Regardless of the court's decision, may I present a consent order, or at least a non-objective order, for grade release of medical record?
Yes, I'm here to help with that. So definitely, we need to dislodge those.
I will, I'll email it.
Excellent. Thank you. Ms. Sherry Lassiter?
Ready for a quick Miss Mark thing.
Great. We'll do that this morning.
Judge, can I run next door?
Please.
Make an announcement?
Yeah.
In case I'll come right back.
Right.
Is your client able to? Oh, okay. Oh, okay. Yeah, so no, you sit here. Just make sure, just speak clearly, so Ms. Rivers, she's remote. But yeah, no, you're good to.
Yes. Yeah, and if you learn anything about this DeChezier thing, let me know. Thanks.
Adam, I'll text you.
Favorite judge is 2 seconds.
Okay, for the bond hearing.
Yes, Judge.
Great.
This McGee Russell is here.
Pardon me?
This McGee Russell is here.
She is. Which person is that? Oh, there she is. No, I'm sorry. You're good. Okay.
Judge, can I run 2 spots real quick?
Sure.
Right back.
Feeling all right?
And Judge, on that SC number for the accusation, I can't remember the case name, A.D. Williams said it should be here shortly. Should just ask for an update.
Great. Thank you. All right, let's get on the record. Ms. Rivers, good morning.
Good morning, Judge. How are you?
I'm all right. You recovered from yesterday?
Yes, I did.
Great. We're going to get on the record with Mr. Wiley's case. It's 26 PI 003-118. Mr. Wiley is here with his lawyer, Mr. Nagasaka. The state is represented by Mr. Peoples. This is an unindicted case that I'm handling through my presiding responsibilities because it involves some charges that our magistrates are not authorized to set bond for if bond is appropriate. Mr. Wiley, good morning. Good morning. I'm Judge McBurney. We're meeting for the first time, and in a moment, I'm going to hear from your attorney about why you should get a bond and what that bond should look like. I'll also hear from Mr. Peoples, the prosecutor, and we will figure out where we go from there. You should know, Mr. Wiley, that you are charged with rape, 2 counts of aggravated sodomy, aggravated sexual battery, cruelty to children, incest, aggravated child molestation, and reckless conduct. So they're serious sounding allegations, but of course, it's not even an indictment yet, and you're presumed innocent. But we're talking about some serious charges. Mr. Nagasaka is going to share some things with me. I do have a question. I don't know, Ms. Simpson, if you've got an answer. There's a W on the calendar next to Mr. Wiley. Nothing that you have. Okay. All right. I just need to make sure you don't have a warrant from somewhere else, because then bond, really, we don't need to be talking about a whole lot. Okay. Mr. Nagasaka, when you're ready.
Thank you, Judge. Mr. Wiley, as you can see, is the big thing that I want to talk about today, I guess, is health.
Sure.
How that relates to his bond. I think that is a big, I think it's relevant to a lot of the bond factors here. I was unable to pull his criminal history, so I don't want to go out on a limb.
You don't need to. We have pretrial services here, and so I'll be getting from them his criminal history. So you can share what you think you know, but we'll get the definitive answer before I pivot to Mr. Peoples. Or Mr. Peoples will give it to you.
All right. So it seems like he has some older felonies, the most recent from 2008, and nothing sexual in nature. That is what I was hoping to see. That is the information that I received from Mr. Wiley. So I believe Mr. Wiley is a great candidate for bond under the Ayala factors. He has never committed an offense like this before, and as Your Honor can see, and as I was saying, his health condition really prevents him from doing a lot, doing too much. I think in terms of, if you look at his likelihood of intimidating witnesses, his likelihood of reoffending, his danger to the community, not putting aside the fact that it was his first offense of this nature. Physically, he has COPD. He's been diagnosed with diabetes. He was at Grady from Thursday until yesterday. So last Thursday, for a week, they just brought him back to Bryce Street. He can't really maneuver himself anywhere. He has a caretaker that he'll be staying with. That caretaker does everything for him, cooks for him, helps him dress, helps him get around. I was hoping to see him in court today, actually. He wasn't able to make it, but I did talk to him yesterday. He was
the caretaker?
Caretaker, yes. He was present at Mr. Wiley's preliminary hearing in front of Judge Ashley a few weeks ago, and I've had a chance to talk with him in person there as well. He confirmed yesterday that Mr. Wiley can stay with him, and that he has been taking care of Mr. Wiley for about the past 2 years, and confirmed again that he has serious issues with taking care of himself and his mobility. I think that's a good reason to take him out of Bryce Street from a humanitarian standpoint. I think they are having trouble managing his symptoms. He is in slightly worse condition than the last time I talked to him, unfortunately. But under the Ayala factors, I think this is not a guy who's being unleashed back onto the street. He's going to be at his house. He stays at his house.
So the caretaker would reside with Mr. Wiley.
Excuse me, he would be going to the caretaker's house where Mr. Wiley has been residing.
Okay.
There is no relationship. So the alleged victim here is Mr. Wiley's family member. The alleged victim's contact with Mr. Wiley consisted of them coming to the caretaker's house to visit him. There's no biological, there's a less direct, I guess the caretaker is a family friend of Mr. Wiley, so I can't say there's no connection there. But the alleged victim was there for Mr. Wiley. They weren't there to visit the caretaker.
Okay.
There's no reason for them to return to the home. And of course, with these allegations, I'm sure they will not be returning. There's no other minors in the house. It's just Mr. Wiley, Mr. Johnson, the caretaker, and I think a grown male cousin who lives there.
A cousin of Mr. Wiley or a cousin
of Mr. Johnson.
Mr. Johnson.
So I would submit to Your Honor that just given that setup and Mr. Wiley's physical condition, there just isn't a significant risk of reoffending, of danger to the community, of intimidating witnesses. And Mr. Wiley, as far as his ties to the community, he is a lifelong resident of Georgia, and he has, of course, family here, including his caretaker who he's lived with for 2 years. So I think that prong is satisfied as well. Mr. Johnson, who again, unfortunately wasn't able to make it today, was able to make it to court as preliminary hearing, has indicated to me that he would help bring Mr. Wiley to court. He has been very responsive, has always answered my calls, has been very generous with his time with me. So I would submit that the fourth legal factor of risk of flight, that Mr. Wiley is not a significant risk of flight, and that a bond would be appropriate in this case. As far as a number, I'd ask for $50,000. I think that is maybe low for these charges in this jurisdiction, but given a lot of the mitigating factors in Mr. Wiley's case and the fact that just for health reasons, it would really be good for him to be out of Rice Street. That's the number that I'd be asking for.
Got it.
Thank you,
Okay, I appreciate that. Mr. Wiley, Mr. Nagasaka said that you were recently at Grady for about a week. What caused you to have to go to Grady?
Pneumonia.
Pneumonia?
Yes.
Okay, they were able to treat that?
Yes.
Okay. What is the, Mr. Nagasaka described a number of conditions that you're suffering from. Is it the COPD that mostly lays you low, or?
The COPD.
Okay.
Yes.
All right. How old are you?
61.
How long have you known Mr. Johnson?
About 40 years.
40?
Yes.
Okay. And you stay at his house?
Yes.
Do you get disability benefits?
Yes.
And that's how he's able to help afford to care for you?
Yes.
Okay, got it. Thank you. Ms. Harvey, good morning.
Good morning, Your Honor.
Do you have any criminal history information on Mr. Wiley?
Yes, Your Honor. 34 cycles. His last arrest was in 2014 for a capital offense. That case was not presented to the grand jury out of Fulton County. I'm showing the last felony conviction was in 2013 for possession of cocaine. There's a 2008 burglary conviction, 2007 possession of tools and theft by taking, 2006 purchase, possession, control of drugs, 2004 purchase, possession, control of drugs, 2003 possession of cocaine, 2001 theft by receiving stolen property, 1995 violating the Georgia Controlled Substance Act, and 1989 aggravated assault. And nothing further, Your Honor.
Thank you so much.
You're welcome.
Mr. Peoples.
Yes, Judge. Good morning.
Good morning.
Your Honor, yes, the state was going to cite Mr. Wiley's extensive criminal history. I do concede to defense counsel that it has been some time since his last offense.
What was, if you've had a chance, and I guess I could press Ms. Harvey for that, the 2014, she described it as a capital offense.
Murder, Judge.
Oh, okay. But it wasn't presented to the grand jury. Whatever happened on your side of the shop, your office concluded we're not moving forward with that.
And I can't speak to that, Judge. I attempted to look this morning. I'm unable to see.
Okay. I mean, it clearly didn't go forward to an indictment.
Yes, Judge.
All right, back to you.
Yes, as it relates, the state citing the Ayala factors, we believe that he is a danger to the community as well as a risk of reoffending while out on bond, citing his extensive criminal history. Your Honor, as the court read some of the charges, a general explanation of some of the facts, and I'll use the victim's initials, M as in Mary, W as in Wiley. She was born on May 3rd of 2016. At the date of her disclosure and outcry, she was 9 years old. She describes ongoing sexual abuse by her father, the defendant, since she was 3 years old.
I want to unpackage this. You're saying that the 9-year-old is the biological child, not granddaughter, but child?
I saw child in.
Okay, Mr. Nagasaka, you confirm that?
Yes, based on what came out of the preliminary hearing, I believe it's child.
Okay, all right.
And she describes ongoing sexual abuse since she was 3 years old. She makes this disclosure to her sister, her adult sister, Takara Wiley, Toccara, Wiley, same spelling. And she describes, Your Honor, penetrative vaginal and penile intercourse, unprotected intercourse with the defendant, and the defendant knowing that he has a communicable immunodeficiency disease. as well as that the defendant had her make oral contact with his penis. We do believe, Your Honor, that, and respectfully, I understand that Mr. Wiley, through his counsel, is submitting to the court that his extensive health issues would prevent him from making any further assaults or sexual contact with children, but we don't believe, the state submits to the court that he was able to continually abuse this child, even with his extensive medical issues. And for all of those reasons, Judge, especially citing at least two of the IL factors, risk of reoffending while out on bond and danger to the community, the state is opposed to bond. I believe our office has reached out to the victim. We were having some difficulties touching bases with her.
And when you say with her, I'm assuming it would be with some guardian?
Yes, Judge.
Okay. And who would that be? If Mr. Wiley is the father, with whom does MW stay?
Her sister, Takara.
Okay. The person to whom she disclosed?
Yes, Judge.
Okay. And this is an adult sibling?
Yes. And for all those reasons, Judge, citing the severity of these charges, as well as reoffending while out on bond and danger to the community, the state is opposed to bond. If the court is inclined to set a bond, we would ask for somewhere around $250,000 to $300,000.
Okay. So I think it's important for the record to reflect, because what Ms. Rivers is able to do is create a text, and there's no video, that Mr. Wiley is here in court with an oxygen tank. He's seated. He's unable to stand. So Mr. Nagasaka is not overstating some of the disabilities that Mr. Wiley faces because of his medical conditions. That said, what I would like to do, Mr. Nagasaka, and if I am told that I need a release, I'll turn to you for this. I would like to confer with the medical professionals at the jail about their ability to care for Mr. Wiley and concerns they may have about his ability to receive the level of care that he needs based on the conditions he has. To me, that is a pretty important factor. I'm going to call it the fifth IALA factor. Mr. Wiley does not present here in court as a flight risk. I'll grant you that. But these allegations involve alleged conduct of Mr. Wiley during a period when he was both more fit and mobile, but also less fit and less mobile. So I do have some concerns about some of the other factors and the dynamic that it's a father-daughter relationship. The prong about influencing witnesses concerns me as well. So I would like to get a little more health information, not in terms of what are the specifics, but again, NAF Care and the jail's ability in partnership with Grady to care for Mr. Wiley while this case moves forward. Do you have any objection if I reach out to the medical professionals?
No, Your Honor, I think that makes sense.
Okay. If they tell me that they need a release of some sort, I will let you know, and you and Mr. Wiley can confer about whether he's going to share that. But again, I'm not asking them for any of the specifics about Mr. Wiley's ailments. And it's much more what's your ability, jail, to provide the appropriate level of care. Because we do have some where it actually is inimical to health to keep the person there, apart from people saying in general it's not healthy to be at the jail. And Mr. Wiley is certainly trending in that direction. So I'd like to chat with them. Mr. Peoples, anything else from the state?
Nothing from the state.
Okay, so Mr. Wiley, I'm taking this under advisement. I need to talk with the doctors and nurses at the jail about your situation. And then if I need more information from the lawyers, I'll email them. We won't drag you back here for that. Otherwise, I'll get an order in place, either setting a bond or denying bond. In the meantime, your case will continue to move forward. You had your preliminary hearing. The state needs to decide, are they indicting, not indicting? And Mr. Nagasaka will be your advocate up until the point that the case is indicted. So if we need to talk about bond again, he'll come to me and you'll come to me. All right?
Yes, sir.
Okay. Thank you, everyone.
Your Honor. And that is, of course, my only matter, Your Honor.
It's nice to meet you, sir.
Good to meet you as well.
See you again, man. Next time.
All right, so put it here.
Yeah, you know, wrong one taking
Handle who?
out here, you guys, I don't know.
Yeah. Okay. So Ms. Wood and Ms. Rios, if you have, I can let lawyers chat if that's what needs to happen. But if you have anyone who's on bond, Deputy Gordon needs to take Mr. Wiley down now. We could work through bond situations.
Do we want to talk about Miss McGee Russell?
Sure, we could do that. Mr. Griggs, you're still here.
Yes, Judge, you said you wanted to hold, on Mr. Jackson, request for the continuance.
Oh, meaning I'm gonna think about it. I didn't mean to keep you here. I'm sorry.
That's fine.
I know you need to circulate. So I've got it on my list. And I will certainly let you and Mr. Abadi know. It's not till end of July that the folks are available to talk with him. Okay.
And I also filed that, conflict with Judge Leader.
Right. Okay, so that's in there now. So you will file it.
Set the notice.
All right, you just learned yesterday about it. Thanks. Okay.
All right, thank you.
All right, take care. Yes, Ms. Rios, I think with, get to it, Ms. McGee Russell, I don't think I've signed the paperwork yet, but this would be a situation that could happen. Are you providing of late, your office has said, I think it's Dr. Browning?
Yeah, I was gonna do a court one.
It was just the standard approach, but it would be one where Ms. Green, who is with our court, would then figure out, yes, a doctor's available. Ms. McGee Russell will come to court and be in a jury room or here in court, an empty courtroom, and the doctor would be here and they'd have a conversation. That's what you're asking to have happen?
Yes, sir.
Okay. Ms. McGee Russell, you doing okay? Well, I'm all right. Any issues getting here today?
No, I said, I'm not grandfather taking.
Is that who's seated next to you?
Yes.
Okay. Is that who you're staying with?
Yeah, right now.
Okay. Do you have phone and email information for Ms. Rios?
Yes.
Ms. Rios, do you have pretty good information for Ms. McGee Russell? Ms. McGee Russell, we're setting up an appointment for you that I need you to be on time for when we set it up. I don't know the date and time, but Ms. Rios will need to be able to communicate with you. Are you likely to have the same number or same email address over the next few weeks? Okay, all right. Ms. Smith, anything on Ms. McGee Russell? Oh, she's not here. You've been talking with her though.
Yes.
We need to figure out what's going on.
Yes, sir.
Okay, anything else?
No, thank you.
All right, we're gonna figure out when that appointment is and someone will let you know, and you just need to make the appointment, all right? Thank you. Why don't I call the inquiry calendar at least, and we'll see what we're doing. Kiera Dickens, it's listed as pro se. Still pro se? Okay, all right. We'll interact with her later. Joshua McDuffie, Ms. Rios, that's a revocation.
Yes,
Is
sir.
that one we can do today?
Yes.
All right. William Walker. I don't know which of you, it would be your number. Yeah.
It's mine, and I'm ready for today. We had to reset because there was a warrant that we didn't get, and she wanted to add it to the, right, Ms. Simpson, Mr. Walker, it was reset.
Oh, it was to add an additional basis for a violation?
I believe so.
Okay. Pontius Thomas. Will that be you or is it Mr. Wright?
He is mine. Yeah, I believe he's mine.
Okay. Is that one we can do today? Great. And then Jamal Stone. Oh,
That's
it's a
mine.
bond hearing and that's Ms. Cabrera. Okay.
That's mine, Judge. I don't know if he's brought over. I'm in Cobb County now, and I don't know if
Okay.
he's physically there. Is he there?
I will know, Deputy Gordon had to take Mr. Wiley downstairs, so, we'll ask him when I have no reason to believe he's not here.
Okay.
Are you gonna be coming here or you will be handling the
Yes.
bond hearing virtually?
No, I mean, if he's physically there, it's gonna be hard for me to talk to him. So I'm in Cobb now, so I will leave and come to Fulton.
Well, why don't you wait till we confirm he's here so you don't come down here unless you got other reasons to be here.
I'll head to my car and
Okay.
I'll stay connected and we'll see what happens.
Head to the red machine. All right.
Yeah.
Okay. Ms. Smith, you're back.
Yes, Judge.
All right, so we, have some revocations we can handle, but I think we have some pleas that are ready, which we ought to do first. We'll get Ms. Sherry last, like, me. So we'll do that. I just want to put on your radar, I'm not sure what we're doing with it, but position 1 on the inquiry calendar, Ms. Kiera Dickens. That's you, me, and Ms. Dickens.
Yes.
Okay, all right. Why don't we start with Ms. Smart? Is that your case, Ms. Smith?
No, that'll be, Mr. Peoples. He stepped out for me.
Okay, well, Mr. People, you can go grab him. Do you have any updates, on the trial calendar?
No.
Okay, Mr. Brill, you had a chance to confer with Ms. Smith and your client?
I was gonna try to do that while this plea was gonna happen, because I was talking to my client about that.
Excellent. Good. Keep talking then. All right, then, that'll happen. So we'll get Mr. Peoples back in here. Okay, I'm not going anywhere. Have you had a chance to speak with Mr. Compton?
I have, Judge. I think, we don't have a plea today.
All right. Mr. Abadi went, I think, to Glanville.
Yes, and
He'll
I
be
think
back.
he's gonna send Mr. Rao in.
Okay.
And it might be a situation where if the court will allow us to just take a plea and maybe do the sentencing portion later so that victim family members can.
Sure. So we block in yep, this is how we're sorting this out.
Yes.
Great. Well, good work.
Thank you. Good, I'm gonna go through the bag.
Okay. Mr. Peoples, you ready for Ms. Smart's plea?
I am, Judge. I'm spinning plates this morning.
You're doing a great job. I appreciate you filling in. And it sounds like Ms. Williams is back a little bit.
She's back, Judge. I think it's a slow.
As it should be, but that's great. Plugging back in is a healthy thing to do.
Yeah, so I'm filling in while she
Great.
transitions back in.
Understood. Let me know when you're ready.
Yes, Judge. 1 second. I'm sorry.
No worries.
Going slow. Ready, Judge.
You good? Okay. Let's get on the record with Ms. Smart's case. It's position 16 on our trial calendar, 25 SC 004843. Ms. Smart is here in court with her lawyer, Ms. Sherry Lassiter. Mr. Peoples is handling things for the state. Good morning, Ms. Smart.
Good morning, sir.
In just a moment, Mr. Peoples is going to put you under oath. Once you're under oath, you'll need to answer his questions truthfully and completely. If at any point someone says something that you don't understand or is going differently than what you and your lawyer have been talking about, will you let me know?
Yes, sir.
Okay, then let's get started.
Good morning.
Good morning, sir.
You able to hear me?
Yes, sir.
And you're very soft spoken, so if you could either just speak up a little bit or into the mic.
All right, scary.
Okay. Will you raise your right hand?
Okay.
Do you solemnly swear the testimony you'll give in the proceedings before you today will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Thank you. You can lower your hand. Will you state your true, correct, and legal name?
Teresa Catherine Judith Smart.
Okay. Can you spell it?
THERESASMART, Catherine CATHERINA, Judith JUDITH, last name Smart SMART.
And are you at this time taking or under the influence of any drugs, medication, or alcohol?
No, sir.
Is there a medication that you normally take that you have not been given today?
No, sir.
And how old are you?
43 years old.
And what is the highest level of education that you've completed?
An associate's degree.
Are you able to read, write, and fully understand the English language?
Yes, sir.
You understand that you're charged with the following offenses. Cruelty to children, count 1, cruelty to children in the first degree, which carries a sentence range of 1 to 10 years. And count 2, cruelty to children in the first degree, which also carries a sentence range of 1 to 10 years.
What did we decide? We actually decided to take a plea deal.
I understand. I'm asking, do you understand? I'm
Do I-
explaining to you the.
Yes, I do.
Yeah, and the question, Ms. Smart, is just, this is what you're charged with.
Okay.
And the sentencing range is the 1 to 10, not that that's what anyone has agreed to. That's just what the law is.
I'm so sorry.
That's okay. This is not something you do often.
Would you like me? I'll restate that question.
Thank you so much.
No problem. Do you understand that you're charged with the following offenses? Count 1, cruelty to children in the first degree, which carries a sentence range of 1 to 10 years. And count 2, cruelty to children in the first degree, which also carries a sentence range of 1 to 10 years. Do you understand? That those are the sentencing ranges, not what you're pleading to today.
Yes, sir.
Okay.
Deputy Gordon.
Yes.
Sorry to interrupt.
May I have one
Quick
more
pause. Is Mr. Stone here?
Down the road.
He will be here? He's in transport? Okay, thank you. All right, back to what we need to do.
Thank you.
Keep going, we're good.
Do you understand that you have the right to plead either guilty or not guilty to these charges?
Yes, sir.
Do you understand that if you plead not guilty or remain silent and enter no plea at all, that you may receive a jury trial?
Yes, sir.
Have you had enough time to speak with your attorney about all the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes.
Do you need any more time to discuss this case with your attorney?
No.
Are you satisfied with their services?
Yes.
Counsel, do you waive formal reading of the indictment?
So waive.
Do you waive any and all defects in the indictment, including any with respect to your client's name?
Yes, we waive.
Ms. Smart, do you understand that this is a negotiated plea of guilty, which means that the joint recommendation of the state and the defense to the court will be a sentence of 10 years probation, that you shall complete mental health evaluation and any recommended treatment, that you shall consume no illegal drugs or alcohol, that you shall have no contact with the victim, Amira Henderson, Amirah, Henderson, Henderson. Do you understand that? And that, go ahead.
It is upon request of the daughter and supervision if needed.
Yes, except upon, I'll say, written request of Miss Amira Henderson and supervision if required.
Oh, no, we hadn't discussed those terms. We had discussed a different term in the hallway.
Do you need a second to talk to your
Yes.
attorney?
Can I have 1 second?
Sure.
Okay.
What do you understand?
Judge, while they're doing that, I have the SC number if you need.
Remind me which case this goes to?
The behaviors in the day.
Is this the Aaron Pendleton? No. I'm looking for Ms. Williams's cases, and I'll give you names. It's not Teresa Smart, we're doing that. Trinice Lawton,
Yes, that's it.
Ms. Wood's case.
It's,
Okay,
it's 26 SC
Take
002
it today.
690.
690?
Yes, Judge.
Great, thank you. Is Ms. Lawton here now? She is, that's right. Okay, great.
Your Honor, if I may, there's some confusion about the behavior incentive date that I will be requesting.
Okay.
And Ms. Smart is understanding what the state is offering, but I was trying to explain to her that there is a potential upon Your Honor's approval of behavior incentive date.
Sure.
And she wants to, I don't want to skip ahead to that part, but she's not comfortable saying anything about the 10-year probation until we talk about the behavior incentive date. So how can we assist?
Well, a couple things, Ms. Smart. Right now, what Mr. Peoples had put on the record is what I think was negotiated, that the sentence would be 10 years probation, and then he provided a few of the special conditions, that you get an evaluation, if any treatment is recommended, you follow that treatment, and then no contact with Ms. Henderson unless she asked for it, and if so, that would be supervised contact. That's as far as we got.
Yes.
There are any other conditions?
No, Judge.
Okay, so that's what the state's going to be recommending. Ms. Sherry Lassiter is going to be asking that I set a behavioral incentive date. How many years out were you asking?
We're asking for 1, Your Honor, because the case is 2 years old. Normally I would ask for 3, but she's already, no trouble in the past 2 years. She's already been compliant with every law.
Okay, so your lawyer is going to advocate, Ms. Smart, for a behavioral incentive date of about a year from now. And if I agree with that, and I don't know yet if I'm going to agree with it, because I actually don't know anything about the case, then you would be done with probation in a year. I might instead say, I think the behavioral incentive date should be a little further out. I might say 2 years, or something like that. But I am the one who decides. I'll hear from you in just a second. Let me just finish. I am the one who decides whether there's a behavioral incentive date. Your lawyer can't impose that. The prosecutor can't impose that. They can advocate for it, and I'm certainly going to listen to them. Your lawyer knows you best among the people here in the room. Mr. Peoples is particularly close to the facts of the case. And so I will certainly be open to being persuaded by what they have to say. But I can't promise you anything right now because I need to hear more about you and your situation. For example, I didn't realize that the case was quite this old. It looks like its anniversary is two days from today.
Correct. Yeah.
And so if you've been doing all the things you needed to do over the last 2 years, that's a great reason to say, let's have a pretty short behavioral incentive date. But I think you can understand why I'd want to hear all the moving parts before I say, all right, here's how we're going to sort this out. Does that make sense? You got to say out loud, yes.
Yes.
Okay. Did you have a question before we keep going?
Yes, sir. My question would then be, since it's been 2 years of me doing parenting classes, mental health, I did community service. I did a lot of things that are going to be remandated in the community service setup. And it's already been 2 years of me not having my daughter. Would we be able to reconvene in a month to make that decision?
Oh, no, we haven't gotten that.
So today's the day we're sorting these things out, because if we don't, then we don't need to wait a whole month. We'll go to Monday, and on Monday we'll have a trial. And we can bring in the doctors and the police officers, et cetera, and they'll tell me what. Yes?
I thought it was your decision.
No, let's get.
So I'm doing a bad job of describing. So if you go forward with the plea, if you accept responsibility for what happened here, then it is my decision as to what we do with the sentence. And I want to set your mind at ease. If both lawyers are recommending probation, I'm very likely to go along with the probation. To me, the question mark will be, where do we set that behavioral incentive date? And that's where I need to learn more about how you've been doing. You've already shared some things. You've done some community service. You've been taking parenting classes. Those are all great steps forward and important for me to hear. But if we don't do the plea today, then the next item on the agenda is trial on Monday, which would mean bringing Amira down here and she testifies and the doctors testify. And that's a decision for you and Ms. Sherry Lassiter to make. Otherwise, we can go forward with the plea and figure out what we're going to do there. Do you have a preference?
I'm not comfortable with the plea,
Tell me what you're not comfortable about.
the 10 years.
Okay. What is it you think should happen?
The 10 years should not be, I mean, I know that that's just like preliminary, but it just seems such a far-fetched number.
Hey, pardon me?
It seems like a wait, it just seems like a it just seems like the max, like not the, it just seems.
Yeah.
It seems.
It's a big number.
It's a big number.
It's a big number. It's probation rather than being in custody. But yes?
I'm a nurse, which means that the longer I'm on probation, also without me, and I haven't been working as a nurse for 2 years.
Right.
So this has killed my finances, my livelihood,
Okay.
my daughter, everything that I've worked my entire life for.
Yeah.
So 10 years.
Okay. So let's take a quick pause. I think the lawyers are going to confer for a second.
I didn't.
I mean, I'm fine, but she gonna blow it up.
Yeah, if I may, Miss Mark is saying a lot of my argument right now.
I think so. It's persuasive too.
Yeah, and I had all that she's saying, you're taking my job. I just think that if we can get to that point, present my argument for the behavior incentive date,
Right.
she can have more of a conscious decision about what she wants to do. We haven't gotten there quite yet.
Right.
I think she heard the 10 years on the stand, and even though we talked about that in the hallway, I
Right.
didn't talk to you about that. And I did talk to her about my request, but the request I'll be making it is your honest decision. I just think that we need to let everything play out. If she could just hold her questions till we get to the end, if possible.
Okay.
And then we decide what you want to do after the judge makes allow me to present your case to the judge.
Are you all right with that, Ms. Smart, if we go forward with it and then we'll see how it shakes out, okay? Yes?
Yes, sir.
Okay. Mr. Peoples?
Yes, sir, sorry.
You understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as in other jurisdictions, including the federal courts.
Yes, yes, sir, thank you.
You understand that if you are placed on probation of any kind, that you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence.
Yes,
You understand that you are not allowed to possess nor use a firearm or any replicas while on probation.
yes,
Are you a citizen of the United States?
yes,
You understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty today.
yes,
There are certain rights that you give up by entering a plea of guilty, which include the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront the witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to have the charges against you proven beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial. You understand all these rights?
yes,
Has anyone used any force, threats, or promises which has caused you to enter this guilty plea against your will?
no,
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
no, sir.
So, is this a offered plea or
Yes,
was this
offered.
question asked in a way that was confusing?
It'll be an offer plea. It's in her best interest to take the plea.
Got it. So, Ms. Smart, what Mr. Peoples had just asked is, are you prepared to enter a guilty plea? And you said no. But now I understand why. Your plea is going to be what we call a best interest plea, where you're effectively saying, I don't agree with all these things you say happened. However, I, Ms. Smart, would like to put this behind me, and I'm going to go forward with this plea because I've decided after thinking about it, talking about it with my lawyer and others, that it's in my best interest, meaning your best interest, to go forward with the plea. Does that describe your situation?
Yes, sir.
Okay, and that's what you want to do?
Yes, sir.
Okay.
How do you plead to count one, cruelty to children in the first degree?
Alfred?
You say, what, so there are three things you can say right now. You can plead guilty, but you've told me that's not your plan. You could plead not guilty, which means on Monday we start the trial, or you can say guilty under Alford, which is that best interest plea. So that's how you are signaling to me and the world that, yes, I want to work this out. It's best for me, maybe best for my daughter, but I'm not agreeing with everything you say happened.
Okay,
So that's guilty under Alford.
okay. Guilty under Alfred, thank you.
How do you plead to count two, cruelty to children in the first degree?
Guilty under Alfred, thank you.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, sir.
You understand that unless counsel is substituted or permitted to withdraw, the defense counsel will represent you until either the end of the current term of court or 30 days from today's date, whichever is later.
Yes,
You understand that you have only 12 months from today for misdemeanors and 4 years for felonies to file what is known as a habeas corpus petition, challenging the voluntariness of this guilty plea.
yes,
You do not have a right to appeal directly from this guilty plea, but if you believe there is some error in your guilty plea, you can apply to the appropriate appellate court to request what is known as a discretionary appeal. The discretionary appeal procedure is outlined in OCGA 5-6-35 and must be completed within 30 days of today's date. You understand?
yes,
You understand any of the filings that we've just discussed must be filed by your counsel unless you're representing yourself.
yes,
Your Honor, if this had proceeded to trial, the state would have expected to prove beyond a reasonable doubt that on or about May 30th to June 4th of 2024, that law enforcement responded to an incident location at Children's Healthcare of Atlanta on Johnson Ferry Road within the bounds of Fulton County. The victim child, Amira Henderson, was brought with neurological concerns and drug ingestion. She was initially transported to Emory Hillendale by her daycare. Hospital staff alleged that her mother, the defendant, had placed some unknown substance into her IV drip. It was determined that they were benzos. She had also given Amira melatonin and Benadryl, and at some point, the defendant had to be removed from the child's hospital room, where she began to improve. Your Honor, the father, I believe, is on the Zoom. My understanding is that he did not want to speak, but he is present. And he is aware of the recommendation. I believe he's fine with it. I did not work out this. I am, as I've informed the court, I am standing in, but the state does believe that this is an appropriate resolution.
Okay. Do you know from your review of the file, where Amira Henderson is now? I don't mean physically today, but she is under whose care?
With her father.
Okay. And is that, there's a Henderson on the call. You said that would be the father?
Yes, Judge.
Well, it says Danique. Okay, but most importantly, the daughter is with the dad.
Yes, Judge.
Okay. And that's where she's been, I guess, since this happened.
Yes.
Okay. All right. And how old is the daughter now?
6.
She's
She's 6.
Okay. All right, thank you. Ms. Harvey, do you have criminal history information for Ms. Smart?
Yes, Your Honor. 4 Cycles does not appear to have any prior felony convictions. The last arrest was June 3rd, 2022 out of Clayton County for criminal trespass. She entered a NOLA on that case, Your Honor, and nothing further to add.
Thank you.
You're welcome.
All right, Ms. Sherry Lassiter.
Thank you, Your Honor. Just to go over a little bit what we've heard already, we will be requesting a plea under first offender. She does not have any felonies on her record, as we just heard, and that we be able to seal her record so that she can be able to continue working. She has been able to work in the past 2 years. She has complied with all of the conditions that would be imposed on probation for the past 2 years of her own without a court order. She has been to parenting classes. She's conducted community service. She's had no other criminal involvement in the past 2 years. She also, I don't believe, has seen her daughter since this incident, so she has no contact with the daughter. And the child is now in Savannah with the father, which she's understanding that if she's able to see her, that it will be at the daughter's request and at whatever supervision they deem appropriate at that time. We are asking for a behavior incentive date, Your Honor, of 1 year because she has been going through this for the past 2 years and she has been technically on probation without an actual order. 43 years old, she's been a nurse over 20 years. And she, because of her nursing background, this situation did not, she's taking responsibility. I don't want you to think she's not aware about what happened, but because of her nursing background, she felt that she was helping her daughter. She had no intent to injure her daughter. And she, I believe.
Was there an underlying condition that her daughter had or?
Did have a illness.
Okay.
Bacterial meningitis.
She had bacterial meningitis.
Okay.
And I believe the over-the-counter melatonin Benadryl was to assist her with her resting. I'm not sure of the other substance, but she was doing what she felt like, which now she knows it's not appropriate. And I'm trying to make sure I don't leave anything out.
They gave her Ativan at the first hospital, and she was very lethargic.
Okay, yeah, so she had been to, before this hospitalization, she had been to a previous hospital where they were giving her Ativan, which also makes the a child like lethargic or tired acting. So it was an ongoing medical condition, but at this stage, we were trying to get her in the another program, the pretrial program, but because she had the Clayton County trespass issue, which I think was a domestic issue from those years ago, she was not eligible for that program. So that's why we were asking for that 1-year behavior incentive date, Your Honor, if possible.
Okay. And just to clear things up, it is Ms. Henderson's stepmother who's on. Her father's at work. So Danique Henderson is stepmom. So she's listening in and representing that part of the family. But Mr. Henderson needed to be at work.
Thank you, Your Honor.
Sure. Ms. Smart, do you have other kids?
I do. They're older though.
What does older mean?
My son is 28. He's U.S. Navy, and my daughter is 23. She's U.S. flight attendant, and my baby girl is 6.
You have a brother who's 6, or you have a 6-year-old?
My baby girl is 6.
Oh, your baby girl, meaning Ms. Right, got it. Okay, so you have a 28-year-old in the military, 23-year-old working with the airlines, and then we've got the child who's the subject of this case.
Correct, Your Honor.
Got it, okay. And are you based locally now, or are you in Savannah?
No, sir. He got into the military about 8 months ago, so he's U.S. Army now.
Okay, but you, Ms. Smart.
Stone Mountain.
Okay,
Stone Mountain.
got it. So you're DeKalb County, you're local.
Yes, sir.
Okay, all right. Tell me why you were doing community service and where you were doing community service.
For an organization called, but it wasn't community service, it was paid service. It's basically the only kind of work I can find right now because of my record.
What's the name of the company?
But it's CEO.
CEO is the name of the company. Where is it based? Where is it?
Well, what kind of work were you doing?
A litter pickup, trash pickup.
Okay.
Cleaning public restrooms.
Got it. I'm familiar with the CEO program. We have folks in our accountability courts who use that. The parenting classes, one class, lots of classes. Where'd you go for those?
Most of those are done I can print out the certificate for that. You call your Zoom and you do every Wednesday from 2 to 4. They'll walk you through the stages of growth in children about how to react to your child when they get upset.
We can get the certificate.
I don't need to see them. I just was interested in hearing about them. Ms. Smart, you are asking to be sentenced as a first offender. You qualify for that. It's mostly an opportunity because if I sentence you as a first offender, this is not a conviction. So if you are trying to go back to work as a nurse or go back to school to get an advanced degree, you don't have to check the box that says I'm a felon because you're not. You will be a first offender probationer. So you will have a sentence, but it is not a conviction. That's very, very valuable for a professional like you. But it comes with a risk. If you are not sure you're going to be staying out of trouble in the next few years, losing your first offender status would mean I would be resentencing you. And in this case, it could be up to 20 years. That's what 10 plus 10 is. I'm not saying it would be anything like that, but I just need you to understand the risk of first offender. It is primarily a benefit and one you qualify for. But the risk is if you aren't taking good care of yourself, if it turns out that you would benefit from some treatment and you're not doing that and you get arrested for doing something else, not only would you have that new case, but this old case, the state could say, no more first offender. We want that revoked and please resentence Ms. Smart. And I would think about doing that. So do you understand the risk of first offender?
Yes, sir.
And the benefit?
Yes, sir.
And would you like to be sentenced as a first offender?
Yes, sir.
Okay, I'll do that. Ms. Sherry Lassiter, I'll look to you to present an order that would seal Ms. Smart's records. Obviously include Mr. Peoples or Ms. Williams on that email in case they've got an issue with it. But if it's a standard order, they shouldn't have an issue with that.
We'll do that over, Your Honor.
All right. Ms. Smart, do you have any questions before we get to the end of this?
No, sir.
Okay. Well, Ms. Smart, I find there's a factual basis for your plea. I understand that it's an offered plea, that you disagree with some of what the state said. But my review of the record is that if this went to trial, a jury could find you guilty of the charges. I don't know that they would, but if they did, I'd find that there's a sufficient basis for their finding. I also conclude that your plea is knowing and voluntary. You know what voluntary is. That means no one's forcing you to enter the plea. And knowing means you've understood what we've been talking about. Maybe not right away, but after asking questions of your lawyer or of me, I feel like you're in a position that you've understood what we discussed. Do you agree with that?
Yes, sir.
Okay, then I'll accept your plea. Ms. Sherry Lassiter, can someone in my office sign the indictment on your behalf?
Yes, Your Honor.
Mr. Peoples?
No objection, Judge.
All right, and Ms. Smart, is it all right if we electronically sign your name indicating your offered first offender plea in this case?
Yes, sir.
We'll do that. Ms. Smart, I am going to sentence you on count 1 to 6 years. Count 2 will be 6 years. I will run those concurrently with each other, and I will probate them. So it's 6 years probation. Special condition of probation number 1 is that you get with a mental health professional, have an evaluation, and if that doctor or counselor recommends any treatment, be it medication or counseling or therapy, that treatment becomes part of your probation. Special condition number 2 is to have no contact with Amira Henderson unless she initiates that contact. So if she reaches out through her father or her stepmother to say, we want to do a FaceTime or this or that or visit, that's okay. It's just you aren't reaching out to them to check on Amira. You understand those conditions?
Yes.
Okay. Mr. Peoples, did you have any other conditions that I overlooked?
No, Judge.
All right. Ms. Sherry Lassiter, other than the behavioral incentive date, which we're going to talk about in a minute.
No, Your Honor.
All right. So, Ms. Smart, well, let me ask this. Ms. Henderson, if you put it in chat, you can come off mute. I want to confirm that you and your husband and Amira have been able to move forward without Ms. Smart trying to reach out to have contact with Amira. Can you confirm that?
Can you say again one more time, Judge? Good morning, everybody.
Good morning.
Can you go again, please?
Good morning. I just wanted to make sure, Ms. Sherry Lassiter has said that Ms. Smart has complied with the condition of bond, which was to have no contact with Amira. And I just wanted to make sure that you and your husband haven't had any issues with Ms. Smart showing up at the house or reaching out, trying to have contact with Amira.
No, she has not done that.
Okay.
She would not initiate to do that.
Okay. Thank you.
You're welcome.
All right. So Ms. Smart, what I'm going to do is set a behavioral incentive date at November 29th of 2020. Make sure I do the math right. 2027. So it's a year and a half from now. If during that time you have continued to have no contact, which you've done great with, and just as importantly, you have demonstrated to probation that if there was treatment that you should be following for your health and well-being, that you're doing that and you're on track with that, then probation is invited to come to me to say, hey, it's been 18 months. Ms. Smart is doing everything she was supposed to do. Can we please close this case out? And if that's what they ask me to do, that's what I'll do. So it really is up to you. If you are doing the things that I know you can do and I know you want to do, then probation will say, we don't need to do the full 6 years. We've established that Ms. Smart is stable. She's working. She's doing the things she needs to do. Let's get out of her life and let her move forward. Okay? Does that make sense?
Yes, sir.
All right. Mr. Peoples, anything else from the state?
No, Judge.
Anything else, Ms. Sherry Lassiter?
No, Your Honor. Thank you.
So I have one more thing for you, Ms. Smart. I'm going to introduce you to Ms. Simpson. She's seated in the jury box right there. She's with probation. She is not going to be your probation officer, but she's going to give you reporting instructions. Because you live in Stone Mountain, you'll be supervised in DeKalb County. So Ms. Simpson's going to tell you where you need to be and when you need to be for that first meeting with a probation officer. Make sure you make that first appointment. That's the most important one. That's how we kick things off in the right direction, okay?
Okay.
All right. Ms. Sherry Lassiter, if you join them, I'd appreciate that. Once Ms. Simpson's finished with Ms. Smart, both of you are free to go.
Thank you, Your Honor.
Thank you for your help with this case.
Thank you, Judge.
Thank you, Mr. Peoples. And thank you, Ms. Henderson, for being on the call. You're good to go.
Hey, Judge, just confirming that way I know what I'm doing for next week. Deshaun Jones won't be shortlisted for the consolidated. I know you said it didn't make the shortlist.
Oh, you shifted gears to Emerson.
Yes.
Correct. It's not on the short list. If we add it, it's already Thursday, so yeah.
Okay. And I'll stand down on this purpose.
Okay.
Thank you.
Sure.
I know I'm up again, if you'll just give me a couple minutes to talk to.
You should talk.
We're back to talk to.
All right, you do what you need to do. Mr. Hey, who's downstairs? Oh, okay, that one can wait. All right, Ms. Cabrera is heading this way, and that's Stone. We just need to know if she needed to come here, and if Stone wasn't gonna be here, she wasn't gonna come here. So we'll make that happen. Mr. Rao is here. Should we bring Mr. Compton?
Not yet.
Not yet. Okay, don't go anywhere. Thanks.
He just wants me to call a family member judge to have them get on Zoom and.
Makes sense.
Oh, yeah, here you go. Oh, you want to talk to him? Thank you.
All right, I will be right back. Ms. Smith, do you have anything for when I come back?
I believe I have a plea with Lacey, and I may be doing a bond during the videos, but.
Okay, great. Yeah, I don't know if Battle is here yet.
Okay. But I think.
Okay.
No, do you need it? Oh, here, I'll just, you might have a copy. I'm curious, please. Yes.
Yeah, make sure that.
What's up? What's up?
I didn't say.
What about you?
As much as I was just bringing the old, office and sealing, Mr. Weaver.
Yeah, I've already done with them.
Yeah, he's reasonable. We're not gonna wait today, three minutes coming, so.
Nice.
It's a. He's not fine. Stupid ass case, but. Anyway. You know, it's a case where I probably.
Which case is it?
Mr. Schmidt. Picking her out. I mean, the reason, the only reason I don't want to is like, if the things go through, they don't.
Yeah.
My client was. And. I'll think they go, I don't, the problem is not. Got to bitch. And she, I mean, with the level of the victim's bitching the whole time and their neighbors, like, it's gonna be a problem, like. It's gonna be, it's gonna be a reduction of disorder.
Oh, perfect. Like 12 months or something less than that.
12 months to serve time with basically, it's basically gonna be a non-reporting sentence when he leaves the courthouse. Yeah.
Okay, perfect.
He nearly died in Bright Street.
How long was he in?
For 17 days. But he was like over Christmas, he doesn't really have like, because he didn't really have a family here, like, I met him at the jail and he's got a few doctors from, and he bought these 3 or 4 properties in the hood. And he put in this property that I was like working on for like 9 years, so I don't know him. He's just some old black guy. And they found he was a cop city guy. He told the cops that he's like, yeah, he's one of those fucking terrible, they're probably trash and shit. He's like, he's a single cop. Like, the videos are overnight. And like, you know, this girl's like, fucking big ass pit bull. She loses track of this big ass pit bull, comes after him. He has this little dog. And, you know, goes like this, and he's yelling at her, takes out his phone. She says it's a gun, and she goes running back. She's crying. He's like, what? Like, calls the cops are like, as he's some guy comes traveling down in his Dodge Charger. He goes, yeah, that white guy's creepy. Like, just the words.
Oh my God.
It's awful.
I
Like,
like this resolution to your client, but this would have been a very entertaining.
it would have been a great,
Yeah.
but like, the problem.
YouTube chat would have loved it.
Yeah, no, but it would have been incredible. But the problem is like, it's.
Oh, no,
You
I
know,
get it.
right, like-
Absolutely. I get it.
I need now for the.
Absolutely.
You know, and that's not, I don't really want to. My client just doesn't understand, like, aggravated assault not hard to prove, like. If the results are all credible and, you know, like.
Yeah.
I have a witness that said it didn't happen, but her account's a little bit sketchy. What's that? From the affidavit and I will say the ADA she did her due diligence. She talked to her, like, she got it reduced. I mean, it would have been a good case to try. I would have tried it if she wouldn't have come down, but like.
Yeah, no, just really
He's
fun.
just like,
Respond.
but I'm number 2 in Gwinnett. It's a child molestation on count and is bad. It's like immediate outcry. Like it's a party. Everyone's just family. It's a party. 10 minutes after it happened, she goes, Mom, like my client's confronted, he leaves. They confront him like 2 hours later, interview. He's been in custody the whole time. I got it, downward deviation.
And he doesn't.
Offers 15, your life's for 15. And which is a gift.
Yeah.
And he's like, I'll take 10. And his mom's like, you shouldn't bleed unless he did something wrong. And I'm like, wait a second. Like, so I'm doing management.
Oh my gosh. What's the other case you have?
The other one is a winnable, very bad child molestation in a cab. It's second in Judge Barry. There's a murder in front of us.
Okay.
That one, my client's been out, so it's fun with that. But we've been second forever. I have it's kind of now like kind of not where client, it's one of those like weird situations, but actually makes sense if you hear the family member. So he basically like lives with his godmother.
Okay.
Because he lives with his best friend's mom and is really very close with his god sister and god sister's friend from school
has a really rough childhood and rough mom. She kind of comes over, mom was in a difficult situation.
Mhm.
Friend makes an outcry, bad, rape,
Yeah.
exile, all this stuff. And he's like, gives this interview, he's like, I can do this, like, he turns himself in. But they confront him and they're like, hey man, I want to play this. And he's like, you know what, like, listen, you have your DNA. And he's like, what? And he's like, how are you going to explain this? Like, when you have your DNA. He's like, you know what, I could not explain it. You're right, I can't. And obviously the DNA comes back. Like, it's great. I'm like, this is great. But I have the witness is the girl who's basically the same age, was also given up forensics, says absolutely nothing happened, nothing would have happened to her. She was with the girl the whole time.
How old is your client?
Like, this is the problem. He's like 28 when it happened. He's hanging out with 14-year-olds. Not a good look, but not illegal.
Any like delays or anything? Not really, okay.
I mean, about a week or two. The biggest problem in the state's case is mom of victims. It's
Okay.
crazy. The delay has been victim had experience or victim exhibited ideations, like when we were getting ready for trial last time and the state 1013 her and mom like got in kind of a fight with the mom is also during admitted to defects that she tried to put a hit on my client. Like it's bonkers.
That's nuts.
Yeah, it's nuts. Yeah. Like my client's mother is also like no one to fuck with. Like her son's in prison for a very serious like armed robbery case and other time like I went to their house to like talk to them and like she's no one to screw around. She's like, someone shot him out, I'm gonna fuck them up. I'm like, hey, like yeah. And the thing is he's like kind of like weird. He's like a very chill guy, but like he's got all these views like at this skating rink and like these games like my dad was a DJ at skating rink and he died when he was very little. So I was skating like, oh, I understand. That's a great story. Like heartstrings. Like it's gonna be. I think we should win this case, but like I also don't like prepping two big trauma stations at a time.
Right. Reasonable.
Yeah. Because I lost one in February at like
What county?
Henry, which is where my office is. Like, client says, I'm not putting together something I didn't do.
What was the offer?
They were gonna do a downward deviation of 3 victims. Boy, 2 girls. Allegations over a 10-year period.
Yeah.
The state would give me a downward deviation, so like between like 12 and 15.
Oh my God.
Yeah, I negotiate like I'm cutting deals like boom, 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 boom. And I got 6 not guilties, but they said guilty 7 times, so he got life so 45.
Okay.
Yeah.
But it could have been worse.
Could have been way worse, yeah.
Yeah, absolutely. And how old is he?
He's 60. It was always gonna be an all or nothing type case.
Yeah.
It sucked because I got to know his wife and mother-in-law came to my office every month. I watched his kids grow up. Like I met his kids in school.
Right.
They're like driving. It was
it was
tough.
All right, let's get clear on a couple of these. For Mr. Garcia, I have found in the docket, Mr. Bennett always files these things.
Yes, I should have looked through my paperwork. I'm filling in for Mr. Bennett. And you did ask and I was not completely clear.
No, that's all right. Let me pull the docket back up.
Oh, is that what we're doing next? Oh, we're doing it, yeah. Okay. Oh, there's.
And I chatted with Mr. Peoples, and they are actively working on.
I'll give it to you, then I can forward you the.
Getting those reports.
Right, so there was a demand on the 12th for that. I dealt with the defects one, I didn't deal with this one, but it sounds like the lawyers have been talking about it? Okay.
Yes.
And what did Mr. Peoples tell you?
He said that he's going to get with one of their investigators to see if they can obtain those reports and talk with family and all that. good
So they weren't resisting production. They just,
From his information, he didn't see any of that, but I'm guessing, I believe his information is limited since,
right.
he's just basing it on
Okay.
their notes.
All right. You and your client can go.
Fantastic, thank you so much, you have a good afternoon.
You too. Mr. Brill, what's the latest with Mr. Schoenherr?
Yes, Your Honor, I think we are in a position where we are going to take a plea. I think we want to set it for a day next week because a little bit of work to do. I don't think we can take it today. The state was okay with that. But the framework of the deal is going to be mostly negotiated with a couple terms that are non-negotiable.
Okay.
Your Honor, it's probably going to be based on the cases that are in front of this one on my conflict letter, which you should have. If you don't, I'll make sure it's entered by the end of the day.
As in, it went in today, or it should have been in the docket a while ago?
We've had some staffing changes in my office, so I would imagine it's not filed in. I think, honestly, I think I'm like another attorney that may have announced I wasn't aware that this was a trial calendar, but thankfully I have Lacey's cell phone and I got that information through my own means.
Okay.
She let me know, but anyway, the conflict letter will be filed in the court by the end of business day.
Got it. And your conflicts were potential trials with older cases in?
I am reporting first to the cab in front of Judge Barry. We would be, I think we're second back up to a murder case that is specially assessed. So I don't anticipate being called out, but strange things have happened. And then we are back up in Gwinnett County in front of Judge Kaysen to a murder case that as of now is still going, but that case also may resolve as well. So
Okay.
you would be number 3rd on my list.
Got it. Unless you're first out, in which case you're not a backup.
First out.
Here, if this was going out on Monday, you're backup on these other places.
And that would be correct, that this is going to be a plea and we would be just asking if we could come and schedule it. Based on your email, I would just ask if my client can be on call because I won't be here at the call of the calendar on Monday.
Right.
But I think either Tuesday or Thursday would work for me. If
Okay.
if that would work for the court's accommodations.
It does. So it will be a plea next week. It's just a question of when.
Yes, sir.
All right.
And I should know, I'll know Monday.
Right.
If I'm trying those cases or not, I probably will know tomorrow.
Well, you'll know more certainly on Monday.
Yeah, absolutely.
Okay. Sounds good. Ms. Smith, anything you want to add on the Schoenherr case?
Nothing further. Thank you.
All right, we will figure out when next week this can happen.
Thank you. Name myself and my client.
You may.
How was jury duty, Your Honor?
It was today.
Oh.
And I ended up not being called in. My group wasn't called in. So that would have been an interesting day too, to have a courtroom full of like, hey, where's the judge? He's on the 7th floor. I actually about once a year get a summons, and I've worked it out with the jury clerk that if my group is called in, I'm ready to serve, but I can go about my business until they say, oh, you got to go to courtroom 4F. And then there I go.
See him Monday.
Yeah.
I'm in Barry too.
See you all later.
All right. Are you in Barry behind him?
I am in, I don't know what number I am on there, but I have a older case. I have two sets of older cases from Monday. I have my amended conflict letter to include this case is being filed right now, but I have my conflict letter that I already filed in Fayette in the cab that says that I've got to appear in Court Judge Ballard in Fayette on 2 older indicted cases Monday morning. They're running 2 judges in that courtroom trying to clear stuff out. So we were like to go in on something, and then if I clear there, then I'm supposed to go see Judge Barry in the cab.
Right, but if Judge Barry has a specially set murder that's likely to go, and then Mr. Brill is the one right behind it, you must be further down that list.
Here's my understanding of it. I've already been called on multiple short lists, and I've had to sit around before, so I don't know that the numbers. My experience with Judge Barry is that the case numbers not always, in fact, how they work. So
okay.
I'm touching that as well. Yes. Now, the Pendleton case, we do have a new plea negotiator.
Okay,
And
so is that what we're doing?
well, we're gonna do it. That's what
Okay.
we're gonna do.
Okay,
And he is under he has been told, make arrangements to be here.
Okay.
For
for the
this
plea.
weekend, for the plea.
Okay,
And per our last conversations, is higher than I wanted, but.
okay. Well, Mr. Peoples is new to it, but you and Ms. Williams and I have talked about it. And so it is higher than you want. You understand what we're working with here. So is this sort of like Mr. Brill's case where we need to check on you on Monday to figure out where you're going to be and when, and later in the week we take the plea?
I think that would work.
Because what I don't want to do is have Mr. Pendleton stuck in Atlanta waiting for a plea date. But I also know it's not just hopping in the car and he's here in 20 minutes. So he does need to make plans to be here.
Correct.
I can't give a specific date because I don't know your availability.
If everything, none of these cases that I have next week are, 1 week murder cases, or 2 week murder cases. And so, I think that if the court had availability on Thursday or Friday, Mr. Pendleton does have a cousin that he can stay with.
Okay.
In the metro area. So what doesn't have to be at a hotel.
Got it. So he should head here, be with the cousin, and then you'll be letting him know when late in the week are we getting together.
I'll do that.
All right. Well, I think he's on, so he can hear all this too.
And I'm available, Judge, if Ms. Williams is back next week, still available. Whatever the court needs.
Okay. All right. Mr. Pendleton, I know you've been on for a while. Did you hear any of what we just discussed?
Yes, Judge. It sounds like the plea will be at the end of next week due to my attorney's conflicts.
You heard it just
I need
right.
to go ahead and be in Atlanta to go ahead and take the plea.
Right. And so whether you come to Atlanta this weekend or Monday or Tuesday, I'll let you and Mr. Cook sort that out. But I would definitely be here by Tuesday. Just in case none of Mr. Cook's cases go out, then we could do the plea earlier in the week. No need to wait.
Understood.
All right. Thank you.
Thanks, sir. You can sign off, Mr. Pendleton.
Thank you.
Thank you, Judge.
You bet.
Always. Have you excused, Judge?
Yes, sir.
Thank you.
Ms. Cabrera, I see you back on the Zoom. Mr. Stone is here.
Hold on, let me turn this camera on. But yes, I'm here.
Okay. Did you want to come down here to handle it, or you said something about needing to talk with him?
Well, I have the information that I would need for a bond hearing, all the information that would matter to judge, I think. So I can do the bond hearing virtually and just sit still and complete it, and then I can go and visit with him later. His case is pretty new to the court right now.
Okay. Do we have another plea we can take right now? We're gonna need to break for lunch in a little bit. So I just wonder if there are people in the gallery we could move along. That would be great. All right, let's bring her up. So Ms. Cabrera, tell me your schedule. Do you want to try to knock out the bond hearing before lunch? Or if we just agree you're back on at 1:30, we can do it then? What works?
I would prefer to do it before lunch. I actually have a doctor's appointment at 1:40.
Okay, well, let's take Ms. Lawton's plea. Is this going to be something that moves maybe more quickly than Ms. Smart's plea did?
Oh, yeah.
Okay, then we'll do Ms. Lawton's plea and then we'll do the Stone bond hearing.
Thank you, Judge.
Is content looking like an afternoon after lunch type of
Yes.
thing?
Well, we were both told to hang on. Are we going to lose traction if we do it after lunch?
No, Judge, if I can have like 30 seconds with Mr. Rao, I just need to give him a little bit of an update, but I think we're good to go.
Okay, give him an update on his way to go get lunch. And if you could be back, Mr. Rao, at 1:30, that would be great. Thanks.
And just my last, for Garcia, they informed me of what's needed. As I explained to you, I am following up, I'm standing in. I will work on getting defense counsel what they need on Garcia.
Is Ms. Williams in a place where she's all right with emails? Because I'm happy to just manage this one via email.
Yes.
Okay. Should I include Mr. Bennett on the email? Is that the right person?
Yes.
Okay, so I'll take it from here.
Okay, Judge.
All right,
and I believe with that, that concludes all of this. Thank you, Judge. Always a pleasure.
Bye.
Sorry. I'll get a nap this weekend since there's no trial on Monday.
There'll be a trial, just not yours.
That's not mine. I was in trial last week.
All right, let's get on the record with Ms. Lawton. This is position 21 on our trial calendar. It's 25S, oh, it was 25SC,
Yes.
but there is a new indictment.
Yes.
It's 26SC 002690, and it's technically an accusation. So the charges against Ms. Lawton have changed. And part of our discussion will likely be a dismissal of the 25SC case. But the case for which we're taking a plea, Ms. Lawton, is 26SC 002690, which is brand new. 02690. Make sure it really exists. There it is. Charging you with cruelty to children in the first degree. Is that your understanding? Okay. Ms. Smith's going to put you under oath. She'll ask you some questions. You need to answer those truthfully and completely. And Ms. Lawton, you need to let your lawyer or me know if you have questions. Will you do that?
Yes.
All right. Ms. Smith?
Ms. Lawton, please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can lower your hand. Please state your true, correct, and legal name for the court.
Trinice Rashiba Lawton.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No.
And is there any medication that you would normally take that you haven't been given today?
No.
How old are you and how far have you gone in school?
28 in high school.
Did you finish high school?
Yes, high school diploma, I'm sorry.
Are you able to read, write, and understand the English language?
Yes.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes.
Have you had enough time to speak with your attorney about all of the facts and circumstances known to you regarding the charge and this accusation?
Yes.
Do you need more time to discuss your case with your attorney?
No.
And are you satisfied with her services?
Yes.
Counsel, are you satisfied that your client has a full understanding of this proceeding?
I am.
Also, do you waive the formal reading of the indictment and any and all defense in the indictment for the purposes of this plea?
Go ahead.
Ms. Lawton, do you remember being arrested on these charges?
Yes.
The state is unaware of any outstanding warrants related to these charges. Are you or your attorney aware of any outstanding warrants?
We are not. No.
Do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court a sentence of 7 years probation?
Yes.
Are you aware that the court does not have to accept that recommendation and that the court can sentence you to the maximum on this charge? Yes, on this charge.
Yes.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes.
I need to pause for a quick second. Ms. Lawton, are you from Miami?
Yes.
So have we worked through how probation is going to work? Yes, all the right heads are nodding. Okay, keep going.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special condition of probation without being subject to revocation for the balance of the sentence?
Yes.
Do you understand that this is a guilty plea, which is permanently recorded on your criminal history?
Yes.
Do you also understand that if you're charged with a crime in the future, that this plea may be used to enhance that sentencing, including on a federal case?
Yes.
Do you understand that if you're currently on probation or parole, that your probation or parole may be revoked based on you entering this guilty plea today?
Yes.
Are you a United States citizen?
Yes.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be following a conviction from a trial? For example, your guilty plea may affect your right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, or the ability to obtain employment.
Yes.
Do you also understand that by pleading guilty to a felony, you cannot use, receive, possess, transport, or own a firearm, and that if you did, you could be charged with another felony offense?
Yes.
Are you asking to be treated as a first offender under the provisions of the First Offender Act?
Yes.
Have you ever pleaded guilty or nolo contendere to, or ever been convicted of a felony in the state of Georgia or any other jurisdiction?
No.
Have you ever been sentenced for any crime, felony, or misdemeanor under the First Offender Act?
No.
Has your lawyer explained what the First Offender Act is to you?
Yes.
Do you understand that if you violate the terms of your first offender sentence or commit a new offense while on first offender probation, your first offender status could be revoked, you could be adjudicated guilty, and you could be resentenced up to the maximum sentence for the charge in this accusation?
Yes.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering this plea of guilty?
Yes.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to see and hear the witnesses called to testify against you, the right to the assistance of counsel, either hired by you or court appointed if you cannot afford an attorney, the right to the presumption of innocence, which means that the state must prove beyond a reasonable doubt that you're guilty of these charges, the right to testify on your own behalf or remain silent, the right to present other evidence of your own and call your own witnesses, and the right to appeal if convicted of these charges after a trial.
Yes.
Counsel, are you satisfied that your client understands that these are the rights that they'll be waiving by entering this guilty plea?
I am.
Ms. Lawton, has anyone forced, threatened, or promised you anything to get you to enter into this guilty plea?
No.
As to indictment number 26 SC 002690, how do you plead to count 1, cruelty to children in the first degree?
I'm pleading guilty to my best interest.
Are you pleading guilty because you have decided that it is in your best interest to do so?
Yes.
And are you aware that even if you do not admit guilt, this is a plea of guilty and places you in the same position as if you were convicted by a jury?
Yes.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
Do you understand that you do not have a right to directly appeal from your guilty plea conviction? But if you believe that there's some type of error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal.
Yes.
Do you understand that that process must be completed within 30 days from today?
Yes.
Do you understand that you have only 4 years from today for a felony charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes.
Thank you. Your Honor, if this case were to proceed to trial, the state would show that on December 30th, 2021, officers with the South Fulton Police Department met with Ms. Zalea Wilson. First name is ZAYLAH, last name is Wilson, common spelling, who stated that her stepbrother's girlfriend, Ms. Trinice Lawton, the defendant in this case, posted a picture of her vagina on Instagram. When Ms. Wilson, the defendant in this case, she was 14 years old. When Ms. Wilson was 14 years old, she was dating Mr. Emmanuel Lowe, not knowing that her mother was dating Mr. Lowe's father. Ms. Wilson was sexually assaulted by another male and confided in Mr. Lowe about the attack. Ms. Wilson felt that something was not right in her vagina area after the attack and FaceTimed Mr. Lowe and asked him to see if he saw anything out of the ordinary. Mr. Wilson was not aware that Mr. Lowe took a screenshot of her vagina during that FaceTime call. And a couple years later, when Miss Wilson's mom married Mr. Lowe's dad, they had to end their relationship. Mr. Lowe did not take it well and blamed Miss Wilson's mother for not being able to continue his relationship with Miss Wilson. After some violent encounters between Miss Wilson's mother, Mr. Lowe and his sisters, Mr. Lowe sent the picture to his current girlfriend, Miss Lawton, who is the defendant in this case. Ms. Lawton posted the picture of Ms. Wilson on Instagram while ranting about Ms. Wilson to get back at Ms. Wilson's mom. Ms. Wilson stated she started receiving several friend requests from unknown males and received a text message from Ms. Lawson threatening her. Warrants were taken out for Ms. Lawson because of the actions of posting that picture on Instagram. She was later arrested, transported to jail, and charged accordingly. All of this occurred in Fulton County, Your Honor, and those are the facts of the case. Regarding the negotiated plea between the state and the defense in this case, we've agreed to 7 years probation for count 1. And for the special conditions of probation, the state is recommending that there is to be no contact between Ms. Wilson or her mom, including indirectly on social media or any other social media platform. We're also asking for the defendant to complete community service, I'll say 30, because I don't have the number here. And then also for the defendant to
How many hours?
30 hours
30,
of
okay.
community service. And also for the defendant to complete a moral recognition therapy course. And that is all from the state, Your Honor. Oh, also, I would just like to add that the state did reach out to the victim in this case. She's currently in boot camp, so she's not able to receive calls or call anyone. So we haven't had a chance to speak with her, but intend to update her at the earliest convenience.
Okay, I want to make sure I followed the fact pattern. Ms. Wilson, who's our victim,
Yes.
was dating a guy, and the guy's dad was dating Ms. Wilson's mom,
Yes,
and then they got married,
right.
and then that made them think, well, you guys are kind of brother and sister, even though biologically they weren't. And so that relationship had to end
That's correct.
by parental direction.
Yes.
Okay. And the guy who had this picture for understandable reasons, because Ms. Wilson sent it because of something bad that happened to her, he is related to Ms. Lawton in the sense that he later on became boyfriend, girlfriend with Ms. Lawton.
Correct.
Got it. Okay. Huh.
Judge, and part of that is also, I know Ms. Smith is just.
She's relaying what the police said.
I know.
and-
And I met with Ms. Williams in her office because we like diagrammed this out, and after.
You met with Ms. Wilson or with Ms. Lawton?
No, Ms. Williams, Michelle Williams.
Oh,
In her
prosecutor.
office,
Yes.
Because it's a very confusing set of facts here, and we had a diagram, and then when I circled back, I found out that our diagram was even wrong. So it's not Mr. Lowe Jr. was actually not a relationship in that way. He's actually a brother to Miss Lawton. So
Okay.
we wanted to make sure that gets.
So Mr. Lowe, who at one point in time was boyfriend of Ms. Wilson, is your brother?
Yes.
Okay, not your boyfriend?
No.
Okay. Didn't mean to misconstrue that. And really the focus here is your choice of posting that online, whether it came from your brother or boyfriend or your uncle. Putting something like that online is, of course, what got people understandably upset and is the problematic piece. So I didn't mean to create the wrong relationship between you and Mr. Lowe. And it's not changing how I think about the case. Again, it's the alarming part was posting something like that. All right, thank you for clearing that up. Let me find out from Ms. Harvey if she has criminal history information for you, Ms. Lawton.
Yes, Your Honor. 1 cycle out of Georgia and 2 cycles out of Florida. The last arrest was out of Florida, September 2nd, 2020 for battery, and that case was dismissed, Your Honor. Does not appear to have any felony convictions. And
Got it. Thank you. Ms. Wood?
Thank you, Judge. And I want to start out and let the court know that why this is an offered plea is Ms. Lawton has maintained. So when I went to review the material in the office with Ms. Williams, I did see the photo and I see that it's coming from an account that's associated with Ms. Lawton. She's maintaining that she actually was not the one that was posting it, but we understand based on the evidence how difficult it would be at trial.
Got it.
And so that is why it's going up as an offered plea in this case. I did speak with Ms. Williams about whether or not they were looking at any other people to charge in this case, and it's just the way the evidence came through. And so that's why she's here, and she does want to move forward. This is a case from 2021. She does live in Miami. Ms. Simpson was so gracious to work with us. We've already sent over all of the information, so we're hoping that will expedite the process, but she also understands she has to be here for a period of time until she gets permission. She's 28. She has a 7-year-old daughter. She's a high school graduate. She did study in trade school for medical assistance program, but she is currently working as a supervisor at a Dunkin' Donuts. Her district manager actually reached out to me with a very nice letter saying all these nice things about her. So I am confident she's going to be in model probationer. That's why I'm asking for first offender treatment for her, as well as a behavioral incentive date, Judge.
All right. Ms. Lawton, your 7-year-old, is you said a daughter?
Yes.
Does she stay with you?
But she's in between me and her father.
Okay, so she's got a place to be right now while you're here. Where will you stay in the Atlanta area until we can get your probation transferred down?
Currently staying, I just know my sister, it's close by.
Oh, I don't mean so much the address. Is it?
Yes, I'm here with my sister.
Okay, you've got a roof over your head where you can stay until this gets worked out?
Yes.
Okay, can you work at a Dunkin' Donuts up here while you're here? No? Okay. All right, do you have any questions about what we've discussed?
No.
Okay.
Everything is explanatory.
Well, Ms. Lawton, I'm accepting this as an offered plea. I understand why. I think you understand why, since it came through your account. It's hard to disassociate yourself with that, even if it was your brother or someone else who used your account. Shame on that person, and they've got some things they may owe you, but it's got your digital fingerprints on it that way. So I find there's a factual basis for your plea, and that your plea is knowing, meaning you've understood what we talked about. You just told me it was explained well, and voluntary. No one's forcing you to enter the plea. Are you all right, Ms. Lawton, if someone in my office electronically signs your name to this new accusation? Okay, we'll do that. Ms. Wood, can we sign for you?
Yes, Judge.
And Ms. Smith? Ms. Smith, is the state moving to dismiss or null pros 25 SC 007173? We'll take care of that. What that means, Ms. Lawton, is that the old case that had more serious charges, that's gone, dismissed. You're pleading to this, still a serious charge, but less serious. And that's what will be out there. I will sentence you as a first offender. Ms. Smith covered the risks and the benefits. I think you understand them. And I think you are very much an appropriate candidate for first offender. You do need to stay in Georgia until your probation gets transferred. I'm going to sentence you to 5 years of probation. Special condition of probation number 1 is no contact from you or your mom or anyone with directly associated with you with Ms. Wilson.
Okay.
Okay. You'll need to do 30 hours of community service and take what's called the MRT course. And probation will help you find that. It could be something you can do online. That's the moral recognition theory or treatment, MRT course. I'm going to set a behavioral incentive date of 2 years, given the age of this case. So May 29th of 2028, if you've done everything you needed to do and otherwise stay out of trouble, which doesn't seem hard for you to do, then this case can be closed early. If you've been struggling with things, then you've got a full 5 years probation.
Okay.
Ms. Smith, anything else on behalf of the state? Ms. Wood?
Just briefly, Judge. So I think the reaccusation, I think the language is going to be fine, but just out of an abundance of caution, when negotiating with Ms. McGillicuddy, Mr. Peoples, and Ms. Williams, it's our intent that this is not going to be a registry case.
And I'll make that clear as well. You are not to be subject to any of the special sex offender probation conditions, and I don't believe you need to register. That second piece is less my declaration and more what the law is, but I'm making clear on the record that probation shouldn't be thinking that you're someone who needs to register, and you're certainly not subject to all those restrictions on probation, okay?
Okay.
All right. In the actual sentence? Yep, I'll add that as a special condition of your probation. Okay, great. Good luck, Ms. Lawton.
Thank you, Judge. All right, Ms. Lawton. So you're going to just meet with Ms. Mohawk, okay? All right.
So, Ms. Cabrera, I've got about 8 minutes before I need to go. Do you think we can give this bond hearing good justice, or should we reset it because you've got a conflict?
No, I think we can. It's not brain surgery.
Well, let's bring Mr. Stone out, please.
Yeah, that's not brain surgery.
For those of you who are still here, you all are here for whom? Oh, well, we're about to do that. Excellent. And you all are here for Mr. Stone. She's got a big audience.
Tell the family for Mr. Stone. I was calling them and I sent the email to mom. I sent the text message to mom and I called mom, but her phone may be off if she's in the courtroom. So just let her know I was trying to reach her.
She's nodding her head.
Okay.
Okay, good. All right, Mr. Stone, come on up to the podium, please. Let's get on the record in your case, Mr. Stone. I gotta find that calendar. Here it is. 26 SC 000679. Mr. Stone, you are charged with multiple counts of aggravated assault and 1 firearm offense. And all we're going to do today is talk about bond. Your lawyer, Ms. Cabrera, who you can see on the screen there, screen in front of you. She was up in Cobb County for other court, but is joining us virtually. Ms. Smith, the prosecutor, seated right behind you. I'm gonna hear from both of them and I'll let you know what I'm gonna do, okay? Ms. Cabrera?
Yes, Judge. Mr. Stone is on the calendar. You've already listed his charges, but he's 25 years old. He does have a 2-year-old daughter, lifelong resident of Georgia. Before his arrest, he was living with his mother in Decatur. I believe he can go back there. He has 10 siblings, went to Cedar Grove High School until about the 10th grade. It's my understanding that while in high school, he was hit by an SUV. He suffered traumatic brain injury, has a learning disability that he was diagnosed with. And so, there's a host of things going on. His arrest was January of 2026. I think it was the 27th. He has probation out of the cab, but it looks like it's a misdemeanor that runs for about a year and should expire in July of 2026. He was working, he was painting, he was also looking for different jobs and kind of trying to be helpful to his mother. It's my understanding that mom may have her own like neurological things that she's dealing with. And so I believe that it's important for him to be there to be helpful to her. I would be asking that Your Honor grant him a bond, a reasonable bond that would allow him to be home to help his mother and also to be there to support his daughter and work while we figure out how this case works. I would also ask if Your Honor would even consider an ankle monitor, curfew, things like that, whatever needs to be built around him for the court to feel comfortable about a release for him.
Got it. Okay. Thank you. Mr. Stone, were you able to follow all that? Yes?
Yes, Your Honor.
Okay, great. Where's your daughter staying now?
She stay with my baby mama.
Okay, with your daughter's mom. Go ahead.
But I began.
Okay. All right. Ms. Smith.
Yes, Judge, in this case, the state will be asking for no bond. The biggest issue that the state has in this case is that we believe that the defendant may be a danger to the community. This incident happened back in 2023, so it's not recent. However, with every ag assault charge that we have here, someone was either shot at or shot, and the state does believe that that is very concerning. The defendant does have an open case out in DeKalb, but it's my understanding that that happened after this because this incident happened in 2023. So we're not making an argument that he's a risk of reoffending. However, the biggest thing is that this event happened on a public highway and where other people were involved, where a lot of people were shot at or shot. And the state does believe that if the defendant is out based on the facts and circumstances of the case, that he may pose a danger to the community or intimidate the witnesses that are involved in this case. It is 4 to 5 witnesses. The state did attempt to reach out to those witnesses. I'm not sure if they are related or have any relations, but we weren't able to reach them. But we don't have a statement from the victims in this case, but based on the facts and circumstances, the state does believe that the defendant may pose a danger to the community and would ask for no bonds to be set in this case.
Okay, hold on, Mr. Stone. So the indictment is of 2 Stones.
Yes.
Brothers?
Correct. I'm assuming.
Okay, Ms. Cabrera is confirming brothers. Do you know from your review of the evidence that you have, Ms. Smith, if there were 2 guns involved or in truth, there's only one shooter and someone else is either the driver or is somehow an accomplice in the case?
Yes, Judge. From my understanding of the case is that both co-defendants had guns. So shooting in the direction where people getting shot could be attributed to both of them, but we don't know which one.
Okay, well, someone got hit according to this. Mr. Venable was hit, other people were shot at.
That's correct.
And your understanding is that both of the Stones were firing guns?
Correct.
Okay, all right. What I don't want you to do, Mr. Stone, is talk about the case. That'll make your lawyer real upset. So don't say I didn't do it or they shot first or I wasn't driving. So don't talk about the case. Is there something you want to tell me?
I had one to read my letter.
What's your letter about? Life? Where's your letter?
In my sock.
Okay. Ms. Cabrera, do you have more that you want to add?
No, I would just, in light of what the state's concern is about him being a danger to the community, I would ask that Your Honor consider again, ankle monitor, some form of curfew, and it can be a tight curfew. It looks like when he was working with family to paint houses, and so perhaps that's something that he can continue to do on a very kind of strict schedule, so that he's
Okay.
not out and about, that he is just at home.
Got it. So the co-defendant is in bench warrant status. He didn't come to court, so we're looking for him. There's a warrant for him. Let me ask Ms. Harvey to share criminal history information about Mr. Stone, please.
Yes, Your Honor. Four adult cycles. There is an arrest out of DeKalb County from 2019 for 5 counts of entering auto. There was no disposition listed for that case. He does appear to be on misdemeanor probation out of DeKalb County for willful obstruction of a law enforcement officer, sentenced June 9, 2025. And nothing further.
Okay. All right. Why don't we do this? First, Mom, would Mr. Stone be staying with you if he received a bond? Okay, that's a place where he can stay. All right. So Ms. Cabrera, I need you to get to Ms. Nelson what that address is. And then I need you, Mr. Stone, to get your letter to Deputy Gordon. I will read that. I got to bring our hearing to a close now that I've heard from your lawyer and the prosecutor. So I'm going to look at your letter. We'll get that address from your mom as to where you're staying, and then I'll make a decision and enter an order. And your lawyer will let your mom know, and you know what the answer is. If I set a bond, there's definitely going to be a curfew and an ankle monitor, where you're going to be at home unless you're working or medical appointments, those kinds of things. If I don't set a bond, Ms. Cabrera is going to keep your case moving along. It's ready to move. The evidence is out there, is old. The fact that you don't have something serious going on during those 2.5 years since it happened is a good thing for you. Says you've been staying out of trouble since whatever this serious situation was. Okay?
Okay.
All right. So Deputy Gore, if you can get that letter from him, we are all set. Thank you. We're going to reconvene at 1:30 for the rest of the calendars.
All right, thank you, Judge. And if Mr. Stone's mom can just, she has my cell phone number. She could just text me her address. I'll make sure that Ms. Nelson gets it.
Yeah, if you'll send your address to Ms. Cabrera, you've got her phone number. Ms. Cabrera will get it on, okay, to my staff. All right, thanks, everyone.
Thank you, Judge.
was talking. I don't know.
All right, we don't have a prosecutor right now, so now's the time if you want to work things out. No, but for your client, you represent Pontius Thomas.
Yes.
And I saw the email, I don't know if you're recent to the case, I think you are.
I was the originating attorney for
Way-
the plea.
way back when.
Way back in, 23?
Okay, but you're new to the revocation piece.
Correct.
I
spoke with them a couple weeks ago. They were supposed to have Mr. Green come see me.
Hmm.
And then I didn't hear anything. Then
Yeah.
I realized, he's here before you today.
Okay.
So that's why I apologize for sending it last minute.
No, that's all right. Before we knew you were sticking with it, I had a brief conversation with Ms. Rios, who indicated it seemed like a workoutable one, not speaking on your behalf and not binding anyone to anything. Ms. Smith will be here soon. That's the prosecutor who's handling it. Is it something that you're keeping? And if so, is it resolvable today, do you think? Or it depends what Ms. Smith tells you?
I need a little time because apparently the revocation is based on the new case, and I don't know anything about the new case.
Plural?
Plural.
Okay.
Two of them are with Judge Schwab, and there's an unindicted.
Okay.
So I saw 26 PI when I was looking this up, so I figured at least one new case.
Mm-hmm.
He may have an old 23 that never got resolved, and this one did.
He's a prolific guy.
I think it's a gun charge.
That's
Maybe that's one of the now indicted with Judge Schwall.
not both of the cases with Judge Schwab are coming back as CPC.
Yeah, but it could have been was it a 23 indictment or 23 incident?
I think he should have 223 indictments.
He
And
had,
then
the
225.
case that's on the calendar is a 23.
I know
Right,
that.
but
He
that's,
has a second one that's a 22.
Maybe it's the
But
20.
that case, he's also on probation.
Okay, because he was thinking we resolved everything in 23, but we left one unresolved. Maybe at the time it was unindicted, so now it probably is a 25.
I'm looking him up here.
Charge.
He is, lots of cases, trying to get into the 20s. So there was a 22 SC you handled in front of Judge Whitaker, sawed-off shotgun, some other stuff.
Yes, I remember.
Then he had a revocation on that. There is a 23, that's this case that you handled, so with me. And then some probation warrants. Then he's got 2 indicted 25 SCs with Judge Schwall. And then this 26 PI, unindicted drugs, gun, et cetera. Probably what should happen, but you should talk with him, is that this revocation is part of the basis of the revocation, the new indictments with Judge Schwall. Our lowercase p policy has been for the last probably 5 years, if one of the bases for the revocation is a new indicted Fulton County case, not Clayton nor Cobb, the judge who's got the new indicted case handles the revocation. So I don't transfer this case, it'll say McBurney on it, but the revocation would go to Judge Schwall, so you've got one judge, one resolution. It's really how we ought to handle this. I will explain that to Mr. Thomas. Do I need to explain to him that you also need to be retained?
I just talked to him about working out a global.
Okay.
Would be that effect.
Yeah.
Either here or with Judge Schwall.
It would be with Judge Schwall.
Get it all handled together.
Okay.
And he's gonna do his best. I told him I'm fiercely loyal to my clients.
Sure.
Sometimes
He has representation, so he's not stuck in Judge Schwartz, got the public defender. But if he can come up through family and friends and lottery winnings, your services, you can file an entry in those other ones.
I probably will, Judge, just because
Because you stick with your clients.
I've been with him for years.
Okay, well, he's given lots of years, as I've seen in here. So maybe he's got the repeat customer discount. Do you want me to bring him to the door to let him know that's the plan, or do you want to tell him?
You could just say it to him, because I did explain that's what I was asking.
Okay.
for.
If you can bring Mr. Thomas to the door. And then are we gonna do Mr. Compton next?
So,
We waited too long?
no, we who we need. He had requested to be able to have a word with her, but during lunch, Deputy Gordon was short-staffed, so.
Oh, so there's someone online?
So she ended up coming in person.
Is that who's in the corner? Okay. Hey, are you Mr. Thomas? Hey, I'm Judge McBurney. We met a long time ago, when you took a plea, with me, and with Mr. Wright. And we were just working through, you have a complex landscape. You have 2 indicted cases with Judge Schwall. You also have an unindicted case. When that gets indicted, if the state decides to go forward with it, that'll go to Judge Schwall as well. So you're gonna have 3 cases there. The primary basis for the revocation that you'd be doing with me are those cases with Judge Schwall, which means it's a whole lot more efficient for you and whatever lawyer you have, whether it's Mr. Wright, you have Ms. Colangelo right now with Judge Schwall, to do all that together. In fact, our court has a policy of transferring the revocation to the judge who has the new cases. So I'm gonna move your revocation over to Judge Schwall, and either you and Mr. Wright or you and Ms. Colangelo, or maybe the 3 of you, will come up with what we call a global resolution that will resolve everything. It may be a little messy because you keep getting arrested for having drugs or guns. Doesn't mean you did it, but you get arrested for it. And that's gonna come around either through the revocation or these pleas. But I wanted you to know, 1, why you were brought over here today, because I didn't know about the new stuff, that they'd been indicted. And so I said, let's handle the revocation. Once I did, I started talking with your potential lawyer, Mr. Wright. He said, yeah, let's get it all under one roof. And that roof's gonna say Schwall on it, not McBurney. Okay, does that make sense? All right, you'll be in touch?
Yes, I'll come see you, bro. And Judge, thank you very much.
You bet, appreciate you coming all the way down here.
Oh, not a problem.
All right.
Take care. May I leave?
Yes, sir. So, hello, Ms. Smith.
Hi, Judge.
Do we want to do Mr. Compton now?
Let's bring him out. I think that's probably a okay idea. I mean, I'm still.
You checking with your consultant? Okay, we're gonna see what Mr. Compton wants to do. Do we know if, Ms. Dickens is up yet?
I think she is.
Okay. There are not a lot of attorneys still here. That doesn't bode well for the trial calendar. Hey, Mr. Compton, come on up to the podium, please. So I'm checking in with you to see what you want to do. I know there's been a lot going on, a lot of moving parts. Ms. Wood has been working with you, and I know she's been leaning on the prosecutor pretty hard to see if there is something better than life or life without parole, which is sort of the only sentence you get if you were found guilty of the more serious charges here. And then Ms. Wood shared with me that there's someone you wanted to chat with. I think you got a chance to interact real briefly. So I'm just checking your pulse to see, do you want to go forward and sort this case out today? Or do you want to keep your case on the trial calendar? We won't be able to try it next week because Ms. Wood is on leave. And if your answer is, Judge, it's trial, I also want to talk a little bit about representation, because Ms. Wood said at one point you were thinking about bringing someone on board, which is your right, assuming you can afford another lawyer. So tell me where you are right now.
I don't really know for real. Like, I don't want to take a plea, but I'm thinking about it. Like,
Okay.
I want to be able to talk to the person.
Oh, did you guys not get to talk yet?
Nah, I ain't
Oh,
talking.
oh, that's right, because you were tied up during lunch. Okay. If you two talk today, you think you'd be in a position to sort things? I'm not rushing you. I want to be real clear about that. And if you're saying, Judge, I need days and not some number of hours, we got cut out around 4 today, then that young lady should come see you at the jail or get you on the phone. I don't know that the state's going to keep this offer open. That's where there's a clock ticking. I don't know what that offer is because judges don't get in the middle of negotiations. I do know that it is significantly better than life, but I bet it's a lot more than 0. So you're having to make a difficult situation, difficult decision here. And so if you say it's not happening today, it's not happening today. But we're going to get on the record. If you're walking away from an offer that expires today, I want that on the record so you don't come back in a week saying, wait, what about that deal? Because you'll know the deal was for today. You'd like to talk to that young lady?
Yes, I would like to talk to her.
Okay, tell me who that person is in your life.
Like my everything.
Your everything. That's a great word for it. Okay. I don't think that can happen right this second, but we will make that happen in a little bit. I just got to coordinate with Deputy Gordon. You know, we've got a few other people back there. So I'm just going to map out what we're doing this afternoon. And assuming Deputy Gordon can make it happen, you guys can have a conversation. You're going to be separated. I mean, you'd be there and she'd be in the gallery. It'd be private. None of the lawyers would be in here. Deputy would be in here, of course. It wouldn't be super long either. It's not you guys can talk for 30 minutes. Okay? All right. Anything you want your lawyer to tell her to be thinking about before you come out here? Like, hey, this is what the offer is, or anything like that? Or this is a conversation you're having with your everything?
I don't know. I don't know. Like, I just want.
Okay, you want to bounce some thoughts off her?
Yeah, I really ain't really processing myself yet. Like, I'm still thinking about it myself.
Okay, well, why don't I get brought into the loop? What is the state's offer right now?
Yes, Judge. Count 1, malice murder would be amended to voluntary manslaughter. The sentence recommendation would be to the court 15 years to serve. That would be parolable time as opposed to day-for-day time on any sentence on a malice murder charge. Count 2, felony murder would vacate by operation of law. Count 3, aggravated assault would merge into count 1. Count 4, possession of a firearm during the commission of a felony would be 5 years probated to run consecutive to count 1. So that would be a total sentence of 20 years to serve 15, with the balance probated. And those 15 years in custody would be parolable time.
Okay, and Mr. Compton will get credit for the well over half year he's already served. Is Mr. Compton, based on your review of his criminal history, a recidivist?
No, Your Honor. He has no prior felony conviction.
Got it. All right. So, Mr. Compton, just so you hear from me, the lay of the land. If you were to go to trial, and if you were to be found guilty, I'm not saying you would be, jury would hear all the evidence, but if they found you guilty of all these charges, the lowest sentence I could give you is life. Life is 30 years in custody before you're eligible for parole. So 30 in. Also, a legal sentence would be life without parole. I don't know enough about the case to know what the state would be advocating for if you were found guilty, but that's a possible sentence, is life without parole. That means what it says. That means you never, ever get out. So worst option, life without parole. Intermediate, not particularly great option, life, which is 30 years before you're eligible for parole. The state today is willing to reduce the murder to voluntary. And instead of offering what they typically offer in these cases, which is 20, that's the max for voluntary. That's usually where the state goes. Mr. Rao is offering the 15 years to serve, followed by 5 on probation. I don't mean to make 15 sound small. It's not. That's a lot of time. But it's half of 30, and it's infinitely less than life without parole. You should think about it. I'm gonna arrange for you to talk with the young lady in the back. But before you leave here today, we're gonna get on the record. I'll get that offer on the record, and you're gonna let me know, I want it, let's take the plea. No, thank you. I'm gonna go to trial. Just trial won't be on Monday. Originally, the plan was to do trial on Monday, but lawyers aren't available. We'll move you to the next calendar. So trial will be soon, but that offer of 15 goes away. Understand?
Understand.
All right, we'll get you back out here to talk with.
I got a question.
Yeah.
I can use my first offender. Like, can my first offender be used?
So I think with voluntary, you can do first offender. I don't know that the state is advocating for that, but ultimately it's my call. I haven't had someone ask about it with a situation like this, but I'll have to look. It may be the legal answer is no, you can't. I don't know with voluntary manslaughter if you can. There's certain crimes where I'm not permitted to give someone first offender. Okay, I'll figure that out while you are back there thinking through things. Any other questions?
No, sir.
All right, we'll see you in a little bit.
And Judge, just for the record, we would be asking if the defendant wishes to take a plea today, that the court would hold sentencing until an opportunity is provided for the victim's family to be heard.
Got it. So, Mr. Compton, should you decide you want to move forward with this, we would do about 95% of the process. I would accept your plea, and I'd let you know, based on what I've heard, I think it's a reasonable negotiation. Just like you would have an absolute right to share with me anything you want to about, Judge, I think you should go with the 15, or it should be less, or you have a right to speak at your own sentencing. Members of the deceased family also have a right to be heard. And this has been moving quickly, and I think the state hasn't been able to get one or more of the members of the deceased family available. They might be on Zoom, they might be in person, but they have a right to be heard too. So we wouldn't sign on the dotted line until they can either be present here in court or on Zoom, but you'd be here for both parts of those. But if you say you want it, you could lock in that offer. Because if you don't take the plea today, like I said, that offer goes away. If you say yes, the state can't change their mind later on. They've locked in the 15 years. Does that make sense? Yes?
Yes.
Okay, we'll bring you out in a little bit.
Thank you, Judge.
You're welcome.
It's a real.
Lord.
Yeah.
He's really got something to say back there.
Miss Lawton was a plea. All right, so I think the trial calendar we've covered for today, other than Mr. Compton. Did you have any, I know I haven't sent out the email yet about what needs to report on Monday, but there are no cases left to sort out today from the trial calendar? Okay, all right. Then, did Mr. Battle ever make it here? Yes, he did. Okay, so we'll do his bond hearing in a little bit. And then we need to bring Ms. Dickens out. Have you met her yet?
He's still downstairs.
Oh, okay. Oh, really? Is it only our people up here?
8C.
Who's in 8C?
Oh, Barbara. Yeah.
Well, like what judge is in there?
Barbara.
Handling her own cases? That's so strange. All right, bless her soul. I'll go in there and say hey in a minute. So then we have some revocations we can do. So Ms. Rios, what would you like to do?
Let's do Mr. McDuffie. I also have a letter from Mr. McDuffie if you would like me to read. You know.
Okay.
His letter. Judge, really quick, before this revocation, Ms. Rios, did we ever hear from Ms. McGee Russell?
Yeah, when she came and we set her for her,
I did. I talked to her. She and I spoke. She was late, but she was here with her grandfather. That's who got her here.
Okay.
All right, give me 1 second. I got your letter. That'll be part of our discussion.
Thank you.
You're welcome.
Are you getting ready to get out of here, Mr. McBurney?
You're getting ready to get out of here, or I'm getting ready to get? Where would I go?
Everybody talking about you retiring. Is that true? I mean,
wow. I don't know who everybody is. I don't know what they know. I'm here for you today, so we're going to see what we do. Let me make.
Congratulations, you know.
Okay, it's not that kind of retirement. I'm going to be doing a little bit of different kind of work in the court. You married?
No, sir.
Well, then I'm not going to bump into you over the next couple of years. All right. Ms. Rivers, good afternoon. You ready to go?
Yes, I am. Good afternoon.
Good afternoon. This is position 2 from our It's labeled an inquiry calendar. Joshua McDuffie, 23 SC 190499. And Mr. McDuffie is here to work through a revocation matter. He's represented by Ms. Rios, and Ms. Smith is handling things for the state. Mr. McDuffie, you have 1 year and almost 9 months left on your probation. 1 year, 9 months. This is your third revocation. You've been revoked twice before because you had moved without giving notice to probation. This time around, your paperwork says that you got arrested for criminal trespass in DeKalb right after New Year, so early 2026. Your probation officer saw you drinking from a Patron bottle. That's some pretty serious drinking. Yeesh, straight from the bottle. And you hadn't been doing super with community service. So 2 technical violations, the drinking straight from the bottle and the community service, and then new charges. It's criminal trespass, not the end of the world, but still something you need to not be getting mixed up in. Ms. Rios, is Mr. McDuffie admitting to the allegations that he was arrested and then had the other 2 situations? Okay. And what are you recommending we do as a result of that?
Yes, sir. I'm recommending that we revoke 19 days.
19.
Yes.
That's as long as he's been in?
Yes, Your Honor.
Okay.
And I'm going to explain what happened. So he was reporting in DeKalb, he
Mhm.
said, and he said I think it was confusion where they thought he was supposed to be reporting in full. And initially he didn't. When the first time we had a revocation, he didn't even know about one of the probation officers. But since then, he said he has been doing good reporting in DeKalb.
Not Fulton.
You were reporting in DeKalb now. That's
Yeah.
where you've been reporting.
Well,
Fulton now.
wherever he's been reporting, it's been fine. The allegations aren't you disappeared on us or you moved or we can't find you. It's you got arrested for criminal trespass, you're drinking out of a Patron bottle, and you haven't done your community service.
So the drinking out of the Patron bottle, his grandmother just died. And so that was the grandmother I believe I spoke to too. So she passed away. That also made him homeless. That explains why he was sleeping.
You've been staying with your grandmother.
No, I was staying with her.
Right. And when she passed, you didn't have a place to stay anymore.
I was sleeping in front of the bank. And I think they really took me that night because I was in front of the bank.
Oh, this was the trespassing?
Yeah.
Okay.
And not only that, I did 2 hours of community service. I'm gonna get back on it.
You did 2 out of 80. So 1/40th.
I'm gonna get it done, I promise. Other than that,
He's been also going to go back to the community service board and they're treating him for his mental health and his seizures and things like that. He does have an address that he gave me at the one at the 1435 Fox Hall. So he has 2 grandmothers that he was going back. The one he was mainly staying with, that's the one who passed away. But these are technical violations, Your Honor. I think we have a good.
I got thrown off.
Hold on. Let Ms. Rios finish. You'll get a chance. Don't step on
He's
it.
been going through a lot with the loss of his grandmother. With that, and then the fact that he hasn't. The only new case that he picked up, it was because, and I believe that case is resolved. I believe it resolved.
Yeah.
According to him, it was thrown out. I wasn't able to verify that, but it was just because he had nowhere else to go. And so that was just pretty much criminalizing him not having a place to stay. But since then, he said he can stay at this address and he understands that he would have to in person report and tool since his address is a little hazy that he'll go in person and report. And he has no problem doing that. He has been doing that.
I'm sorry.
No,
I'm so sorry.
Yep. You're gonna get another violation here, interrupting your lawyer, so watch out.
Mr. McBurney. Sorry, Ms. Williams.
And you give him the letter, he has.
I got the letter. I'm gonna look at it.
Oh, I'm gonna let you finish first.
Good.
So we're just asking for the 19 days. I remember Mr. McDuffie. He's a good guy. He's always pleasant when I see him. I think he just has a situation where he falls on hard times and he's trying to do right. And him staying in jail any further, he's not going to get his mental health services. And so I'm asking just for the time served. I know the state probation was asking for 3 months, but we're hoping that you would just let him go.
Okay. I'm sorry about your loss. That's always difficult. I'm a little confused about which county you're going to be living in. And you can live in any county you want in Georgia, but probation needs to know. And I heard, let me finish. I heard Ms. Rios say Community Service Board, CSB. That means not Fulton, because we don't have a CSB.
DeKalb.
DeKalb. So you'll be living in DeKalb?
The 1445 address.
Okay, and that's your other grandmother?
That's the same address that I have been staying at, but I've been going there. I've been meeting with him 2 times a month. When I got,
meaning Mr. Crank?
You know, when I first took probation, when you gave it to me, I was going through DeKalb. I had a probation officer named Ms. Butler and a probation named Ms. Smith. And I mean, I was doing what I was supposed to do, reporting to Conyers.
So what happened?
I kept getting a violation from here because I had never met Mr. Crank. Then I finally, when I got out last time, I said, I'm going to do whatever
meet this guy.
It takes to be on top of probation. And my grandma passed. And that's what just threw me off. So I just want to get back out there and keep up with with trying to get my disability going. I got my medications and everything and my appointment. I got everything set up. I got my social security card, my birth certificate, my ID and everything downstairs. So I just want to get out and just get back to what they're doing the right thing. You know what I mean?
Tell me what you take medication for.
Bipolar, schizophrenia, and manic depression.
Okay, those are important medicines to take.
And epilepsy. So I got back on my appointments with Grady. So I'm set up for everything. And I got appointments coming up next week. So this was really like a blessing to come to court. But I promise you and assure you that I get that community service done. And y'all won't see me here because I just got a contact number from Ms. Rio. So I'll let her know when I'm actually at the probation office. You know, because I'm meeting with them 2 times a month.
Okay.
You know what I mean?
Well, and again, Mr. Crank didn't say you didn't meet with him. That's not what he was concerned
But
with.
that was the first 2 revocations.
I could, but
Yeah,
we're past
it was
those.
the non-report. And I'm like, I'm putting in the cab.
Well,
And I finally met him and we're on good terms.
you fixed it, which is
sir.
good.
And I promise not to be sleeping in front of the bank and drinking Patron.
Okay.
I promise.
It's a lot of promises. Ms. Simpson, I'm a little confused about where Mr. McDuffie is supposed to report, because he rattled off the names of a couple probation officers in DeKalb, and yet here's Fulton saying,
Transferred his case to DeKalb, at one point, so yes, that is correct, he was being supervised in DeKalb.
Can I ask?
you cannot yet.
Okay.
And
Sorry,
then, at some point, he, there was a transfer request that sent it back to us.
And would that have been, can you tell in your system if that was initiated by Mr. McDuffie or by DeKalb saying, we don't want to supervise this guy anymore? Or?
The only way they would have sent it back to us, is either 1, because of the warrant,
Yeah,
or 2, he requested.
okay. All right. But if it turns out that Mr. McDuffie is living at this 1445 address that's in DeKalb County, will he continue to work with Mr. Crank or,
So the 1445 address, is coming up actually as Fulton.
Oh.
Maybe where the confusion.
that could be part of it?
It's not to cut y'all, it's in Atlanta. It's like at the gas station, the cab pull up at this one and right across the street, Fulton County pull up.
Okay.
Then at one of the gas stations, Atlanta pull up and the cab. But if you call the police at my grandma's house, the cab county come. You see what I'm saying? So it's just, and the probation officer I had in the cab, she left. She said, I ain't gonna be a probation officer again, and gave me a number to another lady.
Okay.
So I went to the Fulton County office, not to cut you off.
Yep.
Can I talk?
You can.
Okay. I went there to Fulton County and I explained to the lady, I said, ma'am, I just got out of Fulton County. And I said, I don't want to do that again. And she said, I'm assuring you. She said, you see who you talking to? Do you see who I'm talking to? I'm going to make sure that you report in DeKalb County. So I've been doing everything, you know what I mean? I think they just backed up and a lot of overwhelmed because it's so crowded.
They have a
be
lot
so
of work.
crowded down at the probation office, but I don't care that they be crowded. I'm gonna still continue to do what I'm supposed to do to finish this probation.
Okay. But it sounds like the address where you say you're going to be staying is, at least in this system that matters, which is probation system, it shows as a Fulton address.
Okay.
So it doesn't matter who reports, if you call 911, whether it's the Okmulgee County Police, that address says Fulton County in their database. So you keep working with Mr. Crank in the office on Memorial Drive. Ms. Smith, what is the state's recommendation in Mr. McDuffie's case?
Yes, Judge, in this case, the state is going to follow probation's recommendation, which is to revoke 3 months in this case and to reinstate the balance upon the defendant entering and completing the MADRC program.
So 3-month revocation, obviously credit for time served, and then add the condition that Mr. McDuffie do the day reporting center.
Yes, Judge.
Okay. And it sounds like, Ms. Simpson, that's your recommendation, because that's what Ms. Smith said it was. Okay. What's the origin of the day reporting center idea?
So Officer Frank was, he was present with the incident that is on the petition, where Mr. McDuffie was drunk. He did correctly, he contacted Officer Frank, and said, hey, I'm in a bad headspace and need to come meet me.
Okay.
And so, I take credit in that he did that.
Yeah.
My grandma was
Officer Frank, was
Man,
there to
alcohol.
speak with them, and I believe it was 11 police that also pulled up because they saw him standing in front of the gas station drinking. Model. But after Officer Frank spoke with them, the officers had determined they weren't going to arrest him, given he had some mental health going on. And so he was just more concerned with making sure that this isn't the beginning of a downward spiral.
Okay. So, Mr. McDuffie, let me talk to you a little bit about the day reporting center. I think it's something you should be open to. It is a program, it's a series of programs where you'd be going during the week, so not Saturdays and Sundays, but each day you'd be showing up. You'll get a little substance abuse treatment, you get some job preparedness training, other kind of trainings, and sort of have some resources that you can check in with. It's not housing, but it is certainly something to fill up some of your hours, where when you graduate from that program, you're much more likely to be lined up for, hey, here's work he could do, or if you qualify for disability, like you said, at least you've got some new tools to help you manage stress in a different way. Because it sounds like when the grief of losing your grandmother caused you to make some choices where you were in a bad place. And the day reporting center can help with that. I think that makes some sense. It's some good structure. And it gets you plugging in very regularly. Like, hey, we know he's okay because he's here today and he's here the next day. If you do well, you move through the program pretty quickly, you're done, and you're on your way. Does that make sense?
I mean, I just don't want to put too much on me. I'm already doing probation, community service, and I got doctor's appointments. I don't want to.
How often do you go to the doctor?
Well, almost all through the week, because I go to the Grady and I go to community service board, and I'm doing community service. I got 80 hours to knock out.
All right, I'm not worried about the community service. While you're in the day reporting center, you don't need to worry about the community service, or that could be part of what you do through the day reporting center.
That's what it's every day?
It is Monday through Friday, but let me finish. It's never going to interfere with medical appointments. If you've got a documented doctor's appointment, first of all, it's not all that far from Grady, so that's convenient. But if you have a documented medical appointment, you always can get out of being at the day reporting center. And if you say, hey, I want to walk around town, you're not going to go walk around town. You're going to be at the day reporting.
How long is that program? That's a lot. That's a lot on me, man.
I'm trying to figure out what else you're doing. You're not working.
I'm writing movies and stuff and trying to get in touch with Universal and Columbia and Sony and really pursue my dreams. Like, even with me dealing with mental health, and even when I took this charge, I took it in sight of doing the right thing. And I didn't cause the I don't know how to say it, like the crowdedness with the Fulton County probation with the 2 first violations.
Okay.
And I didn't.
Well, we're not going to relitigate those.
Yeah,
Those
I ain't
already
trying
happened.
I'm not trying to relitigate it, but I don't want to throw so much on me like that.
Okay.
And then thorough, you know what I mean?
I understand.
Like, that's a lot.
Okay.
For
I'm
just
following you.
every day, like, and then still, like, if you sit right here, look at all these drawings and investors and things that I'm trying to do. That's a lot.
Okay.
I mean, how long is it though? I mean, like, is it?
It doesn't matter how long it is, because I'm not gonna do it, okay?
Okay.
Here's what's gonna happen, Mr. McDuffie. I do find that you violated your probation by getting this new arrest. And I think I saw you nodding, Ms. Simpson. That case has been closed out in DeKalb?
They threw it out.
Okay, so time served, so that's been resolved. The drinking was a byproduct of your grandmother passing.
It was a gathering down at my grandma's house and I walked up to the store and called Mr. Crank. I was just like,
Okay,
man, I just need to
I'm
talk
glad
to
you reached out like that. And then there's the community service issue, and you told me you're gonna be working on that.
I'm gonna make sure I knock it out, and I promise that.
So I am gonna revoke 3 months. I looked at your other revocations, which all were longer than 3 months, so I'm not inclined to go a whole lot lower than that. So I'm revoking 3 months. You're gonna get credit for the time you served. I'm not gonna require you to do the day reporting center, but it is gonna be a special condition of your probation that you take all prescribed medications. So whatever the doctor says, you're taking those meds. If you're not, probation needs to come to me to say, McDuffie's not taking care of himself. You also have 6 months to take care of your community service. If you haven't done it, they're gonna come back to me saying, you gave him 6 months and he hasn't done it. I can figure out, how do we turn community service into days in jail? So make sure you take care of that. That's plenty of time to knock out 80 hours, right?
So can something come off of my probation for sitting 3 months? That's a lot of time to sit in the jail.
It is. When you say come off your probation, you get credit on your probation
Yeah,
for,
but it was due to Fulton County messing up too. I mean, I wanted to be fair.
Okay.
Because if I wouldn't have had it, and I'm not being funny, and I'm not being mean, but I'm being fair. The first 2 revocations was not my fault.
Okay, we're not talking about the
I mean, but
first
I
2.
did 78 days in that jail, and
Got it.
it's jail for nothing.
Okay.
Nothing. I mean, I was reporting, Mr. McBurney. I was
All right.
reporting, doing what I was supposed to do. That's not my fault that DeKalb County messed up and Fulton County didn't do what they supposed to do when I went down there doing what I was supposed to.
I'm hearing you, and
So to do
that's
3
not
months
this
right
time.
now, that ain't right.
Well,
Not
but
right.
this
I was getting
time,
out of jail, lost my grandmother. That's bad, Mr. McBurney. That's not a good fit.
okay, well, now you're unhappy with me, but you are gonna need to complete that community service. And otherwise, you're good to go. You're gonna be able to reside at that 1445 address. You'll keep reporting in Fulton, and we'll take it from there. All right? Ms. Rios, anything else on behalf of Mr. McDuffie?
No, Your Honor, thank you.
Ms. Smith?
Nothing for me, thank you.
Okay, and the reporting instructions would be to connect with Mr. Crank when he gets out, or to go to the office?
I want a new probation officer, man.
Well, I don't control that part, but that means you probably should go to the office once you're
Go to the
released.
office.
So within
This is
48
crazy.
hours of your release, make sure you go, you know where the office is, Memorial Drive. Yes?
Yes, sir.
Okay, go there and you can let them know you're out and you would like to
30 days for,
talk with the supervisor.
this is crazy. Okay.
All right, thank you. I don't think day reporting center would have gone well. So he is the way he's processing things, he's not letting go of the first 2 revocations, about which he feels very strongly, and he may be right, that he was doing everything he was supposed to do, and yet he got dinged. I just pulled up one of them. Judge Brooks gave him 4 months. So if he's not letting go of that. So, Ms. Rios, are you handling William Walker?
Yes, it's due Mr. Walker.
Is that gonna be like the one we just did?
No, that doesn't have the same struggles.
Oh. Mr. Rao, I'm gonna ask Deputy Gordon after we do this next revocation, if he can support I don't mean to keep you stuck here, but if we can support that conversation, after Mr. Walker, because, then we'll do that next.
Yes, sir.
All right. Good afternoon, Mr. Walker.
Good afternoon, sir.
We're going to get on the record in your case. You are 20 SC 175-578. Your lawyer, Ms. Rios, is here to assist you during this revocation. We've got Ms. Smith here for the state. And Mr. Walker, you have a year and a little more than 2 months remaining on your probation. So you are almost done with your probation, but you've run into a couple hiccups. Since you were last here, you picked up 2 convictions in Gwinnett County. It sounds like you got 10 years probation for both those. Does that sound about right?
Yes, sir, and 2 years of something called work release.
Okay. How long ago did you get those sentences?
A year ago.
Okay, so you've been doing work release for a while?
Yes, sir.
All right. And then you have a new case in Fulton County. It has not been indicted yet, but you got arrested for something in Fulton County. And I'm going to check out your petition right now. The allegations that brought you here are, it looks like your Gwinnett cases, or at least one of the Gwinnett cases, and then also this it's pretty recent. It was late March arrest here in Fulton County. You were arrested for drug trafficking and having a weapon in connection with drug trafficking, having a weapon as a felon. Something you had was supposedly stolen, and then some driving offenses. So 2 different cases, one from Gwinnett, this recent one in Fulton, and you haven't been paying restitution or supervision fees. And I think you were supposed to be either working or in school, and you haven't demonstrated that you were in either. Ms. Rios, what is Mr. Walker admitting to here, if anything?
We are stipulating to the violations. We are asking for time served. He's 24 years old. He has 1 daughter, a 3-year-old daughter. And right now he's in the, as he said, a work release program where he, I believe from 11 to 2, he goes to work at an LLC called Light Cleaning Service. And then he goes back to the prison for the remainder of the time. So he's not actually out, and he did a year of that, and he has 1 more year to do. And so I'm asking for him to go back to
return to that process.
Since he only has a year in what, 2 months, you said?
1 year, 2 months, yeah.
1 year and 2 months left. If he still has a year there, so he's not like he's going to be out on the street. My understanding that he's going to be in prison, and so if we just do time served here, then he can just finish his custody, and close it out, and he can finish it in Gwinnett. That's my request.
Okay, so you're well, I'll just ask you, Mr. Walker, when you weren't stuck here in Fulton, you would work for a while each day, and then in the late afternoon, report to the Gwinnett County Jail?
Yes, sir. My work schedule is from 11 a.m. to 1 a.m. and I report to Gwinnett County Correctional Complex. It's a prison, a PDC.
Okay. And so at 1:30 in the morning or something, you're checking back in after you've been working.
Yes, sir.
And then you are in that prison facility until 10:30 or whatever, so you can get to work.
Yes, sir.
How do you get from there to work each day?
Either my people come and get me or I get an Uber.
Okay. Your people is your family or your employer?
Oh, my girlfriend.
Your girlfriend. Okay. And she gets you to the job and then back at 1:30 in the morning to the prison.
Yes, sir. Most of the time I just get an Uber back.
Okay.
She's not able to come and get me.
Got it. Okay. But where you're going is not a county facility? You said it's a PDC, it's a probation detention center?
Yeah. It has one side that's prison and it has one side that's just for workers. So I guess it is like a prison detention center.
Okay, I'm gonna need to learn more about that. I haven't heard of something like that. Here's the critical part that I want to understand better. Conceptually, your recommendation makes a ton of sense. Get Mr. Walker back into work release, which was meant to be rehabilitative and structured and keep him out of trouble, et cetera. But see, March 28th of this year, where Mr. Walker would have been in the midst of work release, and yet he got arrested for speeding, following too closely, suspended license, gun, drugs. To me, it's remarkable that Gwinnett hasn't shown up to say, we're revoking 100 years because you were on work release and then this happened, but Gwinnett's going to do their own thing. How do we manage that? That's the concern I've got. I appreciate it's only arrest. I'm not attributing anything more than that. But the fact that he got arrested while on work release says maybe work release isn't this great setup.
I do not have the facts of that, exactly what happened with that or
Mhm.
the police report. But again, he's denying those allegations at this time.
Yep.
So I don't know how that case is gonna play out, but it seems like, I know that's still an issue, but aside from that, he has been doing good. And my thought is just to let that play out and let that go through the process and just let him return to work release. That's what we're requesting.
Okay. Do either you, Ms. Simpson, or you, Ms. Smith, have a PI number for? Oh, I think you did. It was in your, I knew I had just read it. It was in your email. Great, I've got it. Thank you. By the way, these new emails have extra info in them. I like them. Thank you. For our last month together. Maybe you can do write-ups on my child custody. I'm just looking at the arrest affidavit. Is Kayla Green your girlfriend?
No, sir.
Who's Kayla Green?
I guess like a friend.
Okay. But you know who Kayla Green is?
Yes, sir.
Okay. All right. Ms. Smith, what is the state's recommendation?
Yes, Judge. In this case, the state is asking to revoke the balance of the defendant's probation. Starting with the fact that we have these two new arrests, one from 2024 that I think that he's pled on, and this open case from March of this year, with not just misdemeanors, not just petty crimes, but crimes such as trafficking and having a gun in each of those instances. The underlying case that the defendant is on probation for, he also pled guilty to having a weapon in that case. So after this case where he pled guilty in Fulton County, he then had two other cases where he had guns again, which is a violation of his probation, which is something I'm pretty sure the defendant knew about. So with these two new charges, and also just the fact that the defendant last payment of restitution was $25 in 2024. The state does not believe that the defendant is taking probation as seriously as he should. And because of that, the state is going to ask for the remaining balance of his probation to be revoked.
All right, thank you. I'm checking out the final disposition in the case. Ms. Simpson, what is probation's recommendation?
Judge, I'm in agreement with the state, given the two new cases that he pled to in Gwinnett County, makes him have, it gives him three convictions in the therefore, in addition to with the independent indicted case as well, probation is asking for the
Do you know what I guess I know what one of the Gwinnett cases was, because that's listed here. Felon with a firearm, reckless driving. Okay. What was the second case? Would the charges be in your system?
So one case is possession of a firearm by a convicted felon. driving while license suspended, reckless driving and speeding.
Okay, that's the one that's probably the July 7th one. That's what's in the petition.
And the other one is possession of marijuana more than an ounce, possession of firearm during the commission of certain felonies. And the remaining charges were not cause.
Okay, got it. All right, Ms. Rios, anything else?
Is his mother on?
Let's look. There's a Ms. Faust. Ms. Jackson is on twice. There is an iPhone and a Ms. Mitchell.
What's your mom's last name?
Walker.
Walker.
Yes, I'm on.
Okay, she's the iPhone. Hey, Ms. Walker, can you turn your camera on? Is she going to be speaking?
I think she wants to speak.
Okay.
Let me pull over. Yes.
So, Ms. Walker, I'm happy to hear from you. I need your camera on if you're going to be talking to us.
Hold on, how do?
Oh, you did it.
Okay.
All right. You're not driving right now, are you?
No, I pulled over.
Great. What did you want to add, Ms. Walker?
Detention center where he goes to work, the cleaning services, and he does go back in, and he's been trying, also helping me out at the same time. So I'm asking, I guess, mercy on the court for my son.
Okay. Well, I appreciate you being here on his behalf. That's a good sign.
Thank you.
You're welcome. All right, Mr. Walker, I'm not quite sure what's going on with you and the folks you spent time with during the window you're out with this work release program, but I still can't quite wrap my mind around how in the midst of work release you got arrested in the fashion that is described and with the contents that were described being in the car, et cetera. And I know that's an open case, you haven't even been indicted yet, but that coupled with the two Gwinnett cases tell me that probation hasn't been an opportunity that you took to operate in a way differently than you were back when you took your plea in the 20 SC case. I'm going to revoke a year of your probation and close out the case. So when you're done with the revocation, you're done with this Fulton County case. You've got these new Fulton County charges, which I suspect will be indicted. And then you've got your Gwinnett probation. Now, this revocation is not going to affect your Gwinnett probation. Those sentences were imposed after you pled guilty in the old case where you drove your car at someone. The new arrest in Fulton from late March, that may yet cause you to have to go to Gwinnett to deal with things there. But I'm closing out your oldest case, this 20 SC case, by revoking a year. You'll get credit for the time you've been in, and I'll terminate this case after you're done with your revocation. Ms. Simpson, do you need anything else to do the order? Ms. Smith, anything else from the state?
Nothing further, thank you.
Ms. Rios?
No, you're right, thank you.
Okay, all right, good luck, Mr. Walker. So Deputy Gordon, we only have a few people left. I think one is the young lady you need to get from downstairs. One is Mr. Compton. I'd love to, if you are able to support it with your colleague, to have Mr. Compton sit wherever you tell him to and have 5-ish minutes to talk with his everything. And then we'll all reconvene to see how that goes. Is that, I'm not putting you in a bad spot doing that? Okay, I'll turn off the microphone in here and everything. Before we do that, I just want to make sure I know what's left. Ms. Dickens will be brought up. She's still down in the basement. I think we covered all the revocations. So we've got Mr. Battle's bond hearing, and that should be it.
There's one more.
Oh, what did I miss?
It's on this, I don't think it's on the calendar. It's from Tuesday. It's, Rogers, Christian Rogers. It's a misdemeanor negotiated.
Great, and he's here?
He's here.
We'll do that. Okay, so we're gonna take a quick break so Mr. Compton can have the conversation. If the result of the conversation is he wants to plead, we will do that plea then. He may need to think a little bit about what he learns, but if he's ready to go, we'll take that plea. I understand it won't be the sentencing, but it'll be the plea where the state commits to a certain outcome. And then we'll take the rest as you guys want. We'll just do Ms. Dickens last. Will one of you stay here for Ms. Dickens?
Yes.
Thank you. I saw you volunteer.
Well, I wasn't planning on going here, but tomorrow, can I appear on Zoom?
Yes.
Okay. Then,
I think I'll be the one person in court. Ms. Nelson's like, shh, I was here today. I'm dialing in. So Deputy Gordon and I will be here. You can hold my hand. And someone lined this guy up from the feds. He will be on Zoom through you worked with that AUSA?
Yeah.
Thank you. Okay, and it's just a non-negotiated revocation?
Yeah, I'm asking for 6 months. They're asking for 10 months. It's
Oh, okay. Seems like AI could handle that for me. All right, I'm gonna turn off the podium mic here and I'm gonna ask everyone who is not named Deputy Gordon or everything to step out of the courtroom. told that we're going forward with Mr. Compton?
I think so, Judge.
Everything. All right.
Mr. Compton.
Don't have to
So
get right
that has to be, actually, it does have to go after that. I'll ask for it to be suspended, okay?
Yeah.
So that charge right there has to go after the 15, but I will ask the judge to suspend it, okay? Just the gun charge right there. Okay?
I need you to either move the camera or move you a little bit so Ms. Rivers can see you, and you need to be kind of near the microphone.
So the chat can see you got them.
Someone needs to go take a vacation. Wow. We don't use we go electronic here. It's in fact an avatar of me. What's the indictment number? 23 SC 187611. All right. We're going to get on the record. Ms. Rivers, you ready to go?
Yes, I'm ready.
Great. This is position 2 from our trial calendar, State versus Compton. Mr. Compton is here in court with Ms. Wood. Mr. Rao is here for the state. It is 23 SC 187611. And Mr. Compton, you had asked to have an opportunity to speak with Ms. McCord. We gave you that opportunity. I had Deputy Gordon clear the courtroom other than you and Ms. McCord. Have you had a chance to process that conversation and what we talked about a little bit earlier and decide whether you want to go forward with a plea or instead go to trial?
Yeah, I came to a decision.
And what's that decision?
I'm gonna take the plea.
Okay. What we're going to do today is about 3/4 of the process. We'll do the plea part. We're going to hold off on the sentencing, not because there's a confusion about the sentencing, but the deceased's family has a right to be heard, say what they want to say, and they're not available right now. So we're going to need to bring you back for that little piece. It's not going to delay anything. Obviously, you get credit for every day that you're in, and the state's offer becomes fixed by you entering your plea today. So that won't change. When you come back, it'll probably be next week sometime to do that last little bit. Mr. Rao or his colleague, Mr. Abate, they can't come in and say, yeah, we thought about it some more, and it should be something different. That you are locking in that offer by taking the plea today. Do you understand that?
Yes.
Okay. Mr. Rao, anything you want to add procedurally, or are you ready to do the plea part?
Procedurally, do you want me to go through the factual basis or wait until?
I do, because I'm going to decide whether I'm going to accept the plea. I don't see any reason why I wouldn't, but I need to know there's a factual basis. I need to know that Mr. Compton understands all that. Really, the only piece we'll be saving will be you'll make your recommendation now because that's your offer, and that'll be on the record. And then we'll pause. And when we resume, we'll hear from any victim impact information, and then Ms. Wood will have a chance to present her perspective, and then if Mr. Compton wants to say anything, we'll hear from him.
Yes, sir.
Mr. Compton, Mr. Rao is about to put you under oath, and he's going to ask you a bunch of questions. It's important that you answer all his questions. It's also important that if you have questions, you let Ms. Wood know or you let me know. If we start talking about things that don't make sense to you or different from what Ms. Wood said, hey, here's what's going to happen, tap the brakes and say, wait, I don't understand why this is happening, or could you explain that? And I'll do that. All right?
All right.
All right. Everything you do, you got to do out loud. No nodding or shaking your head, because the court reporter needs to write down spoken words. Mr. Rao.
Thank you, Judge. Mr. Compton, would you raise your right hand, please? You swear or affirm that the statements that you provide the court today will be the truth, the whole truth, and nothing but the truth?
Yes.
Okay. You can lower your right hand. Please tell me your true, correct, and legal name.
Can't say Compton.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No.
How old are you and how far have you gone in school?
I'm 22.
How far have you gone in school?
I dropped out after I got shot in 12th grade.
Okay.
12th grade?
Yes.
So you're almost graduated.
Yeah, I got shot then, didn't go to school.
Okay.
Have you completed your GED?
No.
Are you able to read, write, and understand the English language?
Yes.
You understand that with respect to the indictment under 23 SC 187611, you were charged with the offense of murder, which carries a minimum life to a maximum life without the possibility of parole, that in exchange for your plea of guilty, the state's going to reduce the charge from murder to voluntary manslaughter, which carries a minimum 1 year to a maximum 20 years in confinement. The state's recommendation to the court is going to be 15 years to serve on voluntary manslaughter. Do you understand, sir?
Yes.
With respect to count 2, felony murder, that would vacate by operation of law. Count 3, aggravated assault, would merge into count 1. And count 4, possession of a firearm during the commission of a felony, carries a mandatory 5-year sentence to run consecutive to any other count. The state's recommendation is 5 years probated to run consecutive to count 1 for a total sentence of 20 years to serve 15 years in custody with the balance on probation. Do you understand, sir? Do you need me to repeat anything?
Yes, can you repeat it one more time?
Okay, sure. The total sentence that the state's going to recommend to the court is 20 years to serve, 15 in custody, with the balance of the remaining 5 years to be on probation.
So I think his confusion is that he wanted me at the sentencing portion to ask the judge to consider suspending that, but I've explained to him that that would take place later, and that's up to the judge's discretion.
So, Mr. Compton, the part that the state's not budging on is the 15 to serve. Obviously, that's the more serious component of their sentence. Mr. Rao is recommending, I'm not bound by that recommendation. I'll listen to it, but it doesn't control what I do. He's recommending that +5, and it has to be +5, that be probation. Ms. Wood is going to recommend that it be a suspended sentence, so that when you're done, you've got a parolable offense, and so you will likely get out well before 15 years. I don't control that, but you're probably thinking about when you'll get out. You may be on parole for a while. If I were to follow Mr. Rao's sentence, then you'd have those 5 years probation at the very end. Ms. Wood is going to argue that those 5 years should be suspended, so you don't have any supervision during those 5 years. I'm not deciding that today. I'll decide that when we reconvene, because that's when Ms. Wood is going to make her argument about why that makes sense, and tell me a little bit more about you, because you are more than what these charges are. And I'll hear about all that. Today, I'm just going to receive the state's recommendation, the evidence that the state thinks would be presented at trial. And I know a fair amount about it because I already took Chalmers' plea. So I've heard some about the case. But Mr. Rao is going to tell me about that. And if I think you understand your rights and what you're giving up, and that the state could prove its case at trial, then I'll accept the plea. And we're all locked into 15 to serve. And then it's just a question of, is it +5 probation or +5 suspended? That we'll figure out when we come back next week. Well, it won't be next week because Ms. Wood's got some other things to do, but when we come back in the next couple weeks. Okay?
Yes, sir.
All right.
Mr. Compton, do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yeah.
Have you had enough time to speak with your attorney about all the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses that you might have should this case go to trial?
Like you've had enough time to talk to me about the case.
Yeah.
Okay,
Counsel, do you waive formal reading of the indictment?
we do.
And do you waive any and all defects therein?
So wait,
You understand that this is a plea of guilty, which means that the state has recommended the sentence that I have mentioned before. But the court does not have to accept that recommendation. The court can sentence you to the maximum with respect to each charge and can run those sentences consecutively or one after the other.
Yes.
You understand that this is a guilty plea which may be permanently recorded on your criminal history.
Yes.
You understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as in other jurisdictions, including the federal courts.
Could you repeat that?
Sure. You understand that this plea may be used to enhance sentencing on other convictions that you might have in this jurisdiction as well as in other jurisdictions, including the federal courts.
So what you're saying is this current case can follow me to a next current case if I ever get into another current case.
If you get another case, yes, potentially it can
I
affect
understand.
the sentencing.
I
You understand?
Yes, sir.
You understand that if you're currently on probation, your probation may be revoked based on your entering a guilty plea today. And I don't believe you have any criminal history, but if you are on probation, this may be used to revoke any probation that you might currently have. Okay. You understand that if you were placed on probation of any kind, you cannot violate any criminal laws or any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence.
Yeah.
You understand that you're not allowed to possess or use a firearm if you are sentenced on probation.
Yes.
You understand that if you are not a U.S. citizen, a guilty plea conviction will affect your immigration status and will result in deportation regardless of any advice by your attorney or anyone else.
Yes.
Understand that there may be other adverse or unfavorable consequences as a result of your guilty plea conviction here today, just as there would be from a conviction following a trial. For example, your guilty plea may affect the right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes.
You understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, you'll be guilty of a felony which carries a sentence of 1 to 10 years in prison.
Yes.
Do you understand that you waive any and all defenses by entering a plea of guilty here today?
Yes.
You understand that by pleading guilty, you're giving up these following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to assistance of counsel hired by you or a court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to justify, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial. Do you understand that these would be the rights that you'd be giving up by pleading guilty?
So he had a question and I was explaining to him that those Boykin rights are just to advise him that he does have a right to go to trial, but that by entering a negotiated plea on this case, it just means that you're electing to resolve this case favorably and not go to trial. That's all that means.
Do you understand, sir?
Yeah.
If you don't, we'll explain it a different way. You don't have to say yes just because you want to move on. You understand you've got two choices when it comes to resolving the case: trial or plea. If you choose to plead, which it sounds like you're doing, you're necessarily giving up your right to a trial for these charges, not charges in the future. For whatever reason, you caught new charges 10 years from now. Maybe you go to trial on those. But for these charges, this situation, you're saying, I don't want trial, I'm going to do a plea. And by saying yes to plea, you are saying no to trial. Does that make sense?
Yes.
Yes. Okay.
Does anyone force, threaten, or promise you anything for you to enter a guilty plea today?
No.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Huh?
Are you pleading? Let me ask you this. Is it your decision to waive the rights that I have discussed, that the judge has discussed, and that your attorney has explained to you because you are in fact guilty of the offenses that you were charged with? Are you pleading guilty or not guilty?
So, Mr. Compton, you can plead not guilty if you want, but that's your way of saying, actually, I want a trial. I fooled all of you. I don't think that's what you're trying to do. Or you can say, I plead guilty. I did these things. You're right. And I'm taking this deal. The other answer that people give sometimes is, I'm pleading, but it's in my best interest to do so. I don't agree with what you say happened. And so I'm going to make this up, but I was there. Chalmers did the shooting, but I had a gun and it was messy and I could see a jury may convict me. So I don't want to go to trial. I want to take the 15. I don't want to run the risk of getting life. But I know what you're about to say because I've read the police reports, and you're going to say, again, I'm making it up, I shot the guy in the head. And I know I didn't do that. It was Chalmers who shot the guy in the head. So then you'd be saying, I'm pleading, but I'm pleading because it's in my best interest to do so. I'm not pleading because I did the thing you said. And you can do either one of those. It's still a plea. Your sentence isn't going to be any shorter because you say best interest. But sometimes that's important for a defendant to make clear on the record, which is, hey, I'm working this case out because this is the best thing I can do for myself. But it didn't go down the way you're saying it went down. But plenty of times people say, yeah, you got me. I had drugs in my pocket. I had a gun in my pocket. I'm guilty. Let's keep going. So that's all Mr. Rao was asking is, are you pleading guilty to these charges because you in fact are guilty? You did the things, or are you pleading guilty because it's in your best interest, meaning Mr. Compton's best interest, to work it out this way?
I'm pleading guilty because it's in my best interest.
Understood.
So how do you plead to the charges in indictment number 23 SC 187-611?
You have to say it again.
Oh, I'm pleading guilty because it's my best interest. Like, it's the best interest for me.
Okay.
So just plead guilty.
So is this guilty plea freely and voluntarily given with the full knowledge of the charges against you?
Yes.
Understand that you have only a limited right to appeal this guilty plea conviction.
Can you say it one more time?
You understand that you have only a limited right to appeal this guilty plea conviction.
What that mean?
So if you went to trial and you were found guilty, you get a full-blown appeal. Your lawyer could file a motion for new trial. You get in front of the Supreme Court, and you could argue about all the mistakes that maybe I made as the judge, or your lawyer made, or the prosecutor made. But when you plead guilty because you're not going to trial, there are many, many fewer things to appeal. You could basically, if I gave an illegal sentence, you can appeal that. The most I could give you is 20 years. If I gave you for voluntary manslaughter, if I sentenced you to 21 years for voluntary manslaughter, you could appeal that because that's an illegal sentence. Also, if your lawyer didn't tell you anything about your rights, she just came in here and said, you better plead, you got to do this. And she didn't tell you that you have a right to trial and she'd be your lawyer at trial and all that. You could appeal your plea because you didn't know all the things you were giving up. But I know you know all the things you're giving up because Mr. Rao just talked to you about them. So his question is simply drawing your attention to the fact that you can appeal after you enter a plea, but there's not a whole lot you can appeal. You don't get to say, oh, we should have suppressed my statement. The police beat the statement out of me, or you should have suppressed the gun because they seized it illegally. You're waiving all those arguments by pleading guilty. We're not having arguments about was the evidence strong or legally acquired or anything like that. Understand?
Understandable.
Okay, so that's all he's getting at is that, yes, you can appeal. There's just not a whole lot to appeal from a plea. You understand?
Yes.
Do you understand that you have only 4 years from today for a felony charge to file what is called a habeas corpus petition challenging this guilty plea?
I didn't hear you.
Okay. Do you understand that you have only 4 years from today for a felony charge to file what is called a habeas corpus petition challenging this guilty plea?
Yes.
Okay.
You use the microphone.
Thank you. Your Honor, the defendant does not have any prior criminal history. If this case were to have gone to trial, the state would expect that the evidence would show that on January 14th, 2023, at the deceased victim's apartment located at 8213 Brookwood Valley Circle Northeast in Atlanta, Georgia, the defendant, along with his co-defendant, Matthew Chalmers, opened fire on the victim approximately 25 times, shooting the victim 10 times, resulting in his death. What was alleged to have happened prior to the shooting was the deceased victim had verbal altercation over the phone with his girlfriend's brother, Desuelo Davis, that ultimately led to a physical altercation when the deceased victim came to the apartment, punched his girlfriend in the face, and then got into a fight with.
I'm listening. I'm going to ask you a question in a minute.
Yes. Victim punched his girlfriend. Her brother was also on scene at the time, so there was an altercation between the two of them.
Meaning the girlfriend's brother. So the deceased is Mr. Yancey.
That's correct.
Mr. Yancey shows up and he hits his own girlfriend.
That's correct.
And the girlfriend's brother and Mr. Yancey get into it.
That's correct.
Okay. And none of those people is Compton or Chalmers.
That's correct.
All right.
They are on scene in the apartment complex. But prior to their involvement, after the altercation between the victim's girlfriend's brother, Desuelo Davis, the victim subsequently goes to a room, closes the door, and then reappears with a rifle in his hand, telling everybody to get out.
Mr. Yancey has a weapon in his hand.
That's correct.
Okay, get out of my apartment or whatever apartment we're in, you got to get out.
Correct. There's no evidence that he fired any shots or anything of that nature. He's telling him to get out of his apartment. Mr. Chalmers and the defendant then subsequently get out of a room armed with rifles of their own. Mr. Chalmers armed with
Another room in the same apartment.
That's correct.
Okay.
Mr. Chalmers is armed with a .762 caliber rifle. Mr. Compton is armed with a .556 rifle. They proceed to open fire with the victim's back turned towards them approximately 25 times, hitting the victim 10 times in the back. What ballistics analysis would later reveal is that out of the 25 shell casings that were left on scene, 2 of them go to Mr. Chalmers' .762 rifle, and the other 23 belong to the rifle in the defendant's possession. Subsequent to the shooting, both co-defendants flee the scene. They discard their rifles, and police are eventually called on scene where they collect all the ballistics evidence. An autopsy is performed on the deceased victim, revealing that he shot 10 times in the back. They recover one .762 projectile from him that matches the firearm that was in Mr. Chalmers' possession, and they recover one .556 bullet that was inconclusive to Mr. Compton's rifle. However, they did match it against the .556 rifle that was in the victim's possession, and it was conclusively proved to not have been fired from that firearm. And they also find 7 sets of projectile fragments believed to be .556 caliber rounds, but the same issue where it was not fired from the victim's firearm or Mr. Chalmers' firearm, but inconclusive as to whether it was fired from Mr. Compton's firearm. However, there were witnesses on scene to include the victim's girlfriend and her brother. Both of them indicated that they observed Mr. Chalmers and Mr. Compton firing their weapons at the deceased victim. Mr. Compton later was on a phone call with the deceased victim's girlfriend and also indicated that he fired, although his claim was that it was self-defense. And later on, warrants were obtained for both of the 2 defendants, and Mr. Chalmers and Mr. Compton were later apprehended in this particular case. State's recommendation in this particular case, again, is
20 to serve 15.
20 to serve 15 with a balance on probation.
So from your review of the evidence, if were both the firearms recovered?
All 3 firearms.
Well, not Mr. Yancey's, but the 2 rifles that supposedly Chalmers and Compton had, they were recovered.
They were recovered. Mr. Compton's firearm was specifically recovered in outside the apartment complex by the front gate in an area where there were shrubs.
Okay. Maybe the weapons are distinctive, but just saying it was this caliber versus that, how would you put the one gun was fired a whole lot more than the other? And you're putting that in Mr. Compton's hands rather than Mr. Chalmers. What, from the record, does that for you?
2 things, the video surveillance and Mr. Chalmers in his recorded statement to the police indicated he only fired twice, which is consistent with what on scene.
The only weapon fired twice was the .762.
That's correct.
Got it. And then the video surveillance, you see 2 individuals who match the general description. Mr. Chalmers is pretty distinctive.
Yes. And discarding the firearm.
Okay. And you can tell from this video the difference between the 2 guns.
That's correct.
Okay. Got it. Thank you. Let me get one other piece of information, and I think that's all we're going to do today. Ms. Harvey, good afternoon.
Good afternoon, Your Honor.
How are you doing?
I'm great. 3 Cycles does not appear to have any prior convictions. There is an arrest out of Dougherty County, Albany, Georgia, from May 15th, 2025 for purchase, possession, manufacture, distribution, or sale of marijuana, possession of a sawed-off shotgun, machine gun, dangerous weapon, or silencer, and possession of a firearm or knife during the commission of a felony. There was no disposition listed on this case, Your Honor, and nothing further.
Thank you so much. You know anything about the Dougherty County case?
No, Judge.
No? Is that still out there? Did it get dismissed or you got to deal with that someday?
Bonded out. I bonded
Okay.
out for it.
So you bonded out, but those charges may still be down there.
Yeah, but
Okay.
state.
Interesting how you'd bond out for that. Not because you'd get a bond. I thought you were already in the system for this case by then, but you bonded out. So I think what we'll do is pause here so that when we reconvene, Mr. Compton, if there are members of Mr. Yancey's family who want to be heard, I'll hear from them. The state has already committed to its recommendation of 20 to serve 15, balanced probated. And then after the family members speak, I'll hear from Ms. Wood, who will tell me more about you and this case. And I actually do have one question for Mr. Rao that I'll ask now, but Ms. Wood may be talking about that in the future anyway. And then, like I've said, in the end, if there's anything you want to add, I'll hear from you. And then we'll go into sentencing, okay? Yes? All right, Mr. Rao, my question is this. Based on what you described, with 10 shots in the back, it seems a little less self-defense than some cases you might have had. What is behind the state's offer in this case?
We believe that there's enough mitigating circumstance evidence in this particular case, chiefly the victim coming in, punching his girlfriend in the face, and then subsequently coming out with a rifle.
It was a pretty hot environment.
Correct. 25 shell casings and being shot 10 times in the back. And I think that there's enough evidence to extract from the medical examiner that perhaps some of those shots may have been while Mr. Yancey was on the ground after being fired upon, that certainly there's evidence to warrant the plea offer that the state's made, but there are
But the voluntary fits better with the dynamic in that apartment than malice murder.
That's correct.
Okay, got it. That's your role in this process. Mr. Compton, we will get you back here soon. So when you're next brought to court, you know why. It's to do the second half of your plea. But I'll let you know, I do find a factual basis. I'll close all that out only after you and Ms. Wood have had a chance to share what you want to share. But it does seem like this is a case that we can go forward with. And as I also mentioned, the state has locked in its recommendation. Okay? You got any questions?
A lot, but.
Okay, probably good questions for Ms. Wood to begin with. When we get back together, if you've still got some for me, that'll be the time. I will make sure that I address you so you can ask whatever you want to ask on the record, all right?
All right.
All right.
Thank you, Gotham.
Did either side think there would be someone connected with this case on Zoom? Because there's an iPhone on and that person says, I have a question. Would that be Ms. McCord?
She would, yeah, she was gonna be on the Zoom.
Okay, you have a way to contact her? All
I'll
right,
text her.
great. Thanks. Thank you, Mr. Rao. You don't really need Mr. Abadi. Did anything happen with Judge Glanville's case today? No. Okay.
We're short a lawyer.
On your side? On their side? He had more and lost one, or?
Christian Lamar left their office,
Really?
so it's just the bell.
That's not enough. Huh. What did he go do?
He's doing something with the federal government. I don't recall, honestly, but I feel like he's a federal offender.
Yeah. Huh. That's a big loss to that unit. Okay.
didn't say anything about Monday.
Okay. He won't be here, I know that, but you didn't say he was gonna be here. You said Newkirk, so I'll figure that out.
I came back to ask, your Honor, a question about Mr. Jackson.
Yeah.
I kept coming back in and I never saw the photos again.
Yeah,
I wanted to know if the court had made a determination.
I'm gonna send an email out, saying here's who needs to be here on Monday. I just need to think through it a little bit more. I mean, I interacted with Mr. Jackson a little bit and we are where we are. You don't have any preparedness issues for that one?
No, I'm not sure. I think it's more than enough time.
Okay, I agree. The other wrinkle is, Mr. Grigg saying that he's been called out in a 2018 case in another county. We will verify that. If true, I'm stuck, because that is far older than this. But I'm not gonna leave anyone hanging. We just need to confirm that and I'll get something out. You bet. Battle? Because we have battle and the plea and then the young lady. Is that it? Okay. Don't roll your eyes.
No, I just looked up and looked down.
Uh-huh. That's what it was. I just looked up. All right. Are you Mr. Battle?
Yes, Your Honor.
Mr. Battle, I'm Judge McBurney. We had you here a couple days ago and it was a crazy busy day. And we didn't get to your cases, not because Ms. Rios wasn't saying, Judge, Mr. Battle, we need to have a bond hearing. She made that very clear. Today is when we could get to it. So we're going to handle your bond hearings, plural. You have 3 cases here, and I think I'm going to learn that maybe you've got either an unindicted case or some cases elsewhere also. But in front of me is 26 SC 00224, 225, and 226, 3 different indictments. Ms. Rios is going to tell me why you should get a bond and what those bonds should look like, dollar amounts, conditions of bond, et cetera. I'll also hear from Ms. Smith, who's seated behind you, the prosecutor, and she's going to give me her view about whether you should get a bond. I may also ask probation, if you're on probation and how that's been going. Then we've got someone from pretrial services here on the call who's going to let me know about your criminal history. Okay?
Yes, Your Honor.
Ms. Rios.
Your Honor, Mr. Battle is 28 years old. He's a life resident of Atlanta. He's not a flight risk. He also has a job opportunity at the City of Atlanta Watershed Management. Since he's been in custody, his mom got an email letting him know that they're looking to interview him. And so he wants to be out so he can take advantage of that opportunity. He also was going to school at Atlanta Tech for his CDL license. He has 2 children that he helps take care of, like driving them back and forth to school and their activities. Is a 9 and 2-year-old when they are here in Georgia too. He also helps his mom take care of his sister who's fully disabled. She was shot in the face. And so he needs to be out for those things. I do understand that he has open cases, but I believe everything is nonviolent and I don't believe he'll be a risk to individuals. And I understand that property is still a risk, but with these upcoming job opportunities, that kind of alleviates, would change his life and kind of make him be on a different trajectory than what we've seen with these cases. And the most he would be able to afford is a $10,000 bond. He has a bond on one of the cases. I think it's the case ending in 225 that has a bond. One of them already has a $2,500 bond. And so the other 2 cases, he's in no bond status. So I'm asking for each of those cases to have a total bond of $5,000.
Okay,
You have three cases in total. Can we double check of how many cases? My understanding was he has three cases.
she has at least three here, 224, 225, 226. I've got a bright red W in Odyssey, which says he's got a warrant from somewhere, so we're gonna explore that. And I'm gonna see if there are any other cases. I'm looking at 225 right now because you mentioned he may already have a bond in that one. I don't want to set a bond if I'm going to where he's already got one. And he does on January 10th, in the case ending in 225. Judge Oliver gave him a $2,500 bond for the only count in that indictment. So it would be setting bonds in the other two cases.
Right, he's just trying to make sure there's no other cases if we don't get a bond today so we don't have to come back.
Right. Let me check. We should be able to find him pretty easily. Nope, the only three open cases are 224, 225, and 226. You're welcome. All right, let us turn to Ms. Harvey. Criminal history information on Mr. Battle. This may be a little curveball for you because he wasn't on today's calendar.
I have it, Your Honor.
Great.
12 cycles. He was sentenced under first offender in 2025 for aggravated assault out of Clayton County. There's a 2025 felony conviction for theft by taking and a 2025 conviction for entering auto. There is an arrest out of Riverdale, Georgia from April 11th, 2023 for theft by receiving stolen property, 2 counts with no disposition listed. There's also an arrest out of DeKalb County from April 14th, 2023 for entering auto with no disposition. There's an FTA from 2024 and a hold out of Douglasville, Georgia for burglary. The date of that warrant is December 31st, 2025, and nothing further.
Okay, thank you so much. And that's probably the warrant we're talking about. Is this hold from Douglas or is there more? Okay, Ms. Simpson?
In addition to the warrant out of Douglas County, he also has a probation warrant in Clayton and 2 probation warrants here.
So 3 probation warrants.
Yes.
All right.
The probation warrants for probation cases for here. No.
They gave me. Ms. Smith?
He said in April 7th, he already had his hearing at a given time. So I'll double check on that because it's not showing the system.
Yes, Judge, in this case, the state is going to be asking for the indictment ending in 224 and indictment ending in 226 for the defendant to be held in a no bond status. The indictment ending in 0224 on December 15, 2025, the defendant went before another judge and his bond was, I'm sorry, not on January 8th, 2026 of this year, my apologies. The bond was denied for the indictment ending in 0224 for the risk of reoffending, and for the indictment ending in 226, the defendant's bond was denied on that same day, January 8th, 2026 of this year, for being a threat to the community, person, or property in the community. And the state has the same concerns as that was had by the state in January, because we do believe that the defendant is at risk of reoffending. At the time that he was arrested for these cases, he was already on probation for a theft by taking and entering auto conviction from June of 2025. So the state does believe that the defendant is at risk of reoffending if he is let out on bond. Also, the state still believes that the defendant is a threat to the community and the property in the community. All of these cases that we have are very similar, with the defendant taking something of someone else's, entering someone else's car with the intent to commit a theft or to take from someone else's person. And we don't just have one or two cases for it. There's 3 open cases in Fulton, 2 open cases that he already has in Fulton for theft by taking and entering auto, and a case out of Clayton. Also, we did give him a free trial, said that he has an FTA out of 2024. And the state is kind of less concerned with the fact that we don't think he would come back because it's a flight risk, but more the fact that there is a huge risk of reoffending, and also for him to be a danger to the community based on him going out and breaking into someone else's car or trying to take the items of another person. So because of that, the state is going to be asking for both of these cases that a bond is not set for the defendant.
All right, thank you for that. I do want to clear up, Mr. Battle did have a revocation in the 225 SC cases. April 6th, a senior judge, Judge Cornwall, I think, heard them and revoked him. There's still the Clayton hold, probation violation, Clayton, and the Douglas County hold. So there's still a long queue of holds, but it's important to know that you're not going to be getting in front of Judge Whitaker or another judge. That's your 2 cases in Fulton for which you were on probation when this stuff happened. You've had that revocation. So that's good to know. Mr. Battle, I am not going to say, oh, yes.
Yeah, he did want me to request, I know what you were going to say, but an ankle monitor and a curfew for him just to go to work and school. If you weren't inclined to set a bond, that would make a difference.
Okay, I appreciate that. And I always think of the electronic monitoring option as well. That's sort of the in-between. Let's give him a bond and hope he stays out of harm's way versus let's keep track of where he is. But I need to focus on what's in front of me, which is not 1 or 2, but 3 new indictments. It's interesting to see how different judges look at things in different ways because you had different judges for your pre-indictment bond hearings. And 1 said, yeah, give him a bond. And 2 said, no, there's too much going on here. And I fall into that camp. You've got an active warrant out of Douglas County. You've got a warrant out of Clayton County. And while you were on probation for your 2 Fulton County cases, these 3 situations happen. Of course, you're presumed innocent of these 3 situations. I'm not saying you did any of it, but it is not insignificant that you've been indicted 3 times for these situations. We are going to see you soon in court. Your lawyer has already filed waiver of arraignments, meaning entered a plea of not guilty for you in the cases. Ms. Smith, the prosecutor, will be getting discovery to your lawyer. And hold on 1 second. It's another judge in another circuit. Okay. We will see you soon once your lawyer can process all that discovery and talk to you about it. She will talk to you about, well, should we go to trial on these cases because they're not particularly good for the state, or should we look for an overall resolution that would address getting you back into being productive, whether that means going to school or working or both. But there's clearly something going on because you're collecting cases sort of like they're on sale, and we need that to slow down a little bit. I know that's what your family wants as well. So no bond for 224, no bond for 226. The bond remains in place in 225. And I guess we need to figure out if we should resolve things in Fulton before Douglas and Clayton, or if this is the kind of situation. And you should let Ms. Nelson know, Ms. Rios, if we want to get him to Clayton or Douglas with a hold so that he comes back here afterwards.
Yes, sir. Thank you.
You're welcome. Ms. Would you have a plea?
Yes, sir.
And this was one we didn't get to either from that same calendar, or?
Yes. Christian Rogers.
Oh, there it is. Reset to Thursday. Huh. All right.
You have Rogers, please?
Is it a male?
Yes. Fair question. Good afternoon.
Oh, that's for you. I just forgot the circle. Judge, may I approach?
Yep.
Who's the business meter?
Thank you.
Thank you.
Yeah, of course. So that's everything you should need, but they'll contact you as well.
Okay.
Okay?
Okay.
Let me know when you're ready. Ready. All right. Let's get on the record. This is State versus Christian Rogers, 26 SC 001351. Good afternoon, Mr. Rogers.
How you doing?
I'm sorry I weren't able to get to your case on Tuesday. It wasn't because you're less important than anyone else. It's just we were working on a million things, and Ms. Wood said, I think we've worked this one out. Can we do it on Thursday? And here we are. Mr. Rogers, you are here to take what I understand is going to be a misdemeanor plea. So the state's going to be reducing or dismissing certain charges. Ms. Smith is about to put you under oath, and then she'll be asking you questions about your case and your rights. You need to answer those truthfully and completely. You also need to let me know if you've got any questions about anything we discuss.
Okay.
Will you do that?
Yes, sir.
Okay. Ms. Smith?
Mr. Rogers, please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can lower your hand. Please state your true, correct, and legal name for the court.
Christian David Rogers.
Judge, sorry I didn't say in the beginning, but this will be a misdemeanor plea, and that's just count one is a felony charge. It's going to be reduced to a misdemeanor charge under the same OCGA code.
Okay.
1137.
Got it. And then criminal trespass already is a misdemeanor. That's staying in the mix. So 2 misdemeanors.
Yes.
Thank you.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
Is there any medication that you would normally take that you haven't been given today?
No, ma'am.
How old are you and how far have you gone in school?
I'm 33 years old and I have gone to high school and reached my diploma.
Are you able to read, write, and understand the English language?
Yes, ma'am. In your honor.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, ma'am, in your honor.
You just need to say, yes, ma'am. I'm good. I'm hearing the answer, but you're talking with her.
Okay.
Have you had enough time to speak with your attorney about all of the facts and circumstances known to you regarding the charges in this indictment?
Yes, ma'am.
Do you need more time to discuss your case with your attorney?
No, ma'am.
And are you satisfied with her services?
Yes, I am very satisfied.
Counsel, are you satisfied that your client has a full understanding of this proceeding?
I am.
Also, do you waive the reading of the formal reading of the indictment and any and all defense in the indictment for the purposes of this plea?
No way.
Mr. Rogers, do you remember being arrested on these charges?
Yes, ma'am.
The state is unaware of any outstanding warrants related to these charges. Are you or your attorney aware of any outstanding warrants?
We are not.
No.
Mr. Rogers, do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court a sentence of 24 months of probation?
Yes, ma'am.
Are you aware that the court does not have to accept that recommendation and that the court can sentence you to the maximum on each charge and can run those sentences consecutively?
Yes, ma'am.
Do you understand that this is a guilty plea which is permanently recorded on your criminal history?
Yes, ma'am.
Do you also understand that if you're charged with a crime in the future, that this plea may be used to enhance that sentencing, including on a federal case?
Yes, ma'am.
Do you understand that if you're currently on probation or parole, that your probation or parole may be revoked based on you entering this guilty plea today?
Yes, ma'am.
Are you a United States citizen?
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering this plea of guilty?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up the following rights? The right to a trial by jury, the right to remain silent and not incriminate yourself, the right to see and hear the witnesses called to testify against you, the right to the assistance of counsel, either hired by you or court appointed if you cannot afford an attorney, the right to the presumption of innocence, which means that the state must prove beyond a reasonable doubt that you're guilty of these charges, the right to testify on your own behalf or remain silent, the right to present other evidence of your own and call your own witnesses, and the right to appeal if convicted of these charges after a trial.
Yes, ma'am.
Counsel, are you satisfied that your client understands that these are the rights that they'll be waiving by entering this guilty plea?
I am.
Mr. Rogers, has anyone forced, threatened, or promised you anything to get you to enter into this guilty plea?
No, ma'am.
As to indictment number 26 SC 001351, how do you plead to the reduced count of a misdemeanor charge of terroristic threats and acts and count 2, criminal trespass?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
Do you understand that you do not have a right to appeal directly from your guilty plea conviction? But if you believe that there is some type of error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal.
Yes, ma'am.
Do you understand that that process must be completed within 30 days from today?
Yes, ma'am.
Do you understand that you have only 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, ma'am.
Thank you, Mr. Rogers. Your Honor, if this case were to proceed to trial, the state would show that on February 28th, 2026, officers of the Atlanta Police Department was dispatched to 3101 Piedmont Road, that's in Atlanta, Georgia, and also Fulton County. And the establishment located at that location is Fogo de Chao. It's a restaurant. When the officers got there, they were able to speak with the victim in this case, Mr. Knight, who told them that he had a verbal altercation with the defendant where the defendant accused him of taking $900 from him. When the defendant asked the victim, did he take the $900? The victim initially said yes to joke around with him. However, through the investigation of APD and also by the victim, he told the officers that he did not take the money. The officers searched his car. They did not find any money. So it was determined that the victim in this case did not take anything from the defendant. At this time, the defendant did leave the location, but he did come back later that night. And the victim in this case, he worked at the restaurant as a valet operator. So at the time that the defendant came back to the location, Mr. Knight was inside of one of those cars parking it, and the defendant came up, knocked on the door, and when he got out of the car, they got into another verbal altercation where the defendant told him that he would kill him and he could die tonight. At this time, the officers were called. The defendant started walking down the street. The officers caught up with him, and he was eventually arrested for the charges we have in front of us. So those are the facts of the case. Regarding the negotiated plea between the state and defense, we've agreed to, for both charges, 24 months of probation to serve 90 days with the balance probated. So for counts 1 and 2, 12 months probation to serve 90 days with the balance probated. Regarding the special conditions of probation, we've agreed to a no contact with the victim, to stay away from the incident location, for the defendant to complete a drug and alcohol evaluation with treatment if necessary, for the defendant to also complete an anger management course and 40 hours of community service. I did get a chance to speak with the defendant in this case. He was okay with the reduction based on the facts and circumstances and him initially saying he had the money when he knew he did it and how that probably provoked the defendant in this case. He did say that he would like no violent contact. If he sees the defendant, he said he don't think it'll be a problem. However, no contact with the victim or no violent contact, he's okay with both. But I did get a chance to speak with the victim. He's okay with the offer in this case. And I'll call him after to give him an update. He didn't want to be on the Zoom call today, but that is all from the state.
How did he describe either to the police or to you how he and Mr. Rogers knew each other?
So he said that Mr. Rogers was at the Fogo de Chao location. I'm not sure if he was there to eat or he was just there, but they came into contact because the defendant in this case came up to the victim and said, "Did you take my money?"
As in, like it was in my car, I went in to eat and you parked my car and you took money out of my car?
I'm not too sure on that. I just
Okay.
know that the verbal altercation was about the defendant missing money
Mhm.
and the victim initially saying,
Saying,
got
yeah, I
it."
got it.
Right.
Okay.
And then there was an altercation after that.
Got it. Okay. The criminal trespass count says Mr. Rogers came back to Fogo de Chao after he was told to go away. Was there, I may have missed it in your recitation, was there an initial, either the owner said, some management at Fogo de Chao said, get out of here?
Yes, so it wasn't the officers. The first time management was just like, "Can you leave?"
Okay.
Or the people at Fogo de Chao that was in
Yep.
leadership positions asked him to leave.
Said
And then
leave,
he
and then he came back. That's the trespass piece.
That's correct.
Obviously, the threats are the threats.
Yes.
Okay, thank you. Ms. Harvey, do you have any criminal history information on Mr. Rogers?
Yes, Your Honor. 3 cycles out of Georgia and 1 cycle out of the state of Maryland. No prior felony convictions. He was convicted May 12th of this year out of Fulton County for criminal trespass, and there's a 2025 battery family violence out of DeKalb County, and nothing further, Your Honor.
All right. Mr. Rogers, what was the criminal trespass in May of this year? Oh, Ms. Wood?
It's a situation at Twin Peaks.
Yeah.
So I don't.
Something about you in restaurants.
Yeah, well, so
Okay.
I was a paying customer at the Fogo de Chao as well, but at Twin Peaks, I was a paying customer and I had got a little too drunk. And so they wanted me to leave. And so when I didn't go back to Twin Peaks, I went to the taco restaurant that's in the same vicinity.
Yeah, you
And
got too
because
close.
they was too close. So that's why they said I was criminal trespassing, but I never went back into Twin Peaks.
Okay, not this case, just curious, because you picked that up or resolved that after this incident, but before today.
Yes, Your Honor.
I guess you must have gone to some other court. You've been in for a while, so you were in custody and went and resolved your Twin Peaks case
Yes, Your Honor.
while you've been waiting to resolve this one.
Yes, Your Honor.
Understood. Ms. Wood?
Thank you, Judge. He's 33. He is a high school graduate. He has done the 90 days. He was working prior to this arrest. He was a manager at an Ashley Furniture warehouse. He's not sure if he can return to that job. He is hopeful. So we would just ask that you accept the state's recommendation in this case.
Okay. And home for you is Lithonia?
Yes, sir.
Okay, who lives there?
My friend who I call my brother, his name is Daryl Brightwell. And I also was, prior to that, I was because the money that I lost was part of my 401k.
Cool.
And I was I was enjoying myself before I was going to help my mother out. And I was planning on trying to get my own apartment and get myself together. But I do reside here and there. And I'm just really still trying to get myself together. That's all I've ever been trying to do and everything.
When you say get yourself together,
As far as
does
like
that-
my own place,
Right.
my own apartment.
But when you getting yourself together because you've been struggling because you drink too much or because it was hard to get a job, or what is it that you're getting
My
together?
mother is a stroke survivor. And so I just came back from Maryland. And when I
Okay.
came back from Maryland, I had to find a place. So
Okay,
that's,
how's your mom doing?
I haven't talked to her since February.
Because you've been locked up? Okay, I hope she's all right.
Me too. Thank you.
You're welcome. Do you have any questions about what we discussed?
No, I trust everything and I have faith in you as well, sir.
Okay, well, I appreciate that. So you didn't know Mr. Knight?
No.
He's a valet and you had $900 in your car?
I was a paying customer at Fogo de Chao and I was leaving. I never had an altercation inside of Fogo de Chao. It was with him. And so when I dropped as soon as I dropped my money, it's the things that he said to me that made me assume that
You had $900 on your person
on my person.
and
Cash.
and you dropped it. That's a tough drop.
Yeah.
Okay, so you went into the restaurant with about $1,000 in cash, ate lots of meat on sticks, and then you left. And when you were leaving, you dropped almost $1,000.
And not to disrespect the court or anything, but quote unquote is what he said is, I have your money, PUSSY, come
Okay.
get it.
Got it.
And that's the only reason why I would even return to the, because I wouldn't have never returned. I would have took that loss and, because I had a steady job.
Okay.
And even though I would have been upset that I lost my money, I would have never returned there to even look for it. But it's the fact that he said he had it.
What he said. Okay. I appreciate you giving that context. I was just trying to figure out why you linked him to money you lost. And I was thinking you had it in your car, he's the valet, and like, hey, he was in your car. Maybe that's why, but you've explained it. Mr. Rogers, I find there's a factual basis for your plea and that your plea is voluntary. No one's forcing you to do this, and it's knowing, meaning you've understood what we talked about. You agree with that?
Yes, sir.
Okay. Can I have someone in my office sign the indictment on your behalf indicating your guilty plea to the 2 misdemeanors?
Yes, it's fine.
Yes.
Yes. All right. Ms. Wood, can we sign for you?
Yes.
And Ms. Smith?
Yes, Judge.
All right. Mr. Rogers has done 3 months and you were giving him credit for that. Was it 12 to serve 3 on one count and then a full 12 probation on the other, or 12 to serve 3 on, I just don't remember how you phrased it.
It was 12 months to serve 3 on both counts.
On both counts. All right, that's going to be structurally complicated because you were thinking for it to be 24. They were going to run consecutive?
Yes.
Okay, I'm going to do it slightly differently, same outcome. So Mr. Rogers, count 1 is a misdemeanor. You get credit for the time you served. So I'm sentencing you to 12 months to serve 3 months with a balance on probation. So that's 9 months worth of probation. And then for count 2, I'm going to run that consecutive, but I'm going to make that only 9 months. So you're going to have a total of 18 months probation, and then you'll get credit for the 3 months that you served. So it's a total of 21 months to serve 3, if I did the math right. While you are on probation, which is going to start real soon, you'll get released in the next couple days. No contact with Mr. Knight. Don't look him up. Sounds like he was a stranger to you anyway.
Yes,
To make it easy, you're going to stay away from Fogo de Chao. If that's where he still works, you have no reason to bump into him. And don't pull I went to the taco place near Twin Peaks. There are a few restaurants near Fogo de Chao. Just don't go around those because he might see you and you're distinctive and he's, hey, this guy's back here. No Fogo de Chao, no Mr. Knight. I am going to require you to submit to a drug and alcohol abuse evaluation. And that's only going to help because if someone says you'd benefit from going to some treatment classes or something, that treatment becomes part of your probation. But if that professional talks with you and said, no, I mean, every once in a while you have too much to drink, but it's not a serious thing, then there's no treatment. And hopefully you keep moving forward. You'll need to complete an anger management course within the first 4 months of your probation. And you'll need to complete 40 hours of community service also within the first 4 months of your probation. And that evaluation that I mentioned, you'll need to take care of within the first 2 months of your probation. So I'm front loading things so that if you do need help, you get that sooner rather than later.
Okay.
Any questions about any of that?
But as far as the evaluation and everything, am I talking to my probation officer about that? Okay.
Yep. They will say, here's a great place to go to get an evaluation. Here's a great place to get an anger management course. And here's where you can do community service.
And another question I have is, and thank you, Your Honor. Will I be able to be released tomorrow or so? I don't know, because I definitely still have to get my property from South Annex.
So
that has my actual number, so that way I can contact the probation officer with my own personal.
Good.
It's all written down for you.
Oh,
Yeah. So Ms. Woods already filled out this form, which will go to misdemeanor probation, and then they're going to start reaching out to you to say, hey, you got to come meet with us to do an initial orientation.
So I probably have my cell phones and stuff by then.
You should. I'm not real good about connecting people with their property, but if we the county are holding your property in connection with you being booked in, you're entitled to get it back. If you don't, let Ms. Wood know, and if she needs me to fuss, I can always enter an order saying, give the man his stuff. Now, if what you had was contraband, I'm not suggesting you would, but like if you had a bike or something on you, you don't get that back. Wallet, phone, ID, all that stuff comes back to you. All right? And I suspect you'll get out tomorrow, but I hate promising things. It takes a little while to process paperwork. So they also process people out on Saturdays. So you ought to be out by Saturday. If on Monday you are still in, call Ms. Rios.
Okay.
Okay.
She's not.
She's not going to be around either?
No, she's not listening.
Oh, okay.
No, she did.
Okay, all right, yeah, she gave a look. All right,
I thank you, Your Honor.
all right, well, you want to thank me, don't mess around with Mr. Knight at Fogo de Chao anymore. I hope your mother's doing all right.
I hope so. That's the main reason why I want to just.
Well, you're gonna get out, and you're gonna call her, and you're gonna find out, okay?
Sure.
All right.
Thank you as well. All right, and thank you.
You're welcome.
All right, thank you.
You're welcome. Okay.
Started using the voice.
Mark is here from yesterday from Linda Parlor. We did a bond of a 10%. She already gave a bonding between Monday. But we can switch it to a regular bond instead of the 10% option. She has said she won't be getting her money back, but it's just, they're working with her for it.
Okay, if you will send an email to Ms. Nelson and me to that effect, we'll take care of it.
It's the email for you about just.
Including me is fine. All right. Thank you, Ms. Smart, for helping out in the way you're helping. I can modify that. So you should go ahead and maybe you already have, complete the negotiations. You know the dollar amount. So if they say we're going to do it, I just need to modify the bond order so that it reflects. So the sheriff will accept a bond from a private surety, Second Chance, AA, Rapid Bond, wherever you went.
After bonded last night and I paid them $800 and they already did it.
Okay.
They was telling me when they sent over to release her to get out, they were saying that, oh no, they said you gotta go to jail and pay, but I didn't know it was my first time. And I didn't know nothing about jail. I didn't look up a bonding company.
Got it. I hope it's your last time as well.
I hope so.
Yeah. So you keep Ms. Parler out of trouble. That's a complicated case. I do not know what's going on in that household. But that household needs some help. Yeah. And hopefully your church can bring some of it. I mostly pray for that little girl. It does not sound like she is well. So, but I'll get the bond modified and then Ms. Rios can let you know it's been modified. You can let the bonding company know, try again with the jail, they ought to take it. Okay?
Get out tonight?
No,
No.
it won't be that soon.
Won't be that soon?
No, that's why I say wait till you hear from Ms. Rios. And then you should check in again.
It's almost 4. So.
Okay. All right. Thank you, Ms. Hill.
Thank you for coming all the way back. I appreciate it. I think Ms. Dickens is all that's left before you bring her out. Ms. Harvey.
Yes, Your Honor.
You've been very helpful today. I just need to know what you have on Ms. Dickens, who is position 1 on our inquiry calendar, and then you are free to go.
Okay, yes, one moment, let me pull her.
You flipped that one. Anger management. This is on Rogers.
Sorry, there's lots of paperwork.
Anger management.
Yeah, I forgot to say that, but yes,
40 hours community.
I did say that.
Evaluation.
Yep, and oh no, I did say all those things. Anger management and 40 hours community service, he has to complete within 4 months. And he has to have his evaluation within 2 months.
Okay.
Great.
Since you told him he's getting out.
I didn't say that. I said if he's still in on Monday, he should call Ms. Rios. And she did one of her scowls.
We'll be out next week, so I'm not trying to just give people, I'm just telling people to contact me.
No.
But that makes sense.
Yep, I wouldn't do that to you. Ms. Harvey?
Yes, Your Honor. I show 4 cycles. I show an arrest from March 28, 2025 out of Cherokee County for identity theft fraud when using or possessing identifying info concerning a person. There was no disposition for this case. I'm also showing a case out of Fulton County for theft by receiving stolen property from July 2nd, 2024 with no disposition. But one moment I can double check and obviously to see if that case was handled.
Okay, thank you. And Ms. Dickens is pro se because she said, I've never met her.
So she originally had, I believe it was Scott Smith,
Yes.
And they rolled off the case. Someone was filing pro se things.
Mucho.
Yes, our office was contacted, I think she would have actually been yours. But there were some interesting emails that were sent to our office, and then thankfully, Mr. Haley started, taking a look at things and realized that should she qualify, she would actually be a conflict, and I can pull up the email. We have an active representation on the victim. I believe that's correct. So anyways, so if she actually did qualify for services, she would actually be a conflict, but based on the filings, it's our understanding that maybe she wants to be pro se.
Okay, there was recently a motion for appointment of counsel filed that she and I can talk about, but it's very helpful to know about the conflict, because then the answer would be, yes, if you qualify, but we got to line someone up. So Nikhil Harvey is someone your office represents.
Correct. We have, yes, and there's at least 3 cases, I think, for that person. Or we have an unindicted and then a 26 SC 001712. This is all based off of Ms. Feely's research. And so I know Mr. Haddad had sent off the conflict on May the 1st.
Okay, got it. Ms. Harvey, anything else?
No, Your Honor, that case was dismissed, Your Honor, out of Fulton. So it does not appear that she has any felony convictions.
Excellent. Thank you for your help today, and we will see you around.
Okay, you're welcome. Have a good day.
Bye-bye. Ms. Dickens. Please.
Marky gets her Mr. Walker, you significant with the time served, the new law hasn't gone into effect yet. So I just wanted to make clear what he would get, because he said we're both in here, we could get credit for shooting us things in. Okay.
Mr. Walker was the gentleman we dealt with today. Yeah, right. The work release thing, which is fascinating. Yeah, the year includes credit for time served. And then it's terminated after that. Okay? Hey, Ms. Dickens.
Hello,
I'm Judge McBurney.
nice to meet you.
Nice to meet you at long last. I've been reading lots of things filed into your case by you or someone associated with you. So you had court, you didn't make it to court, you had the lawyers for a while, they withdrew. Someone filed on your behalf a motion for appointment of counsel recently, and we need to figure out what you want to do in terms of representation. I don't want you to represent yourself unless that's what you want to do, and I'm not hearing you say you want to represent yourself. If you can afford a lawyer, then you'll need to hire one. If you cannot afford one because you're in custody, then you have an absolute right to a lawyer, and I will appoint one. It won't be the public defender. They have a conflict. They represent the person who is the named victim in your case, so they can't represent both.
Yeah, they tell me.
Whoever you get's got to be all for you and can't like, well, but I also know this other person. That's not a problem. We have conflict defenders, and so we'd get someone else appointed to represent you. But we needed to see each other so you could say, here's my deal. I do have money and my family's working on hiring someone, or I don't, and we'll take it from there.
So I'm not getting a bond today.
So we really aren't going to talk real substantively about your case unless you say, I want to represent myself. And then I need to ask you a whole bunch of questions that'll seem like I'm talking you out of representing yourself, because you shouldn't represent yourself. It's rarely a good idea. And what we need to do is get a lawyer as your advocate. That person can say, give Ms. Dickens a bond. And I don't think giving you a bond is quite the right way to say it. You had a bond, and then when you missed court, I issued a warrant. That's what scooped you up, I think in Florida. And what a lawyer will do for you is to advocate to set aside that warrant, because that's what's holding you right now. It's not that you still have a bond. And so if the bonding company hasn't surrendered that bond, and we can figure that out. If they haven't surrendered it, if there is a good reason to set aside the bench warrant, then I set that aside, you're released, and your bond remains in effect. If for some reason the bonding company surrendered the bond, sometimes a bonding company learns, oh, our client's in jail again, we want off, and they hand the bond in. I don't know if that's happened, but we can figure that out. Then you would have to post another bond, and we'd need to talk about what does that bond look like, and how do we ensure you don't end up in Florida, but you're here when you need to be in court. So that's where we are right now, is really just, are you gonna hire a lawyer, or should I get a lawyer appointed to represent you?
I feel like I can represent myself right now on this, but I do need to get a conflict attorney.
Okay, let's do that, and I want you to have a conversation with that lawyer. You may decide after you have that conversation, I'm gonna do this myself. And I'll still try to talk you out of it because it's a bad idea, but you have an absolute right to represent yourself if you want to do that. And if I conclude that you understand the consequences of that and how you're at a disadvantage because you're not a lawyer, et cetera, and you say, I get that, Judge, I still want to do it. All right, go ahead, represent yourself, have at it. But you may have that conversation or series of conversations with a conflict defender and say, you got my back. And so you're my lawyer, you're my advocate. Let's get going. Help me get this bench warrant set aside. Let's get discovery in the case so I can see why the state is saying I did these things, and go from there. Okay? So my job, in your case, is to get that lawyer appointed promptly so he or she can meet with you and then say, all right, we're ready, get you back on a calendar so that judge can learn a little bit, that lawyer can learn a little bit more about why it was you missed court, and then come in here to explain to me. And it may be that the lawyer just talks with the prosecutor to say, look, here it was. I'm making this up, but Ms. Dickens was in jail in Miami. How could she be in court in Fulton County when she's in jail in Miami? There you go. That's why you weren't here. But you and your lawyer need to talk about that. And then we'll get back together to figure out, am I setting the bench warrant aside? And if I'm not, how can we move this case quickly? Because I know you don't want to be here.
Okay. And so if I represent myself today, I have to answer a whole bunch of questions.
You do.
Okay. I'm gonna try to represent myself today because I can provide all the information on what occurred with the FTA.
So let me ask this, so we don't necessarily go through all the questions. Are you thinking that you'll represent yourself throughout the trial, if it goes to trial, throughout the case, or you still want a conflict defender appointed, but you also want to talk to me today about why you missed court?
Yes.
It's yes, I want the lawyer, but could we have a conversation today about why I missed court? I'm all right with that, because then you're not having to like, hey, here's a jury and here's how I prove my case and these are the elements and here's the closing argument and jury charges. You just want to lay out why it was you missed court. Okay, and you're not going to talk about any of the allegations that you're facing.
No.
Because that's where a lawyer would jump on you and say, you missing court has nothing to do with what you're charged with. You missing court is whatever was going on.
Yeah, no.
Tell me why you missed court.
Okay, so December of 2025, I was evicted from the address on file. I did not update the address with the courts because I did not know where I was going because I was evicted. And so I came back up here because I was properly notified from Canton, Georgia, that I had court on the 15th, which I indeed was there.
Court on the 15th for what case?
In Canton, Georgia.
Oh, you had a case in Canton. Okay.
And so I went to court, and then they didn't arrest me, so I never knew I had a warrant. I'm not a person that misses out on court.
When was your court in Canton?
It was April 14th or April 15th. It was right out, and I was in Atlanta. I came to Atlanta on the 3rd of April, so I just had no notification. Counsel withdrew. I didn't receive anything in the mail. I didn't receive any notification. My bondsman, he's gonna reinstate my bond. I've already spoke to him. He's saying that he didn't even know I had court. My signer didn't know I had court. Nobody knew I had court, and that's why court was missed. Canton, Georgia also has the same Bolton Road address on file. And they still sent electronic notification letting me know I had court to my signer. Yeah.
Electronic notification, they sent it where?
So my mom signed that bond.
Okay.
She's the one that sent me and told me I had court in Canton, and I went to that court date with no problem. I have no prior FTAs. I don't duck court.
I'm just looking up the notice to see where it was sent.
And then I had a mail forwarding put in, but I don't think they forward state mail.
So Bolton Road, apartment 3010, that's where you used to live? That's what you were evicted out of?
Yes, so a case here in Fulton.
There's an eviction case here in Fulton. Okay. And you were evicted, I think you said in December of last year? And you didn't update your address?
'Cause I didn't know where I was going. I ended up going to a family's house in Florida.
Okay. So you said the bond person is coming back on your bond. Did the bond person say they had surrendered your bond or they had not?
They hadn't surrendered it. He
Okay.
knew I think he's on my Canton bond, the Cherokee County bond. So he saw when I went to court, so he knows I wasn't ducking court.
Ms. Smith?
Yes, Judge, in this case, the state is going to ask that the bench warrant not be set aside. I think the biggest thing here is that the defendant knew that she had a duty to update her address. The state understands that at the time she was evicted or at the time that she left the residence that the notice was sent to, she did not have an address to go to. However, once she did land in Florida with her family, it is still the defendant's duty to then update the court on where she was staying at that time. And even if she was not getting notice via mail, calling the Fulton County Courthouse or staying up to date on the case that she knew was open at that time was still the defendant's duty. So because of that, the state is going to be asking that the bench warrant not be set aside.
All right. Ms. Dickens, do you have a place where you could stay that is in Georgia and not in Florida?
Yes,
Where's that? You don't need to give me the street address right now, but where in Georgia? What?
it's on the west end.
Okay. And with whom would you be staying? I don't care the name so much as it's my aunt or it's my friend or whatever it is.
It's a guy friend.
A guy friend. Okay. You have an active outside network that you're going to need to rely on. I will set aside the bench warrant if someone can get to my staff the address where you'll be staying and a way for me to confirm that that person will let you stay there. So email, phone number, so I can call and like, hey, can she stay there? If that person says yes, then number two, I'll need to confirm that the bond wasn't surrendered. It doesn't look like it. It's showing up in the system, but that's not always accurate. Assuming it wasn't surrendered, you don't need to worry about a new bond. I need to get you the counsel appointed, and I'm going to modify your bond to include 6 months of electronic monitoring. And that's just to make sure you stay local. I'm going to start with a curfew and a don't go too far. If you get back out and things are going well, and you got a job such that you need to modify the curfew, your lawyer can just reach out to say, hey, it turns out Ms. Dickens has a job where she works from noon to 8 p.m. So could we shift the curfew around? And that's fine. The electronic monitoring has a natural expiration date of 6 months. If for some reason your case takes that long to resolve, I don't think it will. But more importantly, it gets you out, but it makes me less nervous about, wait a minute, you disappeared to Florida, and I heard the words you said, but I also heard the words Ms. Smith said. You kind of disappeared on us. And your case didn't go away, but you did. So this, I think, strikes the right balance. You'll live locally, so we're not trying to fish you out of Florida to come to court. The electronic monitor will confirm that you're abiding by the conditions of bond, and if that all goes smoothly, but this case moves slowly, off goes the electronic monitor, and you'll have more degrees of freedom. But we're gonna do it gradually, okay?
Okay.
Any questions about that? So your outside network clearly knows how to contact my office. We need, again, where you're going to be staying, so the actual street address, and then some kind of contact information for, is it a house or an apartment?
House.
Okay. And does the person own the house or rent it? You know a lot about this. So I can talk with the homeowner saying, yes, Ms. Dickens can be there, and that person can let me know, and here's who else is going to be staying there. Do you have kids?
Yes, my son. That's how I got caught in Florida. I was taking him on a Disney cruise for his 7th birthday, and they caught me at the port. I didn't get to go.
That's right. I remember reading about this from one of the filings, that you are all set to get on the happy boat, and you got put in handcuffs. That's rough.
Yeah.
Who took your kid?
My grandmother and my aunt were accompanying us, so
They went on the cruise.
Still had to take.
You went on a different cruise. It was a
Right.
cruiser with lights on top.
Right.
Okay. Darn. All right. Well, that's a story to tell the family 10 years from now. And we were about to get on the boat, and I went that way.
Yeah.
Get that information flowing in my direction. I'll work on getting the lawyer. That won't hold you up. We'll process the bond thing as soon as you can get the information about where you're going to be staying. In parallel, I'll be trying to line up that lawyer, but that's not no contingency for you getting the bond back, okay?
Okay.
Ms. Smith, anything else from the state?
Nothing further, thank you.
All right. Nice meeting you.
Thank you. Have a good day.
Anything else?
Okay.
Thank you, Ms. Rivers.
So what are you gonna try next week?
Have a good evening.
Yeah, have a good month. I don't know, am I gonna see you again?
Well, you will see me again, and I will be keeping in touch.
Good, please do. Let us know how things are going.